State of Florida versus Christian Alexander Douglas, 23 CF 111.
Your Honor, I had announced ready for trial at the previous pretrial, and I had the court discussed at that pretrial the downloading of phones, and since that time I contacted the evidence locker, confirmed that there were 5 phones in the state's possession in evidence, made a request to the lead investigator to have those phones downloaded, or to release them to me to have them downloaded. And the state had contacted me and stated that they would have the phones downloaded. Okay. Ms. Leone suggested that we continue the case one cycle to complete the downloads, and so I guess it would be a joint continuance, request for a joint continuance to complete the downloads.
Ms. Leone, do you agree it's a joint continuance at this point? I mean, you obviously have to provide these things if you have them. I'm just...
Yes, and of course, as Mr. Riosti stated, one of the possibilities is that he gets the phones and gets his own download, but I have offered to do it anyway. So to that extent, I guess I'm not objecting to a continuance. The one thing I do ask, Your Honor, is that the defendant be sworn to give consent to the search of the phones, because otherwise we would have to go through a search warrant.
Okay. All right, Mr. Douglas, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay. All right, so we've talked about these phones several times now, and it sounds like there are 5 phones in evidence. That this case is from January of 2023, and this is the first time someone's, I guess, putting their hands on these phones, which I think is a problem.
Yes, sir.
However, now that the phones are being talked about, Mr. Douglas, do we know that they all belong to Mr. Douglas?
No, 3 of them belong to Mr. Douglas.
Okay, so what are the other 2?
One is the victim's, and one, I believe, is
No, I believe Ashley Woods. Ashley Woods was a passenger in the defendant's car at the time.
that's correct.
Lindsay.
He was arrested in Louisiana, I believe.
Yes, Lindsay Wood.
Lindsay Wood, I'm sorry, Your Honor, Lindsay Wood.
You said the other one belongs to the alleged victim?
Yes, Mr. Levi Hardy. And I would also ask the court
Go ahead, Ms. Lynn.
I'm sorry, Your Honor?
It's fine, go ahead.
To inquire with the defendant about the passwords for those phones to facilitate the download, since he's requesting.
Okay, so Mr. Douglas, what they're asking is, because you've asked for it through your attorney, is to download the entirety of these phones, that you agree to that. I'm not going to say you have to do that, obviously, but it just simplifies things as far as, since you're asking for them to be downloaded in that way, but that you also provide the passcodes to get in. I'm not going to have you announce them out in court today, but is that something you want to do?
I feel, because I don't know exactly, it might be private stuff like of my own, other not pertaining to this case. I'd prefer to review it with my attorney, and I just want to retrieve maybe certain messages between people. Obviously the GPS data, I'd like to hire a specialist for that, or expert on our behalf. Triangle pinpoint my location to prove my innocence.
So, Ms. Leone,
That
it
is
sounds like they're asking for the phones to be turned over to their expert that they don't have yet, right?
Well, I'd like to affect the download, and I have to talk to the. I have an expert that I have talked to about.
You're
And I know
appointed to
that-
this case, right?
I am, Your Honor.
All right, so you're going to have to go through the proper process of having someone appointed for that purpose.
Yes. And I know the, after speaking with, at length with Mr. Douglas, I know the carrier, and I know the process of requesting it. So I was going to make a request to see if it was possible in one cycle to retrieve that information. But with regard to the data that's on the phone, I would request that the phones be downloaded to see if there's text messages.
Downloaded by whom?
The state has stated that they would make the downloads.
But your client just said that he doesn't want them to have all the information that's on the phone.
I prefer our behalf, our experts. I just want a proper due process. I want a fair trial, as I'm entitled to by my.
Your Honor, may I?
Go ahead, Ms. Lee.
I'm just going to respond. It really doesn't work like that. He doesn't get to pick and choose what he wants us to know about his phones. Also, because technologically speaking, they call a phone dump. Everything that is in the phone, then we sort it out, of course. Due to the rule of evidence or constitutional rights of the defendant, we won't be able to possibly use all the information that we gather because it's got protections, such as, for example, any immaterial type of evidence wouldn't be admissible. So we cannot do it what he's requesting.
But why can't the defense say, we want the evidence that you haven't opened up and we want access to it? Because you haven't sought a search warrant to get in the phone, right? And when I say you, I mean the state.
Yes, no, Your Honor, yeah, the court is
Why
correct.
can't they have those downloads done so they can see what's inside of his private phone without having to go through the state where you get to then go through it without the benefit of a search warrant?
Because then I would be requesting the full download for rules of completeness, that he may just choose certain text messages. We can have an in-camera review.
But the issue is, he doesn't have to turn over everything to you, right? As the state has an obligation. He only has to turn over to you what he wants to use. I think this is kind of half-baked at this point as to how this is going to have to proceed. But these phones have been in the state's possession for almost 2.5 years, and no one's looked inside of them. And now he wants a copy of the content of his own property, which the state hasn't sought. Why can't they do that without the state getting their hands on every single thing in there, since you haven't sought a search warrant to get inside of it?
They can get the phones.
Okay. I think y'all have to figure out the logistics of this. I don't have an issue with continuing it because of this. I'm going to point out again that we've been talking about this since December, and no one even seemingly knew if there was a phone last week, which was the end of April. And I think that's a huge problem. That discovery shouldn't take 2.5 years in these cases. And I know, Mr. Riasta, you weren't on the case the whole time. I'm sure you weren't on the case the whole time. I think Mr. Douglas talked about having, 6 prior lawyers?
And Your Honor, I did mention the phones to every one of my attorneys. The lead investigator was supposed to ping the location of my phone. In the very beginning, I gave her consent to do that, and they never did. I guess they never put a search warrant to do so.
Your Honor, I'll discuss whether or not we can consent to the state downloading the data and providing all of the data with my client.
If they're opening up the phone and getting that data, then they have access to it all.
And I
Your client
understand
has
that.
now twice said, I don't want that to happen. I don't want them to have access to everything in my phone. I would like
I
my
understand.
defense lawyer and an expert to look through it without the state doing that.
Yes.
But
And I
twice
understand.
your response has been, oh, we'll let them just download it all.
No, I didn't say that. I said I would discuss that with my client and see if it's possible that he would consent to that. But I
I don't.
But I will
consent
do
to that.
all right, then I'll do the downloads myself.
I would request, though, that we set some deadlines for him to,
Well, what I'm going to do is I'm going to bring you all back on Friday. I know that's our jury review date, but I'm going to bring you back because I want to know what's going on
Yes, Your Honor.
over this week.
That's fine.
To find out exactly how this is going to work. Okay?
That's fine.
I don't want it to be a situation where things aren't done until next month, and then we get to June 24th, which is our next pretrial docket, and like, well, we think we've got a guy who can open up the phones. That's not going to happen. So I want to hear back on Friday, 9 o'clock, what y'all have done this week to find out how these phones are going to be accessed and by who's going to do that and what the next step in that process has to be. Because I know these processes take a long time. And once you get a phone, it'll take you a dozen hours probably to go through the phone. I've been handed those downloads before in cases when I worked as a lawyer. It's volumes of things. And obviously, if it's only the defense going through it, then they're only going to look for what they're looking for. That should go faster. But we obviously need to get somewhere. But we're only talking about the 3 phones, right?
yes, Your Honor,
Okay. What about the other phones?
doesn't have any right to access those.
Well, but they're evidence that are in your possession.
Yes,
So how does he not have a right to, isn't there
because they belong
potentially,
to other individuals, Your Honor.
but they're in the state's possession.
I
Don't they
understand.
have a right to look through them for potentially exculpatory evidence?
Not, I would have to get back with on that, Your Honor. I mean, they would have to get consent from the owner of the phone because they're not suspects, the
Well, I
owners of those
understand, but you
phones.
took possession, I'm sorry. Law enforcement took possession of them, and they've been in law enforcement's possession for the past 2.5 years.
Yes, Your
right?
Honor.
So that's potentially exculpatory evidence because we don't know what's in there. Someone has to review it. For the same reason, if this were some sort of white-collar case and you had boxes of things that you hadn't looked through, well, they should get a chance to look through it to make sure that something that's in the state's possession has been turned over and investigated. We'll talk about this on Friday as well. I'll give you all a chance to figure that out. If there needs to be a motion to compel, or y'all can work something out as far as these other phones, but I'll let you all make those arguments on Friday.
Yes, Your Honor.
Anything else, Mr. Douglas, that you?
Thank you for the extension for my
That's
proper
fine,
due
and if you've got
process.
anything else going forward, certainly bring that up. I know you had some concerns on how things were going. As you can see, I'm trying to push this case along.
They respect that, sir.
So I want to make sure that, you're confident in how things are proceeding.
Yes, sir.
All right. So we'll see you back on Monday, or on Friday. That's going to be, what, the 9th, May 9th? It's not for jury review, but just as kind of a status as to what's going on in this discovery, because I'm not going to fail to put my hand on this file again until June. All right, we'll see you back on that day.
Thank you.
That's
Your
all I
Honor.
have before Your
All
Honor.
right, thank you. All right, Ms. Mayerfield, are you ready now? I just want to kind of get back into the order that they've got.
Appreciate you, Judge. First case I have is Wesley Bertran. Mr. Bertran is present and approaching.
It's under you or Flair?
It should be, I think it's under Flaherty today, Judge.
I just want to make sure I know what page it is.
Mr. Bertran has 23 CF 2071 and 25 CF 473.
Go ahead.
Thank you, Judge. And we have reached an agreement, if I may approach.
Does this agreement contemplate that he lives in another state?
It does, Judge. The score sheet's behind. Mr. Bertrand is going to withdraw his previously entered not guilty plea and enter a no contest plea to the terms as identified, Judge.
So how are we going to deal with the community control?
So we have addressed the community control issue. Mr. Bertrand is going to live locally. He is entitled to a transfer. We have confirmed that with Louisiana, and they're willing to accept him. But he'll have to live
community
locally.
control?
Yes, sir. Which typically does not happen. We understand that. But Mr. Bertrand's under supervision in Louisiana, so they were able to capture that. It will take
So this is a
45 to
this is
60
a little bit of a
days.
unicorn of a case.
It is, Judge.
Okay.
Doesn't happen very often. About 45 to 60 days, we believe, for the transfer to go through. Mr. Bertrand does have a suitable living arrangement until that time.
Okay, so it calls for counts 2 and 3, I'm sorry, count 2 of 23 CF 2071 to be dismissed, and then for 25 CF 473 to be dismissed, right?
Correct.
Is that the state's agreement?
It is, Your Honor.
Okay, so it's going to be 6 months community control followed by 54 months standard probation, GPS, $1 a day, and costs. Is that your understanding, Mr. Bertrand? Have y'all talked about what Louisiana probation is going to do based on the plea?
We have, Judge. He's been in constant communication with his Louisiana probation officer.
And I just wanted to make sure, because I know that's come up on court dates before you were on the case, Ms. Merrifield, that depending on what happened here could really cause him some problems in Louisiana. So I just want to make sure that's been discussed.
Yes, sir. And we do have a workable resolution with Louisiana.
I just don't want to have him coming back and withdrawing the plea because something that you all thought was going to happen didn't.
Understand,
But
Judge.
if that's what happens, we'll deal with it.
Prior to the court's pronouncement, I would be requesting a waiver of the cost of supervision, and my basis is this. Mr. Bertrand has been living in
I think
Louisiana.
probation has indicated they're fine with that.
They have it, and he's going to be on a GPS, Judge, so as long as the court doesn't have issue with that.
Since Louisiana's getting their supervision fees and they're the ones that are actually supervising, I don't
Yes,
have
sir.
an issue with that.
They would have to pay Louisiana, whatever Louisiana.
Exactly.
We're just getting-
All right, so Mr. Bertrand, why don't we raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Bertrand, I've been given a plea and sentencing agreement that calls for you to plead in 23 CF 2071 to failure of a sex offender to notify required information, which is a third-degree felony, punishable up to 5 years in the Department of Corrections and a $5,000 fine, and then 2 similar charges. One is count 2 of that case, and then a new charge in 25 CF 473, which was actually from over a year ago before it was finally filed and sought. Have you gone over this plea and sentencing agreement with your lawyer?
Yes, Your Honor.
Did you read and understand it? Did you sign it? Are you satisfied with the representation that you received from Ms. Merrifield?
Oh, yes, Your Honor.
Say again.
Yes, Your Honor.
Okay. And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir. No, Your Honor.
Okay, and he also scores 35 months, so this is agreed upon downward departure?
It is, Judge.
This is agreed upon downward departure?
Yes, Your Honor. I apologize.
Okay. So the only reason that this is not a prison sentence is because the state's bargained with you, right? Okay, and you understand that if you come back on a violation of this community control or probation, that you can be sentenced to prison up to 5 years in state prison. All right. All right. Are you currently suffering from any mental health issues or concerns? Has anyone forced, pressured, or threatened you in any way to enter this agreement? Has anyone promised you anything other than the terms of this agreement in order to entice you to plea?
No, sir.
You understand that by entering a plea of no contest, which is indicated on your form, that there won't be a trial of any kind. And do you understand that you're giving up all of your trial rights, which are listed on page 2 of your the agreement that you signed? Do you understand that you're waiving all potential defenses that you may have? And do you understand that if you're not a U.S. citizen, this could lead to your deportation? All right. And how do you plead to 23 CF 2071, count 1, failure to notify?
Contest.
I'm going to accept your no contest plea is freely, voluntarily, knowingly given. It's going to be 6 months of community control, followed by 54 months of standard probation. You're going to be subject to a GPS monitor during the entire term of that, basically 5 years of supervision at $1 per day. $518 in court costs. I'm going to waive the cost of supervision based on what we talked about here, that you're paying Louisiana, and they're the people who are actually going to be supervising you, and that the Department of Corrections doesn't have any objection to that. Does the state have an announcement on 23 CF 2071 count 2 and 25 CF 473?
Yes, Your Honor, the state is going to be null processing both of those.
Okay. All right, so Mr. Bertrand, I'm going to have you talk to probation before you leave. You also have to, well, I didn't announce this, but it's adjudication of guilt, so you understand you're a convicted felon for this. Okay. You're going to have to be fingerprinted, and you have 30 days to appeal the judgment and sentence of the court. Obviously, as you heard me refer to this as kind of a unicorn case, which means it's unique, which means you have to really follow the rules of both Florida and Louisiana, because you don't want to fall through the cracks and end up with a violation because you didn't follow some simple rules, because you'll end up in a jail cell and transported back from Louisiana that way. All right. Thank you.
The court has given them permission to transfer to Louisiana upon us being able to verify and transfer supervision through interstate compact.
Yes, sir, and it sounds like from what y'all have talked about, that's been approved. It just has to be officially approved.
And he has to pay the $100 transfer
Yes.
fee.
And if the court could just announce that on the record, that there is no objection and he will pay that transfer fee.
All right, there isn't any objection from the court as far as the community control and the probation being transferred to Louisiana, but obviously they have to go through all of their channels to make sure that happens the proper way. Again, this is not a normal thing to happen, so I expect it could be more lengthy and time-consuming than you might expect, so. All right, thank you, Mr. Bertrand. Make sure. The $100 transfer fee.
It is notated in the plea as well, Mr. Barron.
He will be supervised. He will keep the GPS on the whole time. When he gets to Louisiana, they will remove ours, put theirs on, and send ours back.
Wonderful, thank you. Judge, the next case I have is Matthew Packard in 24 CF 1455, 1456. Mr. Packard is present and approaching. And Judge, I anticipated an incarceration. Can I please bring the GPS cord with me? He needs to take that with him to the jail, or I need to turn that over to somebody.
Okay. Sure. Who has that?
And Judge, we have reached an agreement, if I may approach. Mr. Packard is withdrawing his previously entered not guilty plea, and he is entering a no contest plea. This does contemplate an 1129 sentence, and it is a downward departure based on the need for treatment and the lack of prior treatment in his history. The state would concur with that, Your Honor.
As well, this is an uncoerced plea bargain, correct?
Absolutely, Judge.
All right, Mr. Packard, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Matthew James Packard, February 1st, 1976.
All right, Mr. Packard, you're here in two cases, 24 CF 1455 and 1456. Both are failure to register offenses. Third-degree felonies punished by up to 5 years in the Department of Corrections and a $5,000 fine. Do you understand that?
Yes, sir, I do.
I've been handing in a plea and sentencing agreement that calls for you to plead to the 1455 case. 1456 would be dismissed by the state as pursuant to your agreement, and the court would sentence you to 11 months, 29 days in the Okaloosa County Jail, that you're going to do the ECLC program inside of the jail and comply with that program, $518 court costs, and you'll have to pay those within 90 days of your release.
Yes, sir.
Is that your agreement?
Yes, sir.
Okay, did you go over this agreement with your lawyer?
Yes, sir, I
Did
have.
you read and understand it?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with the advice and representation of your counsel?
Yes, sir, I am.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand that if you plead no contest to the failure to register count, there won't be a trial of any kind?
Yes, sir.
You understand that you're giving up all your trial rights, which are listed on page 2 of the agreement that you've signed?
Yes, sir.
And you understand that you're waiving all potential defenses that you may have?
Sir.
And this will adjudicate you guilty, so this is a felony conviction. Do you understand that?
Yes, sir, I do.
And do you understand that if you're not a U.S. citizen, this plea and sentencing could lead to your deportation?
Yes, sir.
All right, and what is your plea to 24 CF 1455?
No contest, sir.
I'll accept your plea as freely, voluntarily, knowingly given in 24 CF 1455 as charged. State have an announcement on 1456.
Yes, Your Honor. In 1456, the state would announce an all processing exchange for the plea to 1455. Additionally, Your Honor, there was a provision that all prior credit would be waived, Mr. Packard.
Okay.
Mr. Packard is aware of that, as a fresh 1129 would be required for the ECLC program.
Okay, so specifically, I'll put on the record you're waiving your credit for time served, Mr. Packard?
Yes, sir.
And that's to give you a full 11 months and 29 days to comply with the program?
Yes, sir.
They don't like your word complete, I heard last week, so I want to make sure you understand that.
I do, thank you.
I'm going to sentence you to the 11 months and 29 days in the Okaloosa County Jail. You're going to do the Emerald Coast Life Center ECLC program, comply with that program throughout your stay in the jail. 518 in court costs, you'll need to pay those or set up a payment plan within 90 days of your release. And again, you're waiving all prior credit for time served so that you can complete the program in 11 months, 29 days. Of course, that doesn't account for gain time and things like that.
Understood, Judge.
All right, so I'm going to need you to be fingerprinted before you leave, Mr. Packard, and then you have 30 days to appeal the judgment and sentence of the court. It's my reading of the Criminal Punishment Code score sheet that this is a downward departure based on a uncoerced plea bargain as well as the need for treatment.
Thank you, Your Honor.
All right, thank you, sir. Step over, be fingerprinted.
And I believe that is all I have today,
All right,
Judge.
thank you. All right, back to Mr. Gilbert. All right, who do we have?
Good morning, Your Honor. So I have Kayla Salisbury in 24 CF 2925. We have a waiver on file. We have reached final terms, and she had intended to be here today. We must have run into a problem. We'd just like the next best date for a plea.
Did you come in on Friday?
That would be great, Your Honor.
All right, Friday at 9 o'clock for the plea.
And second case, Shannon Smith, 24 CF 2896. We have a waiver on file. We have an agreement with state on a PTI, but we still have to work out the details, so I need to bring them in for that.
Is that correct?
Yes, it is, Your Honor. If we could set it for Friday, we'll have it all set up then.
I don't want to get in the habit of coming in on Monday just to say we'll see you again on Friday. It kind of defeats the purpose of coming in today. All right, so 5-9 for the PTI.
Thank you, Your Honor.
Yeah, maybe we approach quick.
Yes. All right, is that all you have, Mr. Gilbert? All right, thank you. We'll see you Friday. All right, Ms. Dudley.
Dixie Dan Powell of Powell
She
Entry
stepped
Law
out.
for your recent jury verdict of
Oh, there she is.
$11.5 million for your client from a death
Oh, I get
and injury
blind just to the
event
first
in
row.
Amusement Company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida.
I saw you walk through
and
earlier, then you
Dixie is
disappeared.
AB preeminent rated. Dixie Dan Powell works.
Yeah, I got an
tirelessly
offer I need to
to
discuss
find
so we can get a plea.
evident by this extraordinary verdict. If you're taking your case
Okay.
to trial, be
So
prepared.
I'll hang around for him then.
Dixie Dan
I think the
Powell
first one I have, Your Honor, is Terrence McLean. And all mine are inmates, Your Honor.
No, you're good.
Your Honor, this is Mr. McLean in 24 CF 2829, 21 CF 1192, 21 CF 1484, and 21 CF 2777. I do have a plea, Your Honor. It will be adjudication of guilt to the VOPs, 39.9 months DOC. And with credit for all time served, revoke and terminate probation, $100 VOP fee, cost of judgment, and all cases and counts to run concurrent. And the state would dismiss 24 CF 2829. If I may approach with a plea form and a score sheet.
So the new law is being dismissed? Okay, thank you. Unfortunately, when I get this docket for this day, I can't see which ones are VOPs or not.
Yes, sir.
So that's why I'm gonna probably ask that question more often, because it's just different on the pretrial docket.
So it's all the 2021 cases he's entering plea to.
That's what I figured, I just wanted to make sure I was
Yes, sir.
clear on that. All right, Mr. McLean, can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. McLean, I'm looking at a plea and sentencing agreement between you and the state that would call for you to plea to your VOPs, which are 21 CF 1192, 1484, and 2777. The agreed upon sentence is 39.9 months in the Department of Corrections with credit for time served, revoke and terminate your probation, $100 VOP fee, cost of judgment. What about any of the conditions of his probation as far as monetary? Are those just
Just be all monetary, all costs of yes, sir.
all the judgment? All right. Is that what you want to do today, Mr. McLean?
Yes, sir.
Okay. Can you state your full name and date of birth, please?
And Terrence McLean, 12/17/1990.
All right. And Mr. McLean, did you go over this form with your lawyer?
20 times.
All right. And did you understand it?
Yes, sir.
Did you sign it?
Yes, sir. Jesus, nigga, I don't even run
Are you
together now.
satisfied? Say again.
Yes, sir.
Okay.
He'll announce
Are
when
you-
he gets there.
Are you satisfied with your lawyer's advice and
Yes,
representation?
sir.
Just wait till I finish, that way we can both get picked up by the microphone. If we talk at the same time, it gets kind of muddled.
Yes, sir.
Okay. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything?
No, sir.
You understand, you're pleading to the VOP, so it's a little bit different. So you understand by pleading to the VOPs, there's not going to be an evidentiary hearing to prove that you violated your probation in the way the state has alleged you have.
Yes, sir.
Okay. So you don't really have a right to a jury trial in a VOP, so I just want to make sure you understand that difference. Do you understand that you're giving all your up all your rights that are talked about in the plea and sentencing agreement?
Yes, sir.
And do you understand that you'll be convicted of this felony, at least all three of them? Do you understand that by pleading to this, if you're not a U.S. citizen, you could be deported? All right, do you have any questions? All right, this is state's agreement?
Yes, it is, Your Honor.
Okay, and it's a guideline sentence as well?
Yes.
Okay. And what is your plea to the violations of probation? Are you admitting that you violated your probation or denying?
I'm admitted.
Okay. All right, so I'll accept your admission to 21 CF 1192, 1484, and 2777 that you violated your probation. State have an announcement on 24 CF 2829.
Yes, Your Honor, the state dismisses 24 CF 2829 in exchange for a plea to the VOP cases.
All right, so Mr. McLean, what I'm going to do is adjudicate you guilty on all three of those VOP cases. I'm going to sentence you to 39.9 months in the Department of Corrections with credit for all your time served, revoke and terminate your probation, $100 VOP fee. All costs and monetary conditions are going to be to judgment. All of your cases and counts are to run concurrently.
Thank you.
All right, any questions? All right, I need you to be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court.
Your Honor, this is Russell McLaughlin, 24 CF 1304 and 29. I just need him to sign the plea form. I did go over it with him in the back. Your Honor, Ms. McLaughlin will enter a plea to 24 CF 2090, counts 1 and counts 4. State would dismiss counts 2 and 3 and 24 CF 1304. It'd be 1129 with credit for time served, and then time served on the misdemeanor, 615 in court costs and cost to a judgment. If I may approach?
Approach to, Your Honor.
Sure. You had a score sheet?
Yes, sir.
So this is a downward departure based on uncoerced plea bargains?
Yes, Your Honor.
All right, so just to make sure I've got this right, so in 24 CF 2090, 2 and 3 will be dismissed? And then also the entirety of 24 CF 1304?
Yes, sir.
Right? Okay. Mr. McLaughlin, can you raise your right hand, please? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Can you state your full name and date of birth, please?
Russell Noah McLaughlin, 7/16/1956.
All right, you can put your hand down, Mr. McLaughlin. You're here in 2 cases, but I've been given a plea and sentencing agreement for 1, and the other one will be dismissed. But in 24 CF 2090, you're charged with 3 counts of possession of a controlled substance and driving while license suspended. You're also charged in 24 CF 1304 with possession of a controlled substance and possession of drug paraphernalia. Do you understand your current charges?
Yes, sir.
All right, I've been given the plea and sentencing agreement that calls for you to plead to counts 1, which is possession of controlled substance, and count 4, driving while license suspended in the 2090 case, and for the other case to be dismissed in return for sentencing you to 11 months, 29 days in the Department of, in the Okaloosa County Jail, credit for time served, $615 in court costs, and all of your costs to a judgment. Is that what you want to do today?
I plead to it, sir.
Okay. And have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
Yes.
Okay. Do you understand what's going on here today?
Yes, sir.
Are you under any sort of medication for that?
No,
Okay. Do you feel like you need more time to speak with your lawyer? Do you have any
No, sir.
questions for me?
no, sir.
Okay. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
And you understand by entering a plea, there won't be a trial of any kind.
Yes, sir.
And you're giving up your trial rights, which are listed on page 2 of the agreement that you signed.
Yes, sir.
You understand that you're waiving all potential defenses that you may have. And do you understand that you'll be adjudicated guilty, which means you'll be a convicted felon on count 1 of the 2090 case?
Yes.
And you understand that if you're not a U.S. citizen, that this could lead to your deportation?
Yes, sir.
Okay. You're a U.S. citizen? Okay. I know I have to ask everybody, so. All right. So in what is your plea in 24 CF 2090 to the possession of controlled substance and the driving while license suspended? Are you pleading no contest, guilty, or not guilty?
No contest.
All right. I'll accept your no contest plea as to count 1 and count 4 of the 2090 case. Does the state have an announcement on counts 2 and 3 and also on 24 CF 1304?
Yes, Your Honor, the state will be no problem. Counts and cases.
I'm going to adjudicate you guilty on both the counts that you entered a plea, 11 months, 29 days with credit for time served. That'll be on count 1. We'll just call count 4 time served because it's a second-degree misdemeanor, only punished by up to 60 days. $615 in court costs. Those costs will go to judgment. All right, Mr. McLaughlin, I need you to be fingerprinted before you leave.
Yes,
And
sir.
you have 30 days to appeal the judgment and sentence of the court. This is the state's agreement in downward departure based on plea bargain, correct?
Correct, Your Honor.
Thank you, Mr. McLaughlin.
I have one more, but they're bringing them, Your Honor. So
Okay, I'll call you back up.
Yes, sir.
All right, Mr. Rare. Morning.
The only case I should have on the docket is Luis Armando Vasquez. Mr. Vasquez. And Judge, I've called for him. I've had no communication the last week. I know he did not appear for our last court date. We reset him for today, and I have not seen or heard from him in court today. I'll defer to the court's discretion on what he'd like to do today.
What's the state asking for?
State would request a KPS, Your Honor.
Wasn't finding it because I was looking under your name and not Mr. LaPella's name. All right, that'll be a KPS with no bond. Obviously, Mr. Rare, if he shows up and there was an issue as to why you haven't had contact with him, I'll certainly entertain a motion.
Understood,
to withdraw
Judge.
that KPS, but until then, KPS with no bond.
And that's all I have, Your Honor.
All right, thank you. Have a good day. Mr. Shaw? Mr. Shaw, I just called you and,
Judge, I'll handle it.
okay, you're gonna handle that.
Yes, sir.
I didn't know if he heard, he was just walking through the door, so I didn't know if he wanted to be up here too. I'll be starting with his cases, Mr. Flowers.
Judge Jonathan Roller, and I believe that that is under Mr. Shaw's name. We're asking that matter be continued.
Your Honor,
From 2022,
It is.
what is it being continued for?
Plea negotiations, Your Honor, that have been fruitless.
Well, if they're fruitless, why are we continuing to continue?
They may bear fruit if reasonable minds there's no nice way to say it. We have a disagreement as to the treatment of co-defendants, and it's a respectful one with the state, and they've been, we just haven't reached a
I'm
resolution.
trying to remember all the names. Who were the
I don't recall their names, Mr. Roller.
Eric Nicholas,
Yeah.
or Francesco Stevens.
Stevens and Nicholas, Your Honor,
They were represented by, is it Webster out of Tallahassee?
out of Tallahassee.
Stevens was, Your Honor.
Stevens,
yes.
my apologies, Stevens,
Yeah,
yes.
and Mr. Nicholas was represented by Mr. Patel.
That's an accurate, yeah, that's accurate. I apologize, I didn't know about Mr. Patel.
Your Honor, the only thing I can tell the court is that on numerous occasions, defense counsel has been asking me to share the offer in an email. I've sent numerous emails with the same content, and we're still here trying to negotiate. They haven't even approached or asked me any question about negotiation, so
I agree, Your Honor. We've asked her to give us a similar scenario, and she's quite respectfully disagreed. I agree with her assessment.
So is this going to be a trial next time?
Yes, sir. We hope not, but
I mean, it was
I
listed as
understand
plea or
if the court were to say, Judge, or Mr. Flowers, it's going to happen next time, that's the way it is. I respectfully understand that.
It was listed as plea or continue, is what I.
That's how it was listed for today.
because I thought we were going to have a plea.
Okay.
Me too.
You know, subpoenas haven't gone out, so, I mean,
No,
we don't really have a choice here.
No, with due respect, she anticipated a plea as well, as did I. And Mr. Shaw.
I don't have a whole lot of option here, but what I'm going to do is write this down as last continuance, and then it'll be set for next trial.
We understand.
Obviously, if you get it resolved, bring it in for an earlier plea if you'd like to, but it sounds like y'all are.
We'll make every effort to do that, just that.
Okay. But I'm not going to continue it again absent some sort of an emergency.
We understand, Judge.
All right, thank you. Who else do you have?
Judge, while I'm here, Seth Chancey, out of an abundance of caution, may have been removed from your docket.
Judge.
A PTI has been signed and filed.
It's been signed and filed. We just need him to meet with probation so they can get him all signed up, and he has that appointment for.
That meeting's tomorrow.
So it should fall off your docket as soon as probation submits all that paperwork. So if we can just set a pretrial control date, it'll probably fall off the docket later this week, depending on when probation.
Yeah, that's what we had anticipated, Judge.
I don't have him
Yeah,
showing up anymore.
the docket reflected that it was closed, but And it's about to be after the meeting tomorrow, we believe.
That's correct.
Why don't we just put it on for 6/23, just in case it doesn't, it has a date, but the fact that it's not appearing on my screen probably means it's already been taken care of.
Yes, sir.
But if there's any issues, just bring it to the attention of my office.
Thank you, Judge.
All right, thank
The
you.
last matter I have under, and I believe it's under my name, is Zanaya Brown. And I don't recall which state attorney is handling that matter.
My case, Your Honor.
We anticipate the state's going to receive a drop charge request any day now. This was set, if I'm not mistaken, for a plea or continue. We're asking that it be continued, so the state would have the opportunity to see that. I know they have not received it yet.
We haven't received
We
that.
anticipate it, and I'm quite confident they've not received it, but they're going to.
Have you looked at the file? Is this a chance that the state may go forward even if the victim wants to drop charges?
I was gonna assess that, would the court like me to say it right now?
You don't have to do it right now if you haven't looked at it for that
Yes.
purpose. I just want to make sure that it's not a situation where the form comes in and then they say, well, we still want to go forward.
Understood, and I think it'll be difficult for you to answer that, I think, too.
Not only this, but it was set for plea or continue.
I'm not forcing you to do it today,
Yes,
Ms.
no,
Sione.
no.
I'm just curious if that's been discussed and if that's the plan, if you get the drop charge form.
Yes, no, Your Honor.
All right, so we'll continue that to June 23rd at 9 o'clock. Obviously, if it gets dismissed or if y'all
Yes,
work
sir.
something out,
Yes, sir.
the court will deal with it.
Your Honor, that's all I have. Good day, sir.
All right, thank you. Have a good day. All right, Lauren Henderson. Morning.
Not had the pleasure of meeting you. It's very nice to meet you.
You too.
I'm covering for Tony Henderson.
Okay. I didn't want to assume on the last name, but
Yes, Judge, I'm his daughter. He's also my boss. The first I have is Anthony Miles, case number 19CF 3289.
what do we do with Mr. Miles?
So Mr. Henderson's in Santa Rosa County this morning, selecting before Judge Hilliard. So we're requesting to set this for jury review for Mr. Henderson to be here present with Mr. Miles.
What's going to happen on that date?
There's been an offer that he needs to just speak with Mr. Miles about. I believe it is going to be a plea.
And he pled to his other two cases last week, right, Mr. Miles?
Yes, Judge.
Yes. All right, so we'll keep it on for the 9th at 9 o'clock. For purposes of a plea. All right, thank you, Mr. Miles.
Thank you.
Trying to give this to my grandma.
Okay. Yeah, I can take it. Thank you. Thank you. Judge, the next I have is Tommy Kelly. Mr. Kelly is present and approaching. That's case number 23CF2143.
What do we do with Mr. Kelly's case?
Judge, we have an agreement. May I approach?
Yes.
Judge, Mr. Kelly's going to be withdrawing any previously entered plea of not guilty and enter a plea of no contest.
Do you need a signature from the state attorney, though? Come on back. No, it's okay. All right, Mr. Kelly, can you raise your right hand to be sworn? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please? Your full name and date of birth.
Thomas Lee Kelly III,
Date of birth.
12/18/87.
All right, you can put your hand down, Mr. Kelly. Mr. Kelly, you're here in 23 CF 2143. You're currently charged with possession of a controlled substance, which is punishable up to 5 years in state prison. Do you understand that?
Yes, sir.
All right, I've been handing a plea in the sentencing agreement that calls for you to plead to a lesser included of possession of drug paraphernalia, which is a first-degree misdemeanor, punishable by up to a year in county jail. Do you understand the agreement?
Yes, sir.
All right, did you go over this agreement? Did you sign the agreement?
He's asked if you went over the agreement, and if you signed the agreement.
Yes, sir.
He's hard of hearing, Judge.
Okay, do you need me to speak up? Okay, well, y'all got to tell me. I got to make sure that I'm speaking into the microphone as well. So the agreement, Mr. Kelly, calls for credit for time served, court costs, which will be $270, and cost of prosecution, that includes that, right? Okay, so it's a total of $270, and what I can do is give you 30 days to either pay that or make a payment plan with the clerk.
Sir.
All right. Do you want to go forward with this agreement today, Mr. Kelly?
Yes, sir.
All right, and you signed the agreement, right?
Yes, sir.
Are you satisfied with your attorney's advice and representation? Are you currently suffering from any mental health issues?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
Yes, sir.
Has anyone forced, pressured, or threatened you in any way to get you to plea?
Yes, sir.
Has anyone promised you anything to get you to
Yes,
plea?
sir.
Do you understand by entering a plea there won't be a trial of any kind and you're giving up your trial rights, which are mentioned on page 1 of this agreement? And do you understand you're waiving all potential defenses? And do you understand if you're not a U.S. citizen, you could be deported based on this? And what is your plea to the misdemeanor drug paraphernalia charge? No contest?
No
Guilty?
contest.
Okay, no contest?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given to the misdemeanor paraphernalia charge, adjudication of guilt, credit for time served, $270 in court costs. You've got 30 days to pay that or set up a payment plan. All right, and I don't think I need your fingerprints, so you've got 30 days to appeal the judgment and sentence of the court.
Thank you, sir.
All right, thank you, Mr. Kelly.
Judge, and the last I have is Kevin Josie.
Paraphernalia. Thank you, sir.
The last I have is Kevin Josie, 22 CF 1289. Judge, there's a written waiver on file, and I know that his presence was not required today.
Yes, there was some communication on Friday, and I authorized him to not be here today.
Thank you, Judge. We had Mr. Josie evaluated, and that has been filed.
Yes, and I've reviewed the evaluation. In fact, I asked for that before I excused his presence. I did read the evaluation on Friday. All right. Does the state stipulate to making a competency determination on Mr. Josie based on the evaluation that was filed?
Judge, we don't have any objection to the court considering the report by Dr. Zeman, but it does look like an additional evaluation by APD is needed as far as the nature of competency. So that is something we would be requesting before we can begin restoration treatment.
All right, Ms. Henderson, I know this might not be your case normally, but have y'all looked into getting him evaluated by APD, which is the Agency for Persons with Disabilities? That way we know what kind of restoration that he would need.
No, Judge. Typically, we do
It's just based on my reading of it, and Dr. Zeman's opinion is, we got to figure out what would be the best way to go about that. I think Dr. Zeman specifically said that he doesn't meet criteria for hospitalization, but we obviously have to figure out what would work best for Mr. Josie based on his particular needs.
Is it called APD? Is that-
APD, Agency for Persons with Disabilities.
Okay, I will definitely relay that to Mr. Henderson. I do not know what his typical protocol is with that.
What I'd like to do is see if y'all can get that done, and we'll come back for another pretrial. I mean, it sounds like everybody knows where this is ultimately going. We just need to know how we can help Mr. Josie the best.
Okay.
So I'll put him on June 23rd for a pretrial, if you can have that evaluation done and submitted by that point.
Okay, thank you, Judge. That's all I have. May I be excused?
Yes, Ms. Henderson, good to meet you.
Thank you. Nice to meet you.
And Ms. Henderson, APD has a contact, Joseph Sanchez. He should be able to help you with an evaluation.
Thank you. All right, Mr. Switek.
Morning, Your Honor.
Morning.
Your Honor, I've got one appearing by Zoom, which you approved last week. So, Mr. Lopez.
Why don't we handle Mr. Pierce first, and I'll get the Zoom going for him.
With Mr. Pierce's cases, and there are several, 18 CF 2647, 24 CF 1948, 24 CF 2549, and 25 CF 647. We have an agreement with the state to continue this. We got an offer on Friday and a score sheet, and I've got objections to the score sheet. We need to work those out.
Without objection, Your Honor, as far as the continuance, ask Mr. Switek to let me know specifically, and we'll take
To June, that's what would be the 24th?
Your Honor, I'm going to be out of the jurisdiction.
Out of the jurisdiction.
June 22nd through 30th.
You want to try to put it on something earlier for a potential plea?
Yes.
Are you going to be here May 29th? Looking at kind of both of you at this point.
Yes, sir,
I think that's our miscellaneous date towards the end of May. That way it gives you time to work those things out.
I've got another case in front of you on that day.
Okay. All right, so Mr. Pierce, we're going to put you on May 29th. That's kind of what we call a miscellaneous date, to see if y'all can get this stuff worked out. Sounds like there's some issues with the score sheets. If it isn't worked out, we'll have to talk about putting it on the next pretrial docket, which will be in August. August 25th and 27th. So, I mean, again, I can put you on June, but if you're not going to be here, Mr. Switek, you'd have to find some coverage, obviously. All right, so we'll do May 29th. Let me take a look at. I will advise it's a pretty heavy docket that day. Put you at 9 o'clock.
Thank you, Your Honor. Your Honor, and then by Zoom is Luis Lopez.
He's there. Let me just finish getting that all set up.
And for the record, that's 22 CF 1418.
You are in the meeting now.
All right, Mr. Lopez, can you turn on your video, please? He won't appear up there until his video turns on. There he goes. All right, go ahead, Mr. Switek. Mr. Lopez, can you hear us?
I can hear you, sir.
All right, go ahead.
Your Honor, we're set for trial week of May 19th. Nothing has changed.
Same thing. Anything that we have to talk about on Friday as far as motions in limine or any other pretrial matters?
Not from the defense.
I already signed the order allowing that one witness to appear via Zoom based on our discussion last week.
Yes, sir.
And so there's not any Williams rule or child hearsay issues or anything like that?
No, Your Honor, I don't believe so.
Okay, I'm not as familiar with the case, obviously, as y'all are, just don't want to end up doing that on the Monday of trial, so. All right, so we'll be back. Mr. Lopez, I think I've excused his presence for Friday as well, since he's traveling from California. Is that what we talked about, Mr. Switek? For Friday, so he doesn't have to stay the whole week before trial?
Well, we did discuss that, yeah.
Okay. All right, did the state have any objection to that?
No, Your Honor, not to him not being present on Friday.
Okay.
Counsel, how many days do you think it will take?
I wouldn't think more than 2 exclusive.
Exclusive of jury selection? Okay. All right, so. And is there a current plea offer that's been conveyed? I don't necessarily need to know it. We'll talk about it.
Yeah, we got a plea offer and an amended plea offer this morning, and my client has turned them down.
Okay. But they've been conveyed?
Yes.
All right. Mr. Lopez, we're going to have another docket day, or I'm sorry, jury review on Friday at 9 o'clock. I'll allow you to appear by Zoom due to the distance, but then I'm going to need you here on May 19th for purposes of selecting your jury.
Yes, sir. It's not an issue.
All right. Mr. Switek, anything else?
We would request a larger jury pool, given the nature of the offense.
Also, how much?
We usually have 60.
60. Is that sufficient, Mr. Switek?
I think it would probably be so.
Okay. All right, then we'll see you back on Friday at 9 o'clock.
May 9th.
May 9th.
Thank you, Your Honor.
All right, thank you, Mr. Lopez.
Sir?
Did you have anything else, Mr. Switek? No. All right, thank you. Mr. Cobb?
What?
Who was that? Hudson?
Can you just bring him on Friday, I guess? Because it's going to be a change of plea, ready
Does
to
he
go.
have a case down there, or did he just go to get on the wrong bus?
He has a misdemeanor case that he got transported for, but we were going to take care of that today up here with permission from the state. Mhm. 2 felonies here, 1 misdemeanor there. So I guess the misdemeanor trumped the 2 felonies.
I'm showing he's listed as having court in the South End at 1:30 today. All right, so you want to come back on Friday at 9 o'clock, Mr. Cobb?
Yeah, I want to get it over with.
It's a plea to everything.
Yes, sir.
Let's make sure we verify if he pleads in county court this morning, so we don't have him plead twice to it. All right, May 9th at 9 o'clock.
Yes. Judge, can I approach with the state on Mr. Strahan's case?
Eight 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999.
Judge, I'm going to go talk to Mr. Strahan in the back, if you guys could put him in one of the rooms, and then we can recall it.
We'll pass Mr. Strahan and bring him back once you're done, Mr. Cobb. Do you have anything else? Ms. Dudley, are you ready now? Or did they bring up your last person? I think that was the issue.
This is Antreon Coleman at 17 CF 1004 and 25 CF 780. It will be an admission to the violation, $100 VOP fee, reinstate probation to complete our requirements with the next 12 months on CC sanctions. I do have a score sheet and a plea agreement if I may approach.
Thank you. Is he an add-on?
Yes, sir. I had
Okay.
emailed your office and they were okay when we added it for a plea.
It's fine, I didn't pull up the actual computer docket. I was looking at this at about 11 o'clock last night.
Yes, sir.
Let me just pull him up. All right, so it's just a plea to the VOP for 12 months CC. How much time does he have left on his probation?
That's correct, Judge. He has 7 more years left on probation, and he did do 48 months on the front end of his sentence.
48 months of prison.
48 months on his original sentence. But based on probation's recommendation and the nature of the violation, we're not filing on the new charge in exchange for the reinstatement and the CC on the VOP.
So did he do 48 months, or you're just saying that 48
on
months
the
because
front
that's the
end
score?
already.
He did do
Yes.
that in the beginning, Your Honor.
No, what I'm saying is, did he do more than 48 months, or you're just saying 48 months because that's the exact number on the score sheet?
That's exactly the amount that he did in DOC when he
Okay.
was sentenced on the
Just
original
kind of
case.
curious if it worked
Yes,
out
sir.
that way, or we don't see a lot of exact numbers hit
Yes, sir.
like that, so. All right, Mr. Coleman, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
Okay. Can you state your name and date of birth, please?
Antreon Coleman, August 22nd, 1993.
All right, Mr. Coleman, you're here on 17 CF 1004, which is a violation of probation, as well as 25 CF 780, which is possession of marijuana and possession of ammunition by a convicted felon. I've been handed a sentencing agreement between you and the state that would call for that 25 case, the new case, to be dismissed. In return for you admitting your violation of probation, doing the next 12 months of your probation on community control, reinstate your probation, and complete all the terms that you were supposed to. Is that what you want to do here today?
Yes, sir.
All right, there's also a $100 VOP fee. Okay. All right, did you go over this plea agreement with your lawyer?
Yes.
Did you understand and sign it?
Yes.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
All right, since you're only pleading to the VOP, do you understand that by admitting that you violated your probation, you'd be giving up your right to an evidentiary hearing where the state would have to prove how you violated your probation?
Yes, sir.
And do you understand you're waiving all potential defenses to that VOP? And you understand that the other case is going to be dismissed by the state?
Yes, sir.
And I'm assuming, obviously, because he did DOC time, he was adjudicated on the other
Yes, sir.
line. All right. All right, so Mr. Coleman, what is your plea to the violation of probation? Are you admitting or denying your violation of probation?
Admitting.
All right, I'm going to accept your admission to the VOP in 17 CF 1004 is freely, voluntarily, knowingly given. State have an announcement on 25 CF 780.
Yes, Judge, we announced a dismissal of those charges.
All right, and that's in return for the plea to the VOP?
That's correct.
All right, it's going to be a $100 VOP fee, reinstate to probation to complete your original terms. The next 12 months of your probation will be on community control sanctions. Are you residing locally, Mr. Coleman?
Yes.
I just want to make sure we don't have that snafu. We've had it before. All right, so I'm going to need you to meet with probation. I need you to be fingerprinted before you leave here today, and then you have 30 days to appeal the judgment and sentence of your.
And he is aware he has to have a GPS on before he's released.
All right, so GPS before you leave the jail. Is that $1 a day?
Yes, sir.
All right.
Thank you.
That's all I have, Your Honor. Thank you.
Thank you. It's going to be a long one. Yeah. Because he's supposed to tell me which motions he wants to have heard. So I think he usually takes 15 or 20 minutes at least. So. Yes, we went through a Ferretta and I talked to him about it every time. You ready, Mr. Nopes? And then Mr. Kleins, you'll be next.
Judge, I've got Mr. Barnhill, Andrew Barnhill.
Barnhill?
Is he still incarcerated?
He is.
Well, I just don't feel.
Would he plead for time served? And we sit down with him.
She asked me if you would plead, if the offer was for. Judge, based upon the state approaching me with the new offer on his case, I believe we can resolve it today. I just need a few minutes to write it up.
Okay, we'll call you back up, Mr. Barnhill.
All right, and it's not going to interfere with me getting out Thursday, correct?
No.
Okay.
I don't know anything about it yet. That would be a
So
question.
just waiting
for
here?
Mr. Nopes.
Yeah, no,
So we're gonna have you go back there, and then are you gonna meet with him back there to sign it, or?
Yeah, I need to cover the plea agreement with him, so I do need him to
We'll
go
talk
back.
to you back there, then we'll bring you back up.
I then have Madison Chansey, 23 CF 427. President.
Is it a plea to PTI, or is it just PTI?
It's just a PTI.
It's just the PTI without a plea.
Okay. Mr. Nopes, I think you can just give or Mr. Berry, since it's not a plea, I don't have to go over it with her.
I just need to meet with probation, and it should fall off the docket once they file it.
Ms. Chansey, if you'll just talk to probation once they're free, They'll supervise your pretrial intervention. There won't be a plea of any kind, and the case will be taken off the docket once that's done.
Judge, could we just give some sort of a control date? I think June.
I'm going to just put it on June 23rd for a control date, but I'm assuming it's going to fall off well in advance, probably sometime today or tomorrow, and then we'll cancel that court date. So as long as you meet with them and the PTI is going well, you won't have to be here on that date, Ms. Chansey. All right, thank you.
Judge, the next case I've got is J.C. Rycroft, 24 CF 1676. Anything changed?
I have not had a chance to been able to speak with the victim yet. Attorney.
We're state licensed and insured, family-owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
All right, so Mr. Rycroft, what we're going to do is pass the case. They're trying to talk to another lawyer who's somewhere in the courthouse right now and see if they can't get a resolution based on what the alleged victim is asking for.
Judge, the last case I've got on the docket, just wait is William Talbot, 22 CF 2507 and 20 CF 2925.
All right, Mr. Talbot, good morning.
Morning, sir.
Can we talk about potentially a Nelson hearing for you as well today? Is that something you want to proceed with, Mr. Talbot?
Yes, sir.
Okay. I know we talked about it last week, Mr. Talbot, but you haven't filed anything in writing regarding a Nelson request.
Sir, I haven't. I don't know.
I'm not being critical, Mr. Talbot. I just want to make sure I didn't miss it.
Yes, sir. I did not file anything yet, sir.
Okay. So at this point, let me have you raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Normally, I go through a lot of kind of preliminary questions, but I don't even know what the reason is you're asking for the Nelson hearing. I know we probably talked about it all last week, but
yes,
as
sir.
you can see, I handle hundreds of these
yes, sir.
every time we're out here. So tell me what your concerns are with Mr. Nopes as your attorney.
Well, I've asked him to do a few things for me, sir, and he's failed to do any of that. I've asked him to file one. I've asked him to file a motion. I try to give him case laws on my case, and he refuses to take them.
What type of motion, Mr. Talbot?
To dismiss, sir.
Okay.
And I got the case laws right here for that, and he refused to take it. When he's come to the jail and talked to me, it's always an argument, or he don't want to hear what I got to say when I do have to talk to him.
A motion on which case?
On on the trafficking cases, sir.
Okay.
In his eyes, he's practically going with the state's thinking I'm already guilty on the case, and I'm not, sir.
Mr. Nopes?
Judge.
The reason why you haven't filed a motion to dismiss?
Judge, the facts of this case does not support a motion to dismiss.
So, Mr. Talbot, what you have to understand is a lawyer can't file a motion unless he in good faith can believe that it's a proper motion. If he disagrees that this is the proper strategy, he's under an ethical obligation. He can't file motions without good faith. So he disagrees with you. What would you like me to do?
I'd really like another lawyer besides him, because it's nothing, he won't talk to me about none of my case. He's just telling me that this is what the state's offering, this is what it is. And I mean, I'm innocent of my case, sir.
Okay, you understand, but guilt is a trial issue.
Yes, sir.
So, I mean, are y'all ready for trial?
I'll go to trial, yes, sir.
Judge, I'm not ready for trial.
Okay. I don't think we announced it for this time, did we? Because all you're telling me is he hasn't filed a motion that he says isn't a proper motion. So are there other concerns? Because you kind of said, first of all, it's
We
this
argue,
motion.
I'm saying there's no compromising with it. We're arguing constantly, sir. It's nothing, he's not trying to help me on my case.
Sounds like what you're saying is the attorney-client relationship has broken down to some effect.
Yes, sir.
All right, would you agree with that, Mr. Nopes?
Absolutely, Judge.
And I think you talked about this previous cases, that y'all just aren't getting along very well at all. Okay, how many lawyers have you had on this case?
First I had Timothy Gibbs, I believe, but he conflicted off because my brother was one of the ones that.
You don't have to explain every single one, but.
Yes, sir.
All right, and then who did you have after that? You
Jennifer
have
Flowers.
Okay.
And then him.
Okay. You've had only 3 lawyers over the 3 years this is pending?
Yes, sir.
Judge, I got appointed in 22, so
You've had it for some time.
had it a while.
And why hasn't it been resolved in 3 years, Mr. Nopes?
Judge, there was this issue concerning, I was not quick to set depositions, but once we set those, we then found out there was another, at some point we knew there were other witnesses, and then I think the other witnesses led to this deeper involved report. And there were some things that had occurred that I was hoping was going to convince the state to go a different direction.
All right, Mr. Talbot, do you understand that if I relieve Mr. Nopes from your case and point someone else, it's going to take them some time to catch up to speed?
Yes, sir. I'm well aware of that, sir.
This is not the first time y'all have talked about this.
Yes, sir. It's not. No, sir. It ain't.
Breakdown that y'all don't communicate very well at the jail. In fact,
Yes.
it sounds
Yes,
like
sir.
it's hostile at this point.
I'd really, that's fine. Yes, sir.
But what you have to understand is this can't just keep happening.
Oh, it won't, sir.
So
This-
if the next time we're here, you've got the same issue with your lawyer, we're going to have to really delve into this.
Yes, sir.
But y'all have worked together for quite some time, and it's my understanding that's just not going to happen or work anymore.
Sir.
Are you asking to withdraw, Mr. Nopes?
I am, Your Honor.
Based on what I've heard, I'm not going to find that Mr. Nopes has been ineffective. I've only heard that he hasn't filed a motion, which he doesn't think is a proper motion. I've read through the probable cause affidavit. Obviously, I haven't been part of all these depositions, but I'm not sure what the exact issue is that you're talking about, Mr. Talbot. So what I'll do is I'm going to relieve Mr. Nopes from your case and appoint Charles Williams, who's here today, but he's got other cases, so he'll have to make a time to come out and see you.
Yes, sir.
So in the meantime, what I'm going to have to do is continue your case to June 24th.
Sir.
And then Mr. Williams will come out and see you in the meantime.
Thanks, sir.
We'll see you back on that date, Mr. Talbot.
Just, do you want me to send you an order relieving me and appointing Mr. Williams?
If you could, Mr. Nopes.
Get it to you later today.
All right. Probably tomorrow. All right. Thank you.
And I'll be back with the other cases.
Yes, sir. All right, Mr. Kleins.
First, I have, Your Honors, Gabriel Augustine. Will be followed by Laura Brown. Your Honor, can we approach on Mr. Augustine briefly?
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Your Honor, we would ask to continue Mr. Augustine's case to the June docket.
All right, June 23rd. It's a brand-new case. This is probably the first time up for Mr. Augustine. So I'll go ahead and put him on June 23rd. I'm sorry. Well, I'm trying to remember that you're RCC now. So it is 9 o'clock for you.
Yes, sir.
All right. All right, we'll see you back on that date, Mr. Augustine. June 23rd, 9 o'clock.
Call my office today, make that appointment. Yes. All right. Your Honor, next I have Laura Brown, to be followed by Ashley Cook. Ms. Brown is present and approaching the podium, Your Honor. We have reached an agreement to resolve these cases. At this time, Ms. Brown is going to withdraw her previously entered not guilty plea and her plea of no contest. That plea will be to 24 CF 40. A plea is charged on those 3 counts. In exchange for the plea to the 24 CF 40 case, 25 CF 354 will be null prost. The specific terms of the agreement that Ms. Brown has with the state on count 1 and 24 CF 40, that is a third-degree felony. Ms. Brown will be placed on 2 years of probation. She will be assessed $40 a month cost of supervision, $515 in court costs, $150 cost of defense. She will submit to a substance abuse evaluation and any recommended follow-up treatment. While on supervision, she will have no controlled substances without a prescription and subject herself to random urinalysis screenings. She will pay $9.60 in restitution to the CEFCO located at 5353 South Ferdinand Boulevard. Counts 2 and 3 in this case are both second-degree misdemeanors. Ms. Brown would be placed on 6 months of probation concurrent to the probation on count 1. There would be a withhold of adjudication on all counts. If I may approach with the plea and score sheet?
Yes, sir.
No objection.
All right, Ms. Brown, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, you've heard what your attorneys announced, but I'm going to go through some of these things because I have to say certain things as well. Ms. Brown, could you state your full name and date of birth?
Laura Tricia Brown, 1272.
All right, and Ms. Brown, you're here in 2 cases, 24 CF 40, which is 1 count uttering forged instrument, third-degree felony, and then 2 and 3 are petty thefts, which are second-degree misdemeanors, and then in 25 CF 354 is the possession of a controlled substance. I've been given a plea and sentencing agreement that would have you plead to to all charges in 24 CF 40. In return, the state would dismiss 25 CF 354. Is that your understanding? And did you hear all the terms that were announced by your lawyer? Is that what you want to do here today? Have you gone through this agreement with your lawyer? And did you understand and sign it? And are you satisfied with your lawyer's services and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues or concerns? And this is the state agreement.
It is, Your Honor.
Okay. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea? Do you understand by entering a plea, you're giving up your right to a trial and your trial rights, which are listed on page 2 of the agreement that you signed? You understand that you're waiving all potential defenses?
Yes, sir.
Do you understand if you're not a U.S. citizen, you could be deported because of this? All right. And what is your plea to 2024 CF 40, which is uttering forged instrument and 2 counts of petty theft? No contest? Okay. I'll accept your no contest plea as freely, voluntarily, knowingly given in all counts on 24 CF 40. State have an announcement on 24 CF 354.
Yes, Your Honor, the state will null pros that based off of the agreement.
Okay. Count 1, which is the felony count, is a withhold of adjudication, 2 years probation, $40 per month cost of supervision, $515 court costs, $150 cost of defense. Ms. Brown, you're going to have to submit to a substance abuse evaluation and successfully complete any recommended treatment, if there is any recommended treatment. No controlled substances without a prescription. You'll have random urinalysis for the detection of such substances. $9.60 restitution to the CEFCO on 5353 Verdun Boulevard. On counts 2 and 3, it's going to be a withhold adjudication as well, with 6 months of concurrent probation to the 2 years you got on count 3. Do you have any questions about that? All right. I'm going to need you to speak with probation. I also need you fingerprinted because although it's a withhold, it is a petty theft, which is enhanceable, which means if you get another one, as many as only one more, you could be charged with a felony. Do you understand that? All right. All right. Probation. Okay. Yeah. Mr. Klein, DOC up here waive supervision if you're appointed.
It's like, that's super awesome. No, I'll keep that in mind.
And this was a guideline sentence, correct?
Correct, Your Honor.
And I'm looking at the guidelines that show that she did not score. All right, and then also, Ms. Brown, you have 30 days to appeal the judgment and sentence of the court.
Your Honor, next I have Ashley Cook, to be followed by Wesley Moore. Ms. Cook is present and approaching. On Friday, the 2nd, Your Honor, we attempted to depose the alleged victim in this case. We did not get a return of service, so he was not served. Unfortunately, I'm going to have to ask the court to continue this so that we can try to reset that deposition, hopefully before Jan.
Okay, and this is a relatively new case as well. So, Ms. Cook, I'm going to put you on June 23rd at 9 o'clock for your next court date. Stay in touch with Mr. Kleins. Obviously, he's trying to work your case, so stay in touch with him.
Okay. Give me that text message. Next, Your Honor, I have Wesley Moore, and that'll be followed, last on the docket, to be Cecilia Mortimer. Mr. Moore is present and approaching, Your Honor. We did talk with the state between now and last Monday. The state has revised their plea offer. Mr. Moore is going to accept it at this time. Mr. Moore is going to enter a no contest plea as charged. The agreed upon disposition is that adjudication will be withheld. Mr. Moore would be assessed $515 in court costs, a $50 application fee, a $100 public defender fee. Essentially, this is a plea to withholding court costs, Your Honor, for both counts. May I approach?
Yes, sir. No objection to this. All right, thank you. Mr. Moore, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Can you state your full name and date of birth, please?
Wesley Michael Moore, 4/9/1986.
Mr. Moore, you're here as your attorney announced in 24 CF 2394, charged with possession of a controlled substance, third-degree felony, possession of drug paraphernalia, first-degree misdemeanor. I've been handed a plea and sentencing agreement that calls for you to plead to both cases, or both charges, withhold adjudication, $515 in court costs, $50 application fee, and $100 PD fee. Is that what you want to do today?
Yes, sir.
Is that the state's agreement?
It is, Your Honor.
All right. Have you gone over this plea and sentencing agreement with your lawyer? Did you understand and sign the agreement? Are you satisfied with the advice and representation from your lawyer?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea?
Sir.
You understand by entering a plea of no contest, which is indicated on your form, that you be given up your right to a trial and all of your trial rights, which are listed on page 2 of your agreement. And you understand you're waiving all potential defenses. Do you understand that if you're not a U.S. citizen, this could lead to your deportation? And what is your plea to the possession of controlled substance and possession of drug paraphernalia?
Contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given, withhold adjudication, 515 court costs, $50 application fee, $100 PD fee. How much time do you need to pay those?
2 months, I can do
I'm going to give you 60 days to pay them or set up a payment plan with the clerk's office. You can do that downstairs on the first floor. Again, it's a withhold, and it is a guideline sentence as well. All right. Withhold. I don't think I need your fingerprints. I do not. And you have 30 days to appeal the judgment and sentence of the court.
All right, good luck.
Thank you, Mr. Moore. Make sure you take care of those court costs or set up a payment plan.
Last I have on this morning's docket, Your Honor, is Cecilia Mortimer. And Ms. Mortimer is present and approaching. We did take the deposition of the alleged victim on Friday. However, in reviewing her discovery, there's at least 4 more officers that I want to depose. Furthermore, if at all possible, there will be a C4 in this case. I don't know, legally speaking, if I can file that. But, and so the state's aware, talking to Ms. Mortimer today, you should be seeing some amended discovery coming from us as soon as she can get it to me. So for that reason, I would ask the court for a continuance to the June date.
Okay. Put it on June 23rd at 9 o'clock. Ms. Mortimer, stay in touch with Mr. Kleins and be back on that date.
Get me that bill of sale. All right. That's all I have, Your Honor, if I may be excused.
Yes, sir.
Thank you.
Mr.
Have a good week.
All right. Thank you. I'll try. Mr. Cobb?
Lonnie Strahan. Judge Jason Cobb on behalf of Mr. Strahan. He has 2 cases around the docket. I've spoken to Mr. Strahan. He's not happy, but he understands, and he understands that we're going to be selecting the July 14th dates. So that's trial.
Which case is being tried? The 1400 case?
The case involving the female victim, I believe. I think that's the 1400.
That's the one I have it marked as. I just want to make sure we're on the same page.
Yes, Your Honor, it is the 1400 case. I want to be sure we weren't misspeaking.
And how long of a trial do y'all think that will be?
Your Honor, I would say, 2 days exclusive of jury selection, Mr. Cobb?
Yes, ma'am.
Very handy. You understand your case would be continued, and I'm setting it for trial for June 14th, and that is going to be a hard trial date.
July or June?
I'm sorry, July. Sorry.
He understands that's a hard date. We're going, and that's the date, yeah.
So I won't be continuing it again, short of some emergency for a witness or party.
All right, I'll see you Friday.
So we'll put you on June 24th at 9 o'clock for your next pretrial, but we're going to put you down for a trial date for July 14th.
Thank you, Mr. Strahan. Judge, that's my cases. I'll see you on Friday.
What do you have Friday now?
I'm going to bring Henry Hudson back and get that run.
That's correct. All right, thank you. Of course.
I'll see you Friday.
All right, we'll see you Friday. All right. Mr. Powell, did you have something? Is that just the one that's to a misdemeanor? What's the name again?
Thank you, Your Honor. Dixie Dan Powell on behalf of Devin Jones. Case number 2024 CF 2271. I brought the order and the plea and sentencing agreement, but we filed it online and in the portal.
Yeah. The problem is when it went through the portal, but that just brings it to me. I've got to get it filed. So can I see what you got there?
May I approach?
Yes, sir. he's pleading to the felony? Oh, okay. There it is. Okay, I'll announce it. You can step back, Mr. Powell. All right, so this is Devin Nathaniel Jones, 24 CF 2271. Who's the state on that? Mr. Sheik, is that you? Okay. And so I've been handed a misdemeanor plea and sentencing agreement that would call for count 1, the possession of controlled substance, and count 4, the simple assault, to be dismissed, and then a withhold on resisting without violence and disorderly conduct, no trespass at the Waffle House on North Verdun Boulevard, 270 in court costs, which would include the cost of prosecution. And that would be obviously concurrent because it's one case. Is that the state's agreement? It's just basically court costs on 2 and 3, the misdemeanors?
I had,
The original offer wasn't given by me, so I just wanted.
Okay.
One second, if I may.
Pardon me?
Like a withhold, or like
No, we changed it.
Okay.
We
Did
changed
we
it
change
to,
it?
yeah, to, he's gonna do a misdemeanor plea. Dismiss the
pleads to the
felony in
misdemeanor,
the
just
other
go straight
case,
to it.
and then plead no contest to that.
Yes, it is, Your Honor.
All right, then I'm going to accept the written plea in 24 CF 2271 as to counts 2 and 3. That's the resisting and the disorderly conduct. State have an announcement on counts 1 and 4.
Yes, Your Honor, the counts will null pros them.
Okay. Withhold adjudication, 270 in court costs. I mean, I can say no trespass at the Waffle House, but they'll probably have to actually get that done since there's no probation. I don't really have any jurisdiction to bring it back if that were to fail. So how much time does he need to pay the 270, Mr. Powell?
30, 60 days, Your Honor.
All right, I'll give him 60 days to pay, otherwise it'll go to judgment.
Thank you, Your Honor. And I had 270 court cost and $100 cost of prosecution.
I
but
think
it's
cost
just-
of prosecution is part of the 270.
Okay, great. Thank you. Thank you, Your Honor.
All right. Mr. Williams? Oh, different Mr. Williams. There's 2 of you. Which one? All right, Charles Williams.
Ended up with his bar card one time. Or, I'm sorry, he ended up with mine. He ended up with mine.
Oh, what, when you give it to the jail to?
Yeah. We were there at the same time, and he, I didn't think to look. Your Honor, I have a plea and sentencing agreement here that we'd like to enter into. I believe Ms. Leone has the score sheet.
Your Honor, I'm printing it now.
Okay.
As we're speaking.
Just one other sort of
Is it a
thing.
guideline sentence?
He's gonna plead as a youthful offender, so it takes it out of the guideline.
One other thing, Your Honor, we've agreed that he will enter his plea today. Ms. Leone would like to set the sentencing off because I understand there are some victims who would like to say some stuff to Your Honor.
Okay.
And we certainly have no objection to.
But it's an agreed upon sentence?
It is agreed upon sentence, yes.
Are there any terms of the probation? Oh, okay. All right. So, Mr. Whittington, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay. Can you state your name and date of birth, please?
Landon Whittington.
Put your hand down.
Landon Whittington, 05, 03, 09.
All right, Mr. Whittington, you're here in 4 cases, 24 CF 444, 23 CF 2879, 23 CF 2876, 23 CF 2875. I've been handing a plea and sentencing agreement that calls for you to be sentenced as a youthful offender and 4 years in the Department of Corrections, followed by 2 years of probation. Is this the agreement that you want to go forward with today?
Sure.
Now, I've been asked to not have the actual sentencing today because we're going to bring that back so that the victims can be present and can tell the court what they'd like to tell the court. But I just want to make sure you understand it's 4 years in the Department of Corrections, so that's state prison, followed by 2 years of probation, and this is as a youthful offender. Has Mr. Williams explained youthful offender to you?
Sure.
Do you understand that if you commit a technical violation, you're still limited to the 6-year total, right? But if you commit a new felony while on probation, I can go back and sentence you to the absolute maximum on all of these counts and cases. Do you understand that? And I'm going to go through them. It's going to take a while, but just to make sure that you understand that all of these are going to be potentially added up if you violate with a new felony. And the score sheet as of now on all these cases calls for 188 months, which is almost 16 years.
No, it should be 80 months, 79 months. The lowest permissible.
Oh, I'm sure I'm looking at the maximum in years. Okay. So your score sheet's lowest permissible prison sentence would have been, had you not been a youthful offender, 79.8 months. But you did add all that up for me. So the maximum that you'd be looking at if you were to violate your probation is 188 years in Department of Corrections. Do you understand that?
Yes, sir.
All right. So just to go through, he's pleading as charged in every case?
Yes, Your Honor.
All right. So there's 24 CF 444, unlawful use of a two-way communication device is a third-degree felony punishable by up to 5 years. Count 2, unlawful use of a two-way communication device, again, third-degree felony punished by up to 5 years. Count 3 is false report using firearms in a violent manner, second-degree felony punished by up to 15 years in Department of Corrections. Count 4 is extortion, second-degree felony punished by up to 15 years in DOC. And 23 CF 2879, unlawful use of a two-way communication device, third-degree felony, 5 years state prison. Unlawful use, count 2 is unlawful use of a communication device, third-degree felony, punished by up to 5 years in state prison. Count 3 is false report using firearms in a violent manner, which is a second-degree felony, punished by up to 15 years in state prison. Count 4 is false report using a firearm in a violent manner, second-degree felony, punished by up to 15 years in prison. Then counts 5 and 6 are two counts of misusing the 911 system. Those are first-degree misdemeanors punished by up to a year in county jail. Then you've got 23 CF 2876, unlawful use of a two-way communication device. You have 3 counts of that, which are third-degree felonies punished by each by 5 years in prison. Then you have counts 4, 5, and 6 are each counts of false report using firearms in a violent manner, second-degree felonies, 15 years in state prison each maximum. 7, 8, and 9 are 3 counts of misusing 911 again. Those are each first-degree misdemeanors punished by a year in county jail each. 23 CF 2875, unlawful use of a communication device, third-degree felony punished by up to 5 years in state prison. Count 2 is a bomb threat regarding state-owned property, second-degree felony, 15-year maximum. Count 3 is extortion, 15-year maximum on a second-degree felony. And finally, count 4, which is disturbing a school function, second-degree misdemeanor punished by up to 60 days in county jail. Do you understand all of those charges?
Yes, sir.
And do you understand, again, that the maximum, if you were to violate your probation, is 188.2 years in state prison if you violate it on a new law violation? Is this the plea you want to enter today? And you understand that sentencing will be put off to another day so the victims can be present, but it's going to be 4 years in state prison. Now, he has quite a bit of credit for time served, about a year, year and a half. They'll figure out the exact date and number of that, but just to make sure that's clear. And then once you get out, you'll be on probation for 2 more years. And that's because as a youthful offender, the cap is 6 years total of incarceration and probation. Did you go over this agreement with your attorney?
Yes, sir.
Did you understand and sign it? Are you satisfied with your attorney's advice?
Yes, sir.
Ms. Leone, is there anything else you want to put on the record as to why the plea bargain was given and why it's youthful offender? I'm not requiring you to. I just want to make sure if you want to put anything on the record.
Yeah, we considered obviously the age of this defendant, the fact that he didn't have any prior criminal history. And I've also communicated with the lead investigator who has communicated to other investigators and victims, and they were satisfied with this resolution.
Does that include the school system?
Yes, sir.
And how old was Mr. Whittington when he would have committed these offenses?
It was 14.
14?
14, Your Honor. In fact, he just turned 16 a couple of days ago.
Whittington, are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea agreement? Has anyone promised you anything to entice you to plea and enter this agreement? Do you understand that by pleading no contest as charged, is there an adjudication or not? It's not checked.
I believe it can be at the discretion of the court.
Well,
For
I
a
don't know
youthful
that.
offender, it doesn't have to be an adjudication if he serves DOC.
It does have to be.
It does not.
Why
For a
not?
youthful offender.
For a youthful offender.
Yes, yeah.
So are you leaving that to the discretion of the court?
Yes, Your Honor.
Is that something that's going to be determined at the sentencing hearing then? Okay. So let's check that. All right, so do you understand, Mr. Whittington, that means when we come back for the sentencing hearing, I'll be making a determination based on what I hear that day as to whether or not I'm going to convict you of these charges, so you'd be a convicted felon. Do you understand that? Since I'm actually making a decision in the case regarding that small piece of it, what do you want to do about a pre-sentencing report? Do you want that done, or are you waiving that, Mr.
We were going to waive that, Your Honor. I wasn't really sure if leaving that hanging chad, so to speak, required us to sign there or not. I was going to ask you about that.
Well, Mr. Whittington, do you understand that I'll be making that decision based on what I hear on an upcoming date?
Sir.
All right. Do you have any questions about that? Do you need more time to speak with Mr. Williams, your attorney, about that? Do you understand that you're giving up all your trial rights, which are specifically talked about on page 2? All right, I'm going to go through those. I mean, I'm not trying to be offensive, but you're a pretty young man. I want to make sure you understand these things. Do you understand that you have the right to plead not guilty? Do you understand that you have the right to trial by jury? Do you understand that you have the right to be represented at trial by a lawyer? Do you understand that you have the right to compel or make any witnesses come to trial? Do you understand that you have the right to be present when witnesses testify against you? Do you understand you have the right to cross-examine witnesses who testify against you? Do you understand that you have the right to remain silent and not testify against yourself? Do you understand that you have the right to present any and all defenses that you may have? Do you understand that you have the right to appeal all matters, including the issue of guilt or innocence?
Yes, sir.
Mr. Williams, does the plea consider that there are any issues that are being reserved on for or preserved for appeal?
No, Your Honor.
I haven't had the case for the first year of it, so I didn't know if there was any court decisions that were made that you'd be trying to preserve that for purposes of appeal. All right. Do you understand that you have the right for your attorney to further investigate the case, including locating and deposing any potential witnesses?
Yes, sir.
Do you understand that you have the right to testify at your trial? Do you understand there's not going to be a trial of any kind?
Sir.
Do you understand that if you're not a U.S. citizen, that you could be deported because of this?
Sir.
All right. Do you all stipulate there's a factual basis for this plea?
The state stipulates, Your Honor.
All right, Mr. Whittington, what is your plea as to each of the charges and counts that I've recited?
No contest, sir.
All right, I'm accept the no contest plea is freely, voluntarily, knowingly given. When would y'all like to set the sentencing?
Yeah, the information that I have from the lead investigator is that she will not be available the week in June from the 19th to the 29th. Any other time that the court is available, we can do it. I would like to possibly set it for an afternoon, and since some victims and law enforcement officers will be appearing via Zoom from other states.
What about? Check it before I say. May 29th at 2 o'clock.
Yes, Your Honor.
Just a moment, Your Honor, to make sure it's okay. Make it work.
All right. May 29th at 2 o'clock for purposes of sentencing. We'll see you back on that date, Mr. Whittington.
And Your Honor, that's the only case I have on your docket this morning, so.
All right, thank you, Mr. Williams.
Thank you, sir.
About his input on, is okay with the battery?
Yes, he's
okay.
With the
Can I give y'all back the score sheet, just because I can't file it until we actually have a sentencing? Just one of y'all just hold on to it and bring it back.
Williams, I have another copy. Actually, I do, right here. The ones that
All right. Y'all ready?
Yes, Your Honor.
Mr. Maddox or Mr. Williams? I'm not sure who's ready. Mr. Russell? I was surprised when I went through my cases last night that Miss Rivers doesn't have any on the docket.
Out of custody or just call them on the list first?
I know there's at least one listed under J. What is represented on the docket is not accurate. I'm going to need you to identify.
Okay. I got 3 plea agreements I can start with, Your Honor, for.
Hopefully by next cycle, all the
But,
names will be ready.
yeah, let me identify those because I circled them on my docket. So it'd be Daniqua Lemon, Larry Mayo. And those are both being handled by Mr. Russell, as well as Jessica Kosen. That's being handled by Mr. Russell as well. Firestone, which is listed under Mr. Williams, that'll be my case. And I apologize for the confusion. Your
No,
Honor.
it's fine. We're just trying to sort through all this as everyone's kind of moved around and shuffled. He's Maddox. He's Maddox.
Firestone, you mean?
Firestone is the
Yes.
only inmate.
That's that, and then the three that I just listed, if they weren't, I don't believe any of those are inmates. Lemon's not, Mayo's not, and Kosen's not. Yeah. Okay, perfect. And I'll just go ahead and call these plea agreements if you don't mind, Your Honor.
That's fine.
Travis Brennan. All right, we've reached a resolution in this case, if I may approach. This is Mr. Travis Brennan, Your Honor, 24 CF 2583.
So it calls for 10 days county jail, which I think we talked about last time is a minimum. Any idea on what his credit is?
No, Your Honor, you know how long you were in? Day or so, Your Honor.
Still figured, I just wanted to understand. So he's going into custody today.
Yes, Your Honor, he is.
All right, Mr. Brennan, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Can you state your name and date of birth, please?
Travis Brennan, 6791.
You can put your hand down, Mr. Brennan. All right, Mr. Brennan, you're here in 24 CF 2583, where you're currently charged with driving while license suspended or revoked, a third-degree felony, punished by up to 5 years in state prison. Do you understand that?
Yes, sir.
I've been handed a plea and sentencing agreement that would have you plead to a lesser included offense of misdemeanor driving while license suspended. It calls for an adjudication of guilt, $300 in court costs, $100 cost of defense, 10 days county jail, credit for all time served, and then you have 90 days to pay your costs and fees. Is that what you want to do here today?
I really don't want to go to jail, but yes, sir.
Okay, I understand that, but is this the plea agreement you want to go forward with
Yes, sir.
today? Did you read and understand the plea agreement?
Yes, sir.
Did you sign it?
Yes, sir.
Are you satisfied with your attorney's advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand that by entering a plea, you're giving up your right to a trial and all of your trial rights, which are on page 2 of the agreement you signed.
Yes, sir.
And do you understand you're waiving all potential defenses that you may have? And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, what is your plea to the reduced charge of misdemeanor driving while license suspended?
No contest.
I'm gonna accept your no contest plea. In 24 CF 2583 adjudicates you guilty to the misdemeanor driving while license suspended, Florida statute section 322.342B1, $300 court cost, $100 cost of defense, 10 days county jail with credit for all time served. You have 90 days to pay those costs. All right, Mr. Brennan, I need you to be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court.
Thank you, sir.
Since it's a misdemeanor, there won't be a score sheet.
Thank you, Your Honor.
Yes. Cost of supervision will be waived on Mr. Couch.
Thank you, Your Honor. Your Honor, that plea agreement is an agreed upon downward departure by legitimate plea bargain.
How much probation does he have left on these two cases?
The exact amount, I'm not sure, Your Honor. Do you happen to know off the top of your head?
Well, how much probation?
About a year, sir.
Let's see if I have the report on me, Your Honor. Scheduled termination date that I have, Your Honor, is April 24th, 2026.
That's the original one, right?
Correct.
But he's been in violation status since November.
Correct.
You understand your time hasn't been running while you've been on this violation?
Yes, sir.
All right, so the next 6 months you'll do on community control, then you have to finish out the rest of your time on regular probation.
Oh, okay.
All right, Mr. Parker, raise your right hand.
Do you have any other questions for me before the judge goes through the colloquy? No, sir. Okay.
Do you swear or affirm that testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, your name and date of birth, please.
Daniel Cornelius Parker, 2/15/1981.
All right, Mr. Parker, you're here in 24 CF 2688, charged with driver while license suspended or revoked as a habitual traffic offender, third-degree felony, punishment by up to 5 years in state prison. Count 2 is resisting arrest without violence, first-degree misdemeanor. 24 CF 581 is a VOP, and 23 CF 1527 is a VOP. The plea and sentencing agreement I've been given calls for the new case to be an adjudication of guilt and time served. What is the court cost on that? $515 in court costs, and then $150 for the PD fee. And then you've got 23 CF 581 and 23 CF 1527 is a violation of probation, where y'all have agreed that your next 6 months will be on community control, followed by the rest of your term on probation. And then you have to complete the original requirements of that probation. And then you'll have a $100 VOP fee for each case and a $100 PD fee for each case. Do you understand all that? Okay, is that what you want to do today?
Yes, sir.
All right. Have you gone over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with your lawyer's advice and representation?
Sir.
Are you currently under the influence of any alcohol, drugs, or
sir.
controlled substances? All right, you just got to wait so we're not talking at the same time. Are you currently suffering from any mental health issues or concerns?
No, sir.
All right. Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea? And do you understand that if you enter a no contest plea in this new charge, there won't be a trial of any kind?
Yes, sir.
And you understand if you admit your violation of probation in the 2 VOP cases, there won't be an evidentiary hearing?
Yes, sir.
And do you understand that you're waiving all of your trial rights in the new case?
Yes, sir.
And those are listed in the agreement on page 2 of the agreement you signed?
Yes, sir.
Do you understand that if you're not a U.S. citizen, this plea could lead to your deportation?
Yes, sir.
And do you understand your score sheet came up to 35.775 months in state prison?
Yes, sir.
So the only reason that you're not going to prison today is because you negotiated this with the state?
Yes, sir.
All right. As to 24 CF 2688, the drive while license suspended as a habitual traffic offender and the resisting without violence, what is your plea?
No contest, sir.
All right. And to the 2 violations of probation, 24 CF 581, 23 CF 1527, do you admit or deny your violation of probation? Okay. I'm going to accept your no contest plea in 24 CF 2688 is freely, voluntarily, knowingly given. I'm going to accept your admission to the violations of probation as freely, voluntarily given. On the 24 CF 2688, adjudication of guilt, credit for time served, $515 in court costs, $150 to the public defender's office for your fee and application fee. In the 2 VOPs, it's going to be, I accept your admission, modify your probation for the next 6 months will be community control. Then you'll finish out the remainder of your term of probation. Complete all the original requirements, $100 VOP fee on each case, $100 PD fee on each case, and you'll pay those through your probation as well. Any questions, Mr. Fletcher?
No, sir.
All right. I'm going to have you talk to probation. I also need your fingerprints before you leave. You have 30 days to appeal. State agrees this was a downward departure based on uncoerced plea bargain.
Yes, Your Honor.
That's what I would ask for. I'd ask you have time to pay the fees during
All right.
probation.
I'm going to give you 60 days, Mr. Parker, to pay the costs on the new case. You can do that by setting up a payment plan with the clerk.
Thank you, Your Honor.
Thank you.
All right, next up I have Mr. Cameron Thomas, 23 CF 1517. Your Honor, Mr. Thomas is present and approaching.
All right, go ahead.
Your Honor, I apologize to the court. We've worked out a pretrial intervention agreement for Mr. Thomas. We just need to get that signed. The state's going to provide that to me as soon as they can. We'll make sure to get that ready to go by the 9th, Your Honor, if you could just put him on the 9th for resolution.
That's correct, Your Honor.
This is Cameron Thomas.
Yes, Your Honor, 23 CF 1517.
All right, Mr. Thomas, we'll see you back on Friday, May 9th at 9 o'clock. That's this Friday.
Yeah. All right, I'll have that ready. Your Honor, next up I have Mr. Benjamin Deacle. I've spoken to the state about this case. I've also called Mr. Deacle. I may have accidentally told him his court date was 1 o'clock. That's what he informed me. He was coming he was on his way here, Your Honor, actually. I made sure to make contact with him, as did my office. I talked to the state about it. They're not going to be seeking a capias at this time. I would ask the court waive his appearance. Your Honor, we have a pretrial intervention agreement worked out. I'll put him on the 9th for resolution. I'll make sure to have that ready to go.
May 9th at 9 o'clock. Make
Yes,
sure
Your
to
Honor.
tell him that for the PTI.
Thank you, Your Honor. He'll be here. Your Honor, I have one on Zoom, Mr. Jonathan Wolf. 25 CF 454.
All right, Mr. Wolf, are you there? Can you hear me okay?
Yes, sir. Yes, sir, I can.
All right.
Yes, sir.
All right, thank you, Mr. Wolf.
Your Honor, last time I was here, I did provide the court with a copy of the order finding the defendant not guilty by reason of insanity and order for conditional release. It's both my intention and the state's intention to stipulate to that order, Your Honor, and have it adopted by the court, if the court is amendable to that. Okay.
And then what happens after that?
The state is going to dismiss the charges.
Okay, that's what I thought. I just wanted to make sure
Yes.
we're still on the same page.
Yes.
Yes, Your Honor, I do have another copy if the court needs it.
I've got it right here.
Okay, could we file that under seal, Your Honor? It's got confidential information there, including the reports.
It hasn't been filed yet, right?
Oh, no, Your Honor, no.
Okay,
it's just
well,
when it
if
is
you want to
filed.
file it under seal, but I've reviewed it, you can file it under seal. I'll agree it's to be sealed because it has confidential reports on it.
Thank you.
But I've read this. This is an order finding defendant not guilty by reason of insanity that was done in Santa Rosa County by Judge Drake just a couple of months ago. It's my understanding that those charges are the same date and part of the same kind of incident. Thank you.
Correct, Your Honor. It originates from the same incident.
And so based on that, I'll certainly accept the stipulation and adopt Judge Drake's order. It's a well-reasoned order. It's my understanding they had a bench trial on February 28th of 2025 where Mr. Wolf was found not guilty by reason of insanity.
Correct.
And then, again, that was from the same date. So if he was at that time, then that would obviously go for our case as well. So based on the court's adoption of that order, what's the state's position?
The state dismisses the charges in Okaloosa County against Mr. Wolf.
All right, Mr. Wolf, so your case has been dismissed. You're good.
Okay, thank you very much, Your Honor.
All right, thank you, Mr. Wolf. Make sure you comply with the Santa Rosa terms, though. You're on conditional release still. Okay.
Okay, I've been doing it. Thank you very much.
All right, thank you.
Thank you very much.
The rest of them are in custody. If you just call an order on the list, the court would prefer that. Okay.
Sure.
Yeah. Mr. Carter. Your Honor, this is Mr. Rocky Carter before the court in 25 CF 263. He had voiced that he wanted a trial. I've discussed this case extensively since then with Mr. Carter, and he has agreed to allow me to continue the case, Your Honor.
Mr. Carter, is that accurate? Was that accurate, what your attorney just announced?
Yes, sir.
I know last time you wanted a trial, and he said he just got the case, and he's not familiar with it enough to try it yet.
Well, since then, I have talked to Brad Stewart
Okay.
and Paul Mixon, and they asked me to confront the court about my case. And they said that if there's a way to talk to the judge, and now it said that, is there any way that I could get 6 months credit for time served?
I don't negotiate pleas, sir, so
Okay, but-
here's what your options are. You can talk about setting your case for trial. You can take whatever the state's offer is, or you can plead straight up to the court, which means I can give you anything, including the maximum penalty. You're currently charged with felony battery, which is a third-degree felony for which you can get up to 5 years in state prison, and then assault on a person 65 years of age or older. Is that a first-degree misdemeanor or a third-degree felony? We don't see a whole lot of assault charges like
Yeah,
that.
first-degree misdemeanor, to my knowledge, Your Honor.
It's a misdemeanor. I just wanted to make the court aware that the information is going to be amended to reflect count 1 to be battery on person over 65 years old.
Okay.
So
I think we
I'll-
talked
That
about
was
that.
discussed
It's
last time, Your Honor.
Same degree, right?
I've made Mr.
Does the
Same
level
degree,
change?
Level 4 instead, like
And what is it
F3.
now? Now it's a level 3,
Now it's a level 1.
level 1.
Level 1, and it becomes level 4.
Yeah, the current score sheet reflects 17.775 months. The state has since extended another offer where he could do rehab and do 2 years of community control, ECLC, 1 year of drug offender probation as well with that. Is that correct?
Yes, it is
Okay.
correct. Your
Yeah,
Honor.
so that's the offer currently, Your Honor,
Has
and
that
I've
been
certainly
conveyed to
discussed
Mr.
that.
Carter? Has that been conveyed
It
to
has.
Mr. Carter?
It has, and I will get him evaluated for Keaton and some other places as well, Your Honor. And then, if he still wants a trial, that's absolutely fine. We'll be prepared if that's what he wants to do next cycle.
You understand all that, Mr. Carter?
Yes, sir. I'm just trying to avoid the trial and help myself and let it be known this is my sister and there was no
No,
battery.
don't talk about the facts of the case. I got you. We've talked about that. We're good.
Well, if there's a disagreement on the facts, that's what trials are for, sir. Otherwise, again, you can plead to what's been offered, or you can plead straight up to the court. But I don't engage in plea negotiations. All right, so we'll put you on the June 24th date for pretrial. Obviously, if y'all work something out, you can bring it in earlier than that.
Of course, Your Honor. Thank you.
All right, thank you, Mr. Carter.
Mr. Davis.
Mr. Davis. Your Honor, I was just advising Mr. Davis, apologies for that. Mr. Davis is before the court in 24 CF 1400 25 CS 350, CF 352, and 24 CF 2059. Your Honor, the state is working on getting me a new offer. I believe they're going to come down on some of the charges, which is going to affect Mr. Davis's score sheet. I know Mr. Davis was seeking an 1129 offer here last time. I'm awaiting to see if the state is willing to downward depart or not based on their new offer, Your Honor, a new score sheet.
The state will get the amended offer with the score sheet, but we will not be downward departing in this
To
case.
1129,
So
okay.
it will be DOC, will be the offer.
Okay, so when do you want to bring it back, Mr. Maddox?
If we could just continue this to the June 24th pretrial date, Your Honor. Also, just, I am still waiting on discovery, if you could check on that, Josh.
All right, Mr. Davis, June 24th will be your next pretrial. Obviously, if they work something out, they'll bring it back to me faster than that so we can resolve it.
Talk to you about all that. I'll come see you at the jail.
Thank you, Mr. Davis.
Thank you, Your Honor.
Mr. Espinoza.
Your Honor, this is Mr. Nicholas Espinoza before the court in 24 CF 2353. Your Honor, over the weekend, the state was able to speak to the victim. They are now conveying a pretrial intervention agreement. I believe the specifics of that offer have been conveyed to me. He's set for the 9th. If we could just leave him set for the 9th for likely resolution.
Is he on the docket for today?
He is, Your Honor, I believe.
I just don't see him under your.
We had him here for the 5th to get the status of whether or not that offer was going to be in place, and then we still have the bond motion set for the 9th if need be, Your Honor. I'm not sure that'll be needed, and I'll certainly advise the court as soon as I can if that's not.
Is he under someone else's name?
Mr. Espinoza? No, he shouldn't be. It's news to me.
It's not on mine. That's fine, I just want to make sure I'm not losing something. All right, May 9th at 9 o'clock, that'll be this Friday, Mr. Espinoza, and it sounds like they're going to get it resolved for you.
Yes, sir, thank you.
Thank you, we'll see you then.
Talk to you about the specifics of that, okay? It's a better offer than what we had before. Yeah, man.
Schofield, right?
Morning, Your Honor.
Morning. What are we doing with Mr. Schofield?
Okay, Your Honor, so this is Mr. Schofield before the court in all 4 of his cases, 24 CF 2080, 24 CF 1844, 25 CF 495, and 25 CF 398. Your Honor, last time we had spoken about setting case 24 CF 2080 for trial. That is still Mr. Schofield's intention. Mr. Schofield has rejected a 9-month Okaloosa County Jail global offer to resolve all cases where 24 CF 1844 would have been dismissed.
You ready for trial in 2080?
I mean, I would have preferred to take depositions, but with what I have, yes, Your Honor, I am ready for trial.
Okay, you understand, Mr. Schofield, is that your attorney's saying he hasn't had a chance to do any depositions in that case yet, but you're saying I want my trial no matter what?
Oh, yes, sir, due to the circumstances of the case, yeah, you know, Your Honor, like the motions that have been filed, I did them all myself. You know, I had to do them, Mr. Maddox didn't want to do them, you know, like I don't know, like he didn't even want to do the notice of alibi, I did it too. And if I was here in court, I don't understand why he wouldn't have wanted to do that, but you know, I believe that I'm, if me and him have any more disagreements, I believe that I'm ready to, that I could do the cases pro se, because this isn't a murder case, it's a petty theft where I wasn't even there, so I don't think I'd have a problem beating it.
Okay, but do you understand each of these cases are third-degree felonies and punishable up to 5 years in state prison?
Well, yes, sir, but Your Honor, not for me, they're not, because they're using my father's priors.
Yes, for you. We've gone over
Well,
that.
show me a thumbprint and a case number where I've been convicted of petty theft. You won't.
That's what the trial's for, sir.
Yes,
So
sir.
that will all come out at the trial.
Yeah, my priors, because my dad's name is Robert Dwayne Schofield, and if you'll look on the thing.
I'm not going to look at that. That's for the evidence, that's evidence at the trial.
Yes, sir.
Your Honor, for the record, the state has not, in 2080, the state has not received any motion or notice of alibi in the case that we have set for trial.
Yes, sir, Your Honor, I filed it, and it's been sent, it may take another day or two.
Hold on.
It's not in
The state
2080.
has received one in an alternate case, but not for the case that is set for trial.
Yeah, it's
We have
in
received no notice of alibi.
25 CF 495, and at this time, I'm not adopting that notice because we have not received discovery in that case, and I've not been able to even establish whether an alibi defense would be plausible or not, Your Honor.
Your Honor, at this time, I would like to exercise my right just to go pro se, please, I beg of you.
Okay, that's fine.
All right, Mr. Schofield, we're going to call you back up. I'm going to try to get everybody else out of here, then we'll go through what's called a Ferretta hearing, and I'll make a decision as to whether or not you're going to be able to represent yourself or not.
Thank you, Your
Just that
Honor.
you're capable of doing it.
Oh, yes, sir, thank you.
All right, we'll call you back up. I just want to kind of get through some more of the cases before we take a long time with you, Mr.
No problem, Your
Schofield.
Honor. Hey, good morning. This one's under J, Your Honor.
All right, what are we doing with Mr. Firestone today?
Your Honor, this is Mr. Firestone. Your Honor, I'd ask for a continuance in this case. The state has relayed an offer with which Mr. Firestone is still considering. I also need to continue investigating this case from my end, Your Honor. It's pretty new to me, and I'll go over all that with Mr. Firestone and see where we're at next cycle.
Understand that, Mr. Firestone?
Yes, sir, I do.
June 24th at 9 o'clock. We'll see you back on that date.
Yes. Have a good day.
Yep, see you.
Are you still waiting? Why don't we do this? Why don't we take about a 5-minute recess real quick, get everyone kind of lined up?
Sure, thank you, Your Honor.
All rise, please.
Mr. Maddox?
Yes, thank you. Hey, how you doing?
How are you?
Hey, good. Your Honor, this is Miss Nikki Grimes. She's before the court in 24 CF 1776. Your Honor, I believe the state just needs to further speak with the officers in this case. We're trying to work towards a resolution, and the state may be willing to come off some of these charges or come down based on those discussions.
Yes, Your Honor, the state reached out, have not been able to get in contact yet. They may have tried to reach me this weekend. I was at drill, so I didn't get all my emails and messages back yet. Hopefully, we can resolve it quickly, Your Honor.
29th maybe, if you're willing to throw it on there?
Well, why don't we do this? Let's put it on the June 24th. If y'all work something out, we can probably get it even faster than May 29th, but just find a date and get it on there.
Certainly, Your Honor.
All right, June 24th, 9 o'clock. And Ms. Grimes,
See,
like I
okay.
said,
All right.
they work it all out. The court's always open for a plea.
May I ask a quick question? Right.
Thank you, Ms. Grimes.
Your Honor, this is Miss Gloria Pettit, 25 CF 343, 23 CF 1829, and 24 CF 738. Your Honor, we're working towards global resolution. In this case, it's still fairly new. I'd ask for a continuance today. She had gotten into the Savings Grace Women's Home. For personal reasons, she does not want to attend that facility. She would rather attend Keaton, so we're going to send her a Keaton application, make sure that gets in, Your Honor. And as long as she gets into Keaton, the state's amenable to doing Keaton in lieu of the Saving Grace Women's Home.
This case is just from February, but obviously there's the VOPs. I'll put it on the June 24th at 9 o'clock date, but again, if y'all get it worked out, bring it in sooner than that.
Certainly, Your Honor.
All right, thank you, Ms. Pettit. We'll see you back on the June 24th or sooner if there's a resolution. Thank you.
I believe that's all my cases? Okay. Just to double check though, Your Honor, there's no Venetia Berry on the docket today.
I don't remember that name.
I don't think so. I just want to double check and make sure.
I don't see
Okay, perfect. Thank you, Your Honor.
Mr. Nopes, have you asked to cut in?
He probably is. It's a plea to a misdemeanor.
On Rycroft?
Rycroft, yes, sir.
Gone over it yet?
Judge, I went over it with him, and he signed it, and,
You're up, so we probably.
well, if he left, he left. I mean,
Oof. Sorry.
That's it. Your Honor, may I approach?
So this is an agreed upon downward departure?
Sure.
Okay.
Yes, sir.
All right, Mr. Barnhill, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Barnhill, you're here in 23 CF 1308, charged with domestic battery by strangulation, which is a third-degree felony punished by up to 5 years in state prison. You also have 24 CF 496, which is dealing in stolen property, which is a second-degree felony and punishable by up to 15 years in state prison. I've been handing do you understand your charges?
Yes, sir. Yes,
All
sir.
right, and I've been handed a plea and sentencing agreement between you and the state that calls for you to plead no contest to those charges, be adjudicated guilty, sentence for credit for time served, $967 in court costs on the 23 case, and $150 court-appointed legal assistance fee, and then you've got on the 24 case is $515 in court costs plus another $100 legal assistance fee. Is that what you want to do here today?
Yes, sir.
Is that the state's agreement?
Yes, it is.
Has the state discussed this with the victim in the 23 case?
They have provided input.
They've
Yes,
provided
sir.
input?
Yes.
Okay. All right. Mr. Barnhill, did you go over this agreement with your lawyer? Did you understand and sign it?
Yes, sir.
Are you satisfied with your attorney's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances?
Yes, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for the plea? Do you understand if you plead no contest as contemplated in this agreement, there won't be a trial on either case? And you understand you're giving up your trial rights, which are on page 1 of the agreement you signed? You understand you're waiving all potential defenses that you may have to those cases?
Yes, sir.
And you'd be adjudicated guilty in both these cases, which means those would be felony convictions for you. You understand that?
Yes, sir.
All right. Do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right. And what is your plea to the domestic battery by strangulation?
No contest.
And what is your plea to the dealing in stolen property by trafficking?
No contest.
Accept your no contest pleas as freely, voluntarily, knowingly given. As charged in 23 CF 1308, it's going to be $967 court costs, $150 court-appointed legal assistance fee. Again, it's adjudication and credit for time served on both cases. In the 24 CF 496, it's going to be $515 in court costs, $100 court-appointed legal assistance fee. Do you need time, Mr. Barnhill, to pay those?
As much as possible. I got a job lined up, but
I'm going to give you 60 days to either pay them or set up a payment plan with the clerk's office.
Clerk's office. Okay, thank you,
But make
sir.
sure you do that, otherwise it's going to be a judgment.
Yes, sir.
Suspend your charge of election.
Yes, sir. Yes, sir. Thank you.
All right, this is a downward departure based on an uncoerced plea bargain with the state. I'm going to need you to be fingerprinted before you leave,
Yes, sir.
Mr. Barnhill, and you have 30 days to appeal.
Thank you, sir.
Thank you.
Judge, my last case is J.C. Rycroft, 24 CF 1676. May I approach?
Yes, sir. All right. Mr. Rycroft, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, can you state your name and date of birth, please? All right, you can put your hand down, but pull the microphone a little closer to you. You're kind of soft-spoken. All right, Mr. Rycroft, you're here in 24 CF 1676. I've got a plea to a lesser-included offense of misdemeanor battery that calls for you to be sentenced to time served, $270 in court costs, $150 court-appointed legal assistance fee. You got payable within 12 months, but I would say just do a payment plan with the clerk. 12 months is a pretty long time for us to be, keeping tabs on that.
I understand, Judge. I asked him how long he thought it'd take him, so.
Okay. Well, you can set up a payment plan with the clerk's office, and they'll give you how much you'll have to pay every month to be done. Is that what you want to do today, Mr. Rycroft?
Yes.
All right. Did you go over this form with the agreement with your attorney?
Yes, I did.
Did you understand and sign it? Are you satisfied with your attorney's advice and representation? Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Say again. You're just very quiet. It's kind of hard to hear. All right. Has anyone forced, pressured, or threatened you in any way to enter this plea?
No.
Has anyone promised you anything in return for your plea? You understand there won't be a trial of any kind and you're giving up your trial rights? Use hand sanitizer over there or something? It's just, for some reason, it's very odorous at this point. All right, do you understand you're waiving any potential defenses that you have, Mr. Rycroft?
Yes.
Do you understand that if you're not a U.S. citizen, this could lead to your deportation? All right, and what is your plea to the lesser included offense of battery?
No contest.
All right, I'll accept your no contest plea as freely, voluntarily, knowingly given to the misdemeanor battery. Adjudication guilty, $270 in court costs, $150 court-appointed legal assistance fees. I'll give you 60 days to pay that or do a payment plan for it, Mr. Rycroft. But don't just ignore it. All right, this is a misdemeanor, so it doesn't need a score sheet. I do need your fingerprints because it's a battery charge, and you have 30 days to appeal. Thank you.
Thank you, Judge.
Thank you, Mr. Knopf.
That's all I've got.
Thank you.
Judge, with the court's permission, I'm going to call my out of custody, then Mr. Williams is going to call his out of custody, and we'll go back to the inmate list.
Okay. However y'all want to do it.
Jessica Kosen, case number for the record is 24 CF 2203. Kosen, no response, Judge.
Was she here last Monday?
Yes, sir.
Date?
State would ask for a KPS, Your Honor.
APS, no bond. Mr. Russell, if you get in contact with her, I'll consider withdrawing it.
Yes, sir.
There's a reason for it.
Yes, sir. Daniqua Lemon. Lemon's case number, Judge, is 24 CF 2165. She's present and approaching. The case was passed to today, Judge, to see if the state could get a hold of the alleged victim to work out an alternate plea bargain in this case. He was not able to reach those people, so at this time, we're just going to ask for a full continuance to the June docket.
June 23rd at 1 o'clock, Ms. Lemon. Stay in touch with your lawyer. Obviously, if they figure something out and want to bring it in sooner, they can. Thank you.
Next case, Judge, is Larry Mayo. Case number is 24 CF 2367. Mr. Mayo is present and approaching. Judge, we've worked out a plea agreement, and I also have a score sheet if I may approach.
All right, calls for him to plea as charged, credit for time served, which would be a downward departure, correct?
Correct, Judge.
All right, Mr. Mayo, raise your right hand. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, Mr. Mayo, you're here in 24 CF 2367. You're charged with possession of a controlled substance, third-degree felony, punishment up to 5 years in state prison, possession of less than 20 grams of marijuana, which is a first-degree misdemeanor, punishment by a year in county jail, failure to have insurance, second-degree misdemeanor, 60 days in jail, and drive while license suspended, first-degree misdemeanor, 1 year in county jail maximum. Do you understand all that?
Yes, sir.
I've been handed a plea and sentencing agreement between you and the state that calls for an adjudication of guilt, time served, court costs, which would be $615, which includes the cost of prosecution, and $150 of PD fee. Give you 120 days to pay that, or else it'll go to judgment.
Yes, sir.
Is that what you want to do here today?
Yes, sir.
All right, did you go over this plea and sentencing agreement with your attorney?
Yes, sir.
Did you understand it and sign it?
Yes, sir.
Are you satisfied with your attorney's advice and representation?
Yes, sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand that the possession charges are going to give you another driver's license suspension?
Yes, sir.
Okay, so you got a lot to clean up.
I know a lot.
And
That's what I'm working on next.
all right, well, Hopefully you get it all worked out, but, there's the driver's license clinic is happening in September. You might want to take a look into that, too, if you're still
Yeah, Mr.
struggling
Russell
at
told me
that
about
point. Okay. And do you understand that by entering a plea, there won't be a trial of any kind?
Yes, sir.
And do you understand that you're waiving all potential defenses?
Yes, sir.
And you're waiving your trial rights, which are on page 2 of the agreement you signed?
Yes, sir.
And do you understand if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, so again, this is adjudication of guilt, so this is a felony conviction for you?
Yes, sir.
All right. And what is your plea to each of the 4 counts?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given, adjudicate you guilty, time served, 615 court costs, which includes the $100 cost of prosecution, plus a $150 PD fee that you'll pay within 120 days, or else it'll go to judgment. This is a downward departure based on the uncoerced plea bargain between you and the state, Mr. Mayo.
Yes, sir.
You have 30 days to appeal, and I need you to be fingerprinted before you leave this
Okay,
morning.
thank you.
Next case is Judges Michael Bell. He has 2 cases on the docket, 24 CF 1340 and 24 CF 1355. Mr. Bell is present and approaching. Judge, it was passed to today for plea or continuance to see if Mr. Bell wanted to take the state's probation offer. He does not, so at this time, we're going to ask for a continuance to your next pretrial conference day.
Is that what the intent to set it for trial next time?
If we can get all the depositions done, Judge, and he's on my list of people to set.
This is Michael Bell?
Yes, sir. Jake Bell's in custody.
Yeah, I'm just...
Yeah.
Between things changing between y'all's names and then the same last name, I'm just trying to keep them all straight.
Yes, sir.
Where they're at. Was he here last time?
Last minute, Your Honor.
He came in.
You were the one at the last minute?
Yes, sir.
Okay. That's why I think we had a capias for you, and I just want to make sure that was withdrawn, correct? All right. So
Thank you.
I was just making sure that you didn't have a warrant out for
Yes,
you
sir. I appreciate
because of
that.
last time, but you got here in time. All right, so we'll see you back on, it's going to be June 23rd at 1 o'clock, Mr.
Thank
Bell.
you, Your Honor.
You got that date? June 23rd?
Yeah, I got it. I'll
Don't be
here.
late.
I won't be.
Okay. Okay, we'll see you then. And then my last out of custody judge is going to be Elijah Falls, Falls. Case number is 24 CF 2112. Mr. Falls is present and approaching, and we have a plea agreement and a score sheet, if I may approach.
All right, Mr. Falls, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, I do.
All right, can you state your full name and date of birth, please?
Elijah Julian Falls, 10/30/03.
All right. And Mr. Falls, you're here in 24 CF 2112, where you're charged with possession of a controlled substance, third-degree felony, punished by up to 5 years in state prison. Do you understand that?
Yes, sir.
All right, I've been given a plea and sentencing agreement between you and the state. That calls for you to plead no contendere or no contest as charged. It would be an adjudication of guilt, which is a felony conviction. Do you understand that?
Yes, sir.
Time served, 615 in court costs, including the cost of prosecution. $150 PD fee within 90 days, or it'll go to judgment. Is that your understanding?
Yes, sir.
Is that what you want to do today?
Yes, sir.
Okay, I gotta hear you. All right, did you go over this form with your attorney?
Yes, sir.
Did you understand and sign it?
Yes.
Are you satisfied with your attorney's advice?
Yes.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, promised, or forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for the plea?
No, sir.
You understand by entering a plea there won't be a trial of any kind, and you're giving up your trial rights, which are on page 2 of the agreement you signed.
Yes, sir.
You understand you're waiving all potential defenses?
Yes.
And do you understand if you're not a U.S. citizen, then this could lead to your deportation?
Yes, sir.
And what is your plea to the possession of a controlled substance?
No contest.
Accept your no contest plea is freely, voluntarily, knowingly given. Adjudicate you guilty. Time served, 615 in court costs, including the $100 prosecution, $150 PD fee within 90 days to pay all that, otherwise I'll go to judgment. I'm gonna need you to step up and be fingerprinted because it is a felony conviction, as I mentioned, and you have 30 days to appeal the judgment and sentence of the court. This is a guideline sentence.
Peggy Casper?
Casper?
Yes, sir. 4624 CF 989.
She here?
Judge, she did not answer the call.
Was she here last week?
She was here last week, Judge.
You don't ask for a KPS.
KPS, no bond. Again, you have any contact with Mr. Williams, I'll entertain a motion to withdraw
Thank you, Judge.
the KPS.
Judge, the next one that I have that's out is Sebastian Fletcher Gillette. Judge, this is going to be a plea. Sorry, Judge, I'm trying to avoid giving you more than one score sheet.
Thank you.
Judge, from the original typed offer, there's been one change. It was reduced from 34 to 24.
All right, sir, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Can you state your name and date of birth, please?
Fletcher, 09/10/2000, sir.
All right, and Mr. Fletcher, you're here in 24 CF 2477, currently charged with dealing in stolen property, which is a second-degree misdemeanor or felony, punished by up to 15 years in state prison, and as well also pawn breaker transaction fraud, which is a third-degree felony, punished by up to 5 years in state prison. Do you understand all that?
Yes, sir.
All right, I've got a plea and sentencing agreement between you and the state that calls for you to be adjudicated guilty upon a no contest plea, 24 months in Department of Corrections on each count, and those will be concurrent. Restitution, if any, will be reserved on for 90 days, $515 in court costs, and then $150 to the appellate defender. Is that your understanding?
Yes, sir.
Is that what you want to do today?
Yes, sir.
Did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand and sign the agreement?
Yes, sir.
Are you satisfied with your attorney's advice? Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? And this is the state's agreement and a downward departure?
It is, Your Honor.
Based on uncoerced plea agreement?
That's correct. Thank you.
Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea? You understand if you enter this plea, there won't be a trial of any kind, and you're giving up your trial rights, which are starting on page 1 and going on to page 2 of your agreement. All right, do you understand you're waiving all potential defenses that you may have? And do you understand if you're not a U.S. citizen, then this could lead to your deportation?
Yes, sir.
And you understand these are felony convictions? All right, and what is your plea to each of the counts?
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. Adjudicates you guilty on both counts, 24 months in the Department of Corrections. Credit for any time served, correct?
Yes, sir.
And see it mentioned, I just want to make sure. That'll be for each count, and they'll run concurrently. Reserve restitution for 90 days, $515 court costs, $50 application fee, and $100 PD fee. Judgment on those then, Mr. Williams?
Do you want to either have a date certain to pay it when you get out, or just go to a judgment and you pay it when you can?
Either or. Either or, sir.
All right, right, I'll just make them the judgment since it's Department of Corrections. All right, and this is, again, a downward departure based on an uncoerced plea, where you scored almost 33-plus months. All right, Mr. Fletcher, you've got 30 days to appeal. I need your fingerprints, and then you'll be taken into custody.
Judge, the next case I have is Cody Hinesley. He has two cases, 4622 CF 2449 and 4622 CF 1909, excuse me, three cases, 4622 CF 3039. Mr. Hinesley was determined some time ago to be incompetent to stand trial. He's gone through outpatient competency training as a result of a conditional release plan. We received certification from the current supervisor of that plan that she believed that he was competent to stand trial. I had previously met with him, come to the same conclusion, and in fact had inquired about us internally having him evaluated by Dr. Zeman. I don't believe that's happened yet. So we're satisfied with the report on the supervisor of the conditional release plan.
That been filed somewhere?
Believe it was filed with the clerk, Judge.
There's 3 different cases. I'm trying to find them.
I do have a copy. It's dated 4/15/2025 by Gabrielle Balancier.
All right, have you seen this? Who's on the?
I'm trying to go, Your Honor, on benchmark.
I don't see where it was filed. I've only checked 2 out of the 3 cases so far, but.
I only saw the reciprocal discovery shared by Mr. Williams.
That was back on November, or the
19, yeah.
Yeah, we filed it on November 19, or gave it to you on November 19, and his conclusion was dated, I believe, November 17. I can give the court my copy of that.
That says he was competent.
Yes, sir.
Back in November?
Yes, sir.
Why is he still on restoration if he was competent in November?
Because I think that was when we were still trying to get her in a position where she could take that over, and we were basically without anybody. Mr. Barnes had left the position.
What I'm saying is the doctor did a report back in November that said he was competent back then. So
Yes,
why
sir.
was he still doing restoration on conditional release?
I believe at this point, we still had to have I'm not sure what we'd call her, but the person that supervises the restoration program. And at the time, we did not. There were some, I believe, certification issues that were delaying her being able to take over. And so we went for a period of a few months with Mr. Barnes being gone and her not being in a position to render an opinion, offer testimony, being able to be fully on board.
Okay, I understand that, Mr. Williams, but what I'm saying is he had been going to competency restoration.
Yes, sir.
And a doctor evaluated him, Dr. Zeman.
Yes, sir.
Back in November and said he was competent back then. So
Yes,
what does
sir.
it matter what competency restoration people say now if he was already competent back then?
My understanding was that they would be a necessary party, and that at that point, I didn't feel like I had a necessary party that I could include in this.
yeah.
Well, I mean, he was found competent back in November. It sounds like he's been doing everything right since.
Yes, sir. One of the things that I'd asked about was to try to get the case resolved for time served or something of that nature today. There was a question regarding restitution. The state was considering making an offer for probation so that restitution can be ordered. I think the last conversation was along the lines of we'll find out what the restitution is and maybe we can have him just go ahead and pay that. He's got some family resources that might be able to help.
Do we need to have a competency hearing, or are y'all stipulating to the reports?
I'm stipulating to the report.
Yes, Your Honor.
Based on the stipulated reports, again, I'm reading the Dr. Zeman's report back from November that said he was competent, and then as well as Ms. Balancier, who says he's been attending his restoration meetings on his conditional release and continues to be compliant and appears to be capable and competent to attend his hearing. I'll go ahead and find that he is competent at this time.
Thank you, Judge.
All right, so do you want to put it on June?
That's fine. We can bring him in earlier if I can. Maybe we can do something where he auto-terminates.
Oh, yeah, I would be fine with that.
Okay, so Mr. Hinesley, we're going to see you back on June 23rd, but if they work out a deal earlier, they may ask you to come in earlier and get it done. Okay, June 23rd. All right.
All right, Mr. Hinesley.
Thank you, Mr. Hinesley.
Thank you.
Thank you, Judge. Judge, the next one that I have is William Jack Hinesley. Judge, when we were in court last time, Mr. Hinesley indicated that he had a witness he wanted me to speak to. He has since contacted my office and given me the contact information he has for that witness. That witness, as it turns out, is a former client of ours, and is the contact information he provided is the same information that we had. So I have reached out twice to try to speak to that witness, but have not received a call back. But we did not get that witness's information until this weekend, or until Friday.
What are you asking for?
Judge, it was set today, I believe, for plea or continuance. Well, actually, my notes just say
Trial or
defendant has new witnesses. So I'm going to go ahead and ask for a
How are there new
continuance.
witnesses in a case from November of '23?
Judge, we were all present in court when he came up and said that he had a witness. This is apparently concerning a statement of the alleged victim, and I don't know, without talking to that witness, when that statement was made. It may have been recently, it may have been some time ago.
You're asking for a continuance?
Yes, sir.
State.
I'm not going to object because I would like to know more about this witness as well.
I mean, just because I feel I have to at this point, but I'm not going to continue this again, Mr. Hinesley. If you have any other witnesses, you should be providing those to your lawyer who's been on your case for quite some time. June 23rd at 1 o'clock, last continuance.
Thank you, Judge. All righty. William Gerald Jackson. And this will be my last out of custody. Mr. Jackson was excused for today. He had indicated to me he was going to come in. I believe the state has an announcement.
Yes, Your Honor. The state is going to null pros 23 CF 2180 for insufficient evidence, Your Honor.
All right, Jackson's case is dismissed.
Thank you, Judge.
Everybody out of custody?
That's all that I have, Judge. Out of custody.
Yes, Your Honor.
Everyone here is family?
Judge, this is Mr. Norris's father.
I'm aware.
The other
I don't need y'all to point them all out, but. Whoever y'all want to call.
Judge, this is Wanda Carpenter. She has two cases on the docket, 24 CF 909, 24 CF 1124. This is the case that we have a competency evaluation pending, and we had some depots set for Friday. Some of those witnesses showed up. I'm showing it on page 24 of my docket. Okay. So at this time, we're going to ask for a continuance to get that evaluation and also finish the depositions.
Have y'all tracked down the other alleged victim? Wasn't there one was deceased or something like that?
One was deceased. The state is still trying to look into that. The other one was not at the address provided by the state. We got a return on that, and they're looking for him. And then a couple of the officers in one of the cases are no longer with OCSO, so the state's going to have to track them down.
Did you want to talk to your lawyer first before you ask me anything? Okay.
Don't talk about your cases.
Whenever I was told, when the psychological Miss Randy McDonald come and see me, I was called a bitch, excuse my language, and I was told not to testify.
Who said that?
Miss Randy McDonald did. And I did. She asked me when, and I did.
Hold on a second. Mr. Russell, do you know if she's met with Miss McDonald or Dr. McDonald?
I have not heard that yet, Judge.
I got up and walked out of the room on her.
Well, I'm going to wait to get her report then, because I want to see, I don't just take one person's side for things.
Right.
And I've known Dr. McDonald for quite some time, and that doesn't sound like something normal from her. So I'd like to hear her side of it. Okay. So we're going to have you come back on June 24th at 9 o'clock so that I can get those reports, and your attorney's still doing some depositions for you.
I have a question. If Villarreal's running because I was sexually assaulted that day.
Say again?
Villarreal's running because I was sexually assaulted that day. That needs to be brought up.
I don't understand what you're saying about someone running.
One of the alleged victims in the one case that was not at the address that we served, that's Mr. Villarreal that she's referring to.
Okay. I understand. I just couldn't, you were saying a name I didn't recognize, so I just didn't, I wasn't computing that. I'm sorry, but, all right, we'll see you back on June 24th, Ms. Carpenter, but your attorney's working on your case.
Okay.
Thank you.
Judges, this should be Jake Bell. Case numbers are 24 CF 2560 and 24 CF 2907. If I could just have a moment. Full name. And on Mr. Bell's cases, Judge, I have a plea agreement score sheet, if I may approach.
Yes, sir. So this calls for him to plead to 2 counts on 24 CF 2907, 11 months, 29 days. Just because it talks about ECLC, he's still getting the credit for everything, right? Has he already been in the program?
He has not, Judge, but he doesn't have any problem with doing it while he's in there.
Okay, I just want to make sure, because a lot of times we've been getting 1129 waiving credit so he can quote-unquote finish the program, but you're not asking for that here?
No,
That's
sir.
not the agreement, okay. So you'll get credit for all your time served, Mr. Bell. I'm just making sure it's a little bit differently how they've been doing it, so I wanted to make sure of that before we went through it together. All right, Mr. Bell, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I swear.
All right, can you state your full name and date of birth, please?
Jake Coleman Bell, January the 3rd, 1989.
All right, Mr. Bell, you're here on 24 CF 2560. In that case, you're charged with 1 count of burglary of an unoccupied structure, which is a 3rd-degree felony, punished by up to 5 years. And then you also have 24 CF 2907, where you have 6 counts of burglary of an unoccupied conveyance, a third-degree felony, each punished by up to 5 years in state prison. And then 7 through 9 is 3 counts of attempted burglary of an unoccupied conveyance, also third-degree felony, punished by up to 5 years in state prison. Do you understand all the current charges?
Yes, sir.
All right. In the plea and sentencing agreement I've been handed, it calls for the 2560 case to be dismissed, and also counts 3 through 9 of the 2907 case to be dismissed. So you'd just be pleading to 2 counts of burglary of an unoccupied conveyance. Is that your understanding?
Yes, sir.
And in return for that, it's an adjudication of guilt, 11 months, 29 days in county jail, credit for time served, ECLC, and your costs.
Yes, sir.
Is that what you want to do?
Yes, sir.
Did you go over this agreement with Mr. Russell?
Yes, sir.
Did you understand and sign it?
Yes, sir.
Are you satisfied with Mr. Russell, your attorney's representation and advice?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir.
Has anyone forced, pressured, or threatened you in order to enter the plea?
No, sir.
Has anyone promised you anything in return for entering the plea?
No, sir.
You understand that by pleading no contest, you'd be giving up your right to a trial, and there will be no trial.
Yes, sir.
Do you understand you're giving up all your trial rights, which are listed on page 2 of your agreement?
Yes, sir.
Do you understand that you're waiving all potential defenses that you may have?
Yes, sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, so in 24 CF 2907, what do you plead to the 2 counts of burglary of an unoccupied conveyance?
No contest.
I'll accept your no contest plea to those counts as freely, voluntarily, knowingly given. State have an announcement on the rest.
Yes, Your Honor. I just want to state for the record, the case in 24 CF 2560 and 24 CF 2907 were actually from the same incident. One was just filed later when more information came. So I just wanted to make sure that's on the record. But yes, the state will be null processing 24 CF 2560 and counts 3 through 9 of 24 CF 2907.
All right. All right, I've accepted your plea on counts 1 and 2 of 24 CF 2907, adjudication of guilt, 11 months, 29 days in Okaloosa County Jail. There'll be concurrent between those 2 counts, credit for all time served, comply with the ECLC program while you're in jail. Court costs will be $515 and a $150 PD fee. Those will go to judgment. And this is a guideline sentence pursuant to the guidelines that I've looked at where he does not score. All right, thank you, Mr. Bell. I need you to be fingerprinted before you leave, and you have 30 days to appeal.
Judge, this is Dwayne Bonnick. Case number for the record is 24 CF 2696. Judge, this was passed to today for the state to try to reach the alleged victims to see if they were amenable to our counteroffer. State was not able to reach them since our last court date. In talking over with the state, they said they might be able to reach them by this Friday. So can we pass this to Friday for plea or continuance to see what happens?
Is that accurate?
No objection, and that is accurate, Your Honor.
All right. May 9th at 9 o'clock to see if they can reach the victim in the meantime. We'll see you back on Friday, sir.
All right, thank you, Judge.
Thank you.
Judge, this is a Keem Callaway. Case number for the record is 23 CF 923. If I could just have a moment. Judge, we've reached a plea agreement with the state. It's going to involve them null processing the 1 felony, plead to the other misdemeanors for concurrent time, so there will not be a score sheet if I may approach.
Y'all had depots on Friday? Is that what it was?
We did.
Okay. All right, Mr. Callaway, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Out loud. All right, I can see you, but the microphone can't. So, all right, Mr. Callaway, you're here in 23 CF 923, where you're currently charged with possession of a controlled substance, third-degree felony, punishment up to 5 years in state prison, possession of paraphernalia, and resisting are each first-degree misdemeanors, punishment up to a year in county jail. Then you've got driving license suspended, failure to have insurance, and improper tag. Attaching improper tag. Those are all second-degree misdemeanors, punishable up to 60 days in county jail. Do you understand what the current charges are?
Yes, sir.
Okay. Now, I've been handed a plea and sentencing agreement that would have the state dismiss count 1, and then on counts 2 and 3, you'd have 180 days county jail with credit for all time served. And then on counts 4 through 6, it would be 30 days county jail concurrent. So you'd be doing 180 days jail, right?
Yes, sir.
Okay, is that the state's agreement? Okay. All right, Mr. Callaway, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir.
Did you understand it?
Yes, sir.
And did you sign it?
Yes, sir.
I think you did it right in front of me just now, right? All right, and did you, are you satisfied with the work of your attorney?
Yes, sir.
And are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
And are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
You understand by entering a plea, you'll be giving up your right to a trial and all the trial rights, which are on page 2 of the agreement that you signed.
Yes, sir.
And do you understand you're waiving all potential defenses that you may have?
Sir.
And do you understand that if you're not a U.S. citizen, this could lead to your deportation?
Yes, sir.
All right, and what is your plea to counts 2 through 6? That's all the misdemeanor counts.
No contest.
I'll accept your no contest plea as freely, voluntarily, knowingly given. State have an announcement on count 1.
Yes, Your Honor, the state will no pros count 1.
Okay. All right, and then on counts 2 and 3, it's an adjudication of guilt on all 2, 3, 4, 5, and 6. And 2 and 3, it's 180 days county jail, concurrent to each other and any other sentence that he's serving. Credit for time served. Standard court costs are on misdemeanors. Is it going to be 270? 300 total because of the driving. $100 PD fee, all money to judgment. On 4 through 6 will be again adjudication of guilt, 30 days county jail, concurrent, and credit for all time served. All right, I will need your fingerprints, Mr. Callaway, because you have at least one charge that is enhanceable, and then you have 30 days to appeal. Thank you, Mr. Callaway.
And Judge, for the record, all sentences are concurrent to each other and to any other sentence he's serving?
I think I said that one time under a couple of counts, but not under all of them, so I appreciate you bringing that up, Mr. Russell, that all counts are concurrent with each other and any other sentence that you're serving. All right, step up and be fingerprinted.
Judge, this is Jonathan Murphy. Case number is 24 CF 2181, if I may have a moment. Judge, on Mr. Murphy's case, we've reached a plea agreement, and I have a score sheet. One note for the court, we had originally 18 months Department of Correction. We've since changed that to 21.68 months in Department of Corrections. That's because that's what he scores. And then I've had both Mr. Murphy, the state, and I have initialed where I've made that one change.
Bring it up, Mr. Russell. Is the score sheet in there too?
Yes, sir.
All right. I have 21.675.
Rounded up.
Rounded up. Well, all right, Mr. Murphy, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
Jonathan Joshua Murphy, 22491.
All right, Mr. Murphy, you're here in 24 CF 2181, charged with aggravated assault with a deadly weapon, which is a third-degree felony punished by up to 5 years in state prison, as well as felony battery, which is a third-degree felony as well. I've been handed a plea and sentencing agreement that has you pleading to both of those counts. Adjudication of guilt, 21.68 months, Department of Corrections. Credit for all time served. Court costs be $515. Oh, because of the battery. $867 in court costs and a $150 PD fee, which will go to judgment. Is that what you want to do here today?
Yes, sir.
Is it the state's agreement?
Yes, Your Honor, it is.
Okay. And it is a guideline sentence from what I've just looked at. Mr. Murphy, did you go over this plea and sentencing agreement with your lawyer?
Yes, sir, I did. I mean, if I can speak?
Sure.
I had an offer Wednesday, and the state attorney sat over there and told me that they'd sign me 1129 with credit for time served on the ECL, to attend the rest of the time with the ECLC program. That was the only issue we had right here. And they said that they couldn't do credit for time served now. I said I'd sign it, but he said he had to go over my mental health report from the report Mr. Williams had filed for that you issued for me to have a doctor come see me at the jail. I've been sitting up there almost 8 months now. I want to take the 1129 with the ECLC program, but they said they're not going to give me my credit for time served. I've been sitting in that jail up there for almost 8 months now. I received these charges because I was detoxed on psychiatric medication, and me and my mother got into a verbal and a physical altercation. Well, really, me and my little brother and my mother split us up, and that's what I ended up getting arrested for. Should be found for momentary insanity is what I should be, and I should be getting released.
All right, so that I'm not going to accept your plea today. Is that what?
I mean, you said you asked me the question. I mean, I'm pleading out the thing, but they were supposed to be sentencing me to 1129 with credit for time served to the ECLC program, and they said they can't do it now. Why, I don't know. I mean, if that's what the woman stood up the other day and offered me. I said I would sign it, and now that's what they said. I told them to give me my guideline sentence then.
That offer was never on the table. There was a 1129 with ECLC waiving all the credit like we do in other cases, but not credit for time served.
My little sister was watching the thing. I had called her to make sure of it. Ma'am, she's got the reporting at the house. But
Well,
that's
you have
fine.
to understand, Mr. Murphy, they could have offered that, and it'd be clear as day. They could admit they offered that, but until it's accepted
Till
by
I
the
understand that. I was just
Mr.
making.
Murphy, did I interrupt you?
Oh, no, sir, no, sir.
We have to talk one person at a time, so if you talk.
I apologize.
Just wait till I'm done talking, and then, just like I did. In fact, I had almost interrupted you, and I stopped talking because I didn't realize you were
apologize.
finished.
You're correct, sir.
We just have to make a clear record. Everything is recorded, so if we talk at the same time, it makes a very messy record, so that's why we just have to do it one at a time.
Yes, sir.
But plea offers are revocable at any time.
I understand that. I mean, I stood right here and said, this man said he's going to go over my report. Like I said, they all haven't even issued, I have a mental health report by the doctor that you issued to be done that hasn't even been vocalized in the court as well.
Is there a mental health report?
Judge, what he's referring to is we had an internal report that we asked for, and we have not filed it because it was going to be a mitigation report and/or a competency. Dr. Zeman found him competent, but because there's a negotiated plea, we didn't file it.
Do you understand that now, Mr. Murphy?
Yes, sir. I was found competent. That's what Mr. Williams, the first original public defender I had, was looking for it because he was going to trying to get me time served, referred out to Bridgeway, because my mom she went to the state attorney and filled out a thing saying she wanted me sentenced to Keaton, I believe, with the 6 months probation followed behind it, and the state attorney said they couldn't originally do that. That's why yourself issued the competency exam for the in-house evaluation for Mr. Zeman.
No, if it's in the house, I have nothing to do with that, Mr. Murphy.
I mean, you issued for it to be done in the jail, is what I mean. When I said that's what you called it, was the in-house evaluation from Mr. Williams, is the one who filed for it.
If they do it in-house,
Yes, sir.
There's no motion, there's no order. The court has nothing to do with that. That's why it's called in-house. So I haven't seen that report. I had nothing to do with ordering that report.
You are the judge that ordered it, sir. I've been sitting in jail.
It wasn't ordered by any judge. It was something that your attorneys did to see
Oh,
if
that's
you
what I
were.
said, Mr. Williams. That's what I said, Mr. Williams asked you to have it
Mr.
done.
Murphy, I'm trying to explain something to you, and you just keep talking over me. How am I supposed to explain it if you won't let me tell
Okay,
you?
I mean, I understand, that's fine. I understand it. That's why I'm.
I don't think you understand what's going on here today, so maybe there needs to be a further report.
Well, no, it's not the thing. I mean, you asked him, I was just making it clear. The Mr. Williams asked you for me to do because of my medical history over the past year. I was detoxing off psychiatric medication 5 times in that jail up there. I've been there for 8 months, right? When I detoxed off of it, I had an issue when I wasn't able to obtain a prescription. I received the charges I did. Mr. Williams asked for the doctor for you to give me a continuance.
Mr. Murphy, again, I didn't have anything to do with that.
The doctor come to see me under due to your judge's order, and it's right
No.
there. The man's got the report right there.
That's not accurate.
Don't you have the report, sir?
It was done. It wasn't done at my order.
It's right here.
Read this.
By the public defender, Landon Maddox.
Correct.
Yes, sir.
Not the judge.
Well,
We did it.
Okay, I understand that. The public defender's office has to issue.
See, here's the thing, Mr. Murphy. If they ask me for an order to do it, then everyone gets to see it.
I understand that.
What they did is they did it in-house without asking me, without, any input from the state attorney. And so that way they can keep it confidential.
Yeah, well, I mean, I should have been applied for the downward departure, like you said. The woman said the other day that she was going to sentence me to 1129 credit for time served.
Okay, the state attorney doesn't sentence you, the court does.
He spoke up in the middle of our court
All
proceeding.
right, Mr. Murphy, I'm going to pass you until you can.
Okay, that's fine. I mean, that's fine. I'm just making sure this is clear on record, right? Because one thing that she stated it on the record that she was going to say, and I said that's fine. I would sign out to it.
Let me talk to you in the back.
Okay.
I'm going to let you talk to your attorney. Mr. Murphy, you have to understand what people are trying to explain to you, and you're just talking over everybody and not listening to what's being explained. All right. All right. Mr. Williams, Mr. Maddox. Who's that under?
It's my case and it's Mr. Williams.
All right. Mr. And I had previously gone over with you your rights when we were looking at the 36 months.
Yes, sir.
So that hasn't changed. That's the same.
It's the help that I wanted.
Yes, sir. Yes, sir. And we're getting that for you, but we're getting it for you in a way that you don't have to spend 3 years in prison to get it. Okay?
Thank you.
All right, let me get your signature right there. Yes, sir, I understand. One of these days, maybe they'll give us a podium we can raise and lower. So I'm going to go ahead and date this for you, if that's okay.
Thank you.
No problem.
Mr. Williams, restitution, $200 to Mr. Michael Wright, W-R-I-G-H-T.
Okay. And it's 200?
Yes. Obviously, he can pay it once he's out of jail. He doesn't have means to pay sooner.
Do you understand that, sir?
It'd be after I get out.
Yes, sir, it'll be after you get out.
You have the score sheet or no?
I do, but it doesn't have the right date on it. I'll have to dig it out and pull that out of the file.
I have it.
So this is kind of like we talked about earlier, ECLC for the 1129, but waiving any credit, so he's there for the year.
Yes, sir. The alternative was 3 years DOC.
I'm looking at the score sheet where he scored 44.7 months. So this is a downward departure.
Yes, sir.
And I think it was mentioned, but just to make sure, the state has talked to the victim in the case.
Mr. Wright is present in court, Your Honor. Yes, I have.
Okay,
And he
and
confirms
he-
that it's okay.
Okay, and he said he's
Yes.
given you his input.
Yes, yes, Your
Okay.
Honor, yes.
All right, Mr. Cooper, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, make sure you speak into that microphone, Mr. Cooper. Can you state your full name and date of birth
Rady Cooper,
and date of birth?
3/24/84.
All right, Mr. Cooper, you're here in 24 CF 1832, charged with grand theft, third-degree felony, punishable up to 5 years in state prison. Also, 24 CF, it's the same number twice up here. 2513, and that's one count grand theft of over $20,000, is that right?
Yes, Your Honor.
Okay. The second-degree felony, punishable up to 15 years in state prison, possession of burglary tools, third-degree felony, 5 years state prison max, and criminal mischief. First-degree misdemeanor, punishable by up to a year in county jail. Do you understand the current charges, Mr. Cooper?
Yes, sir.
And I've been handed a plea and sentencing agreement between you and the state that calls for you to plead as charged, be adjudicated guilty, which means felony convictions on the 3 felony charges, 11 months, 29 days in county jail, waive any credit that you have for time served. You're going to do the comply with the ECLC program as a special, well, not really a special condition of jail, but then you've got some costs, and the restitution is how much?
$200.
$200. So were the things returned? I mean, you got grand theft over 20,000 and restitution for
There's
200.
some damage to the property that he caused. The property was retrieved by the
Okay,
owner.
I just want to make sure that I'm clear on that because
I think the
I'm reading
200
Mr.
on the
Williams'
criminal
writing here.
mischief.
So I just wanna
Yes,
make
sir.
sure. All right, so $200 restitution to Michael Wright. All right. And Mr. Wright's here. Mr. Wright, do we know each other in any way? Okay, your name sounds familiar, but you're pretty far away. You didn't look familiar, but I just always want to make sure if there's a possibility that I've asked that question. All right, Mr. Cooper, is that the agreement that you want to take?
Yes, Your Honor.
Okay, and have you gone over this plea and sentencing agreement with your lawyer?
Yes, Your Honor.
Did you understand and sign it?
Yes, Your Honor.
And are you satisfied with your lawyer's advice and representation?
Yes, Your Honor.
All right. Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, Your Honor.
Has anyone forced, pressured, or threatened you in any way to take this plea?
No, Your Honor.
Has anyone promised you anything in return for your plea?
No, Your Honor.
You understand by entering a plea, you're giving up your right to a trial and all the trial rights, which are on page 2 of the agreement that you signed.
Yes, Your Honor.
And do you understand you're waiving all potential defenses to those cases? And do you understand that if you're not a U.S. citizen, you could be deported because of this?
Yes, Your Honor.
All right, and what is your plea to each of the counts?
No contest.
I'll accept your no contest plea and 24 CF 1832 to the grand theft, third-degree felony, and 24 CF 2513. I'll accept your no contest plea to the grand theft, second-degree felony, possession of burglary tools, third-degree felony, criminal mischief, first-degree misdemeanor. In each of those counts, adjudication of guilt, 11 months, 29 days in county jail, waive any credit that you have for time served. You're going to comply with the ECLC program, $515 in court costs, $150 PD fee, and $200 in restitution to Mr. Wright. That's an adjudication of guilt. And this is a downward departure based on an uncoerced plea bargain, correct?
Yes, sir.
Okay. All right, so Mr. Cooper, I'm going to need your fingerprints, then you have 30 days to appeal.
All right, sir. Good luck to you, okay? Judge, after consultation with Mr. Norris, reviewing the court's order that was published, I believe, Friday afternoon.
And again, I apologize for taking a little longer than I expected to get that done, but
Yes, sir, and speaking with a couple of other lawyers that have done these, I'm not prepared to waive Mr. Norris's right for appellate review of the court's order, so I'm going to be seeking a writ of prohibition. Although the rule doesn't specify an amount of time under the Snow case, it is a somewhat limited amount of time. I think in Snow it was 6 weeks. I anticipate being able to get the writ done, depending on the trial docket, between 2 and 4 weeks. Basically, the writ is, my initial brief contains the record. So there's a bit of coordination work that has to be done. I believe that the transcript that was already prepared will serve as an official transcript, and so that will save us some time. But I anticipate getting the writ filed between 2 and 4 weeks. My understanding is that the state's going to ask for a date certain on that.
date certain on the filing of it?
That's what she indicated to me, Judge. It seems a little loose considering we don't have a rule that states a specific date that it has to be filed by. But again, if you look at the Snow case, a friend of mine was the attorney on that.
Do you have a cite on the Snow case?
I do, Judge.
I may have read it before, I just don't recall it off the top of my head.
It was Jason Comer's case over in
Pensacola?
Pensacola, yes, sir. Tell you what, actually, I can bring it up on my computer.
And Your Honor, just to clarify the record, I believe Mr. Williams is asking for a continuance based on his need to file the writ of prohibition rather than staying the proceedings pending filing a writ of prohibition. I know that seems like semantics, but for appellate purposes, I think it has.
I think I found the case.
All right, Judge.
Snow versus State, which is 352 Southern 3rd 529. First DCA case. Talks about the delay. I'm not familiar with the case off the top of my head, but I mean, obviously I can't give any advice on how long you have to file that, Mr. Williams, but you've read the case, I haven't.
Yes, sir. In Snow, my recollection was about 6 weeks, and first DCA found that was too long. But a regular appeal would be 30 days, so I think somewhere shy of that, I should be fine.
You're asking for a continuance to pursue?
Yes,
that?
sir.
All right, Mr. Norris, is that what you want to do?
Yes, sir.
And that would be over the state's objection.
I think I have to give it to him for that particular purpose. I mean, this case is very long in the tooth, and I think I brought it up before, that this incident happened the day after I took the bench, and that's almost 4 years ago. So I'd like to get it resolved, but obviously, you have a right to take your writ up, Mr. Norris, and so I'll give you the time to do that. As far as, do you have any sort of practical experience with it, Mr. Williams, as to how long that it may take at the DCA level?
Judge, I would imagine that it would go a lot faster than a regular appeal.
I would hope so.
But I don't have any specific.
A writ of prohibition is considered an emergency writ. That's basically saying I've done something outside of my jurisdiction. And there was the case that came out last week. I'm not sure if Ms. Sandler, if you had it, we were talking about it the day it came out or the day after it came out.
Rollerson.
Kind of Rollerson, if you've seen it, there's a very lengthy concurring opinion that talks about writs of prohibition in this kind of case. To be honest, I don't think I ever picked it back up. I told you I was about halfway or a little more than halfway reading the concurrence, and then I got into court, and I've been, frankly, writing this order ever since, so finishing it up on Friday. So
I did do it, and I think it tracks along with Snow, but I think that it's very much contrary to opinions from other districts that basically say that the preferred way of resolving issues at the stand your ground motion is through a writ of prohibition. There's some discussion about seeking writs of certiorari on it, but that would be an unusual circumstance that you'd go that route.
Your Honor, just for the record, my understanding of the case is that the writ of prohibition is still the only mechanism, seeing as how when they revised the rule for the civil immunity, they specifically didn't say anything about the criminal immunity. So even though the case highly disfavors the writ of prohibition as the tool, it's still the only toolbox right now. So I think that's where the case stands.
well, I think we've talked about it a lot in this case. Obviously, y'all are saying I did something incorrectly, so I can't say I think you should do this or I think you should do that. That's not for me, obviously. That's an appellate issue, but this is the stand your ground in general is a relatively new issue that we're dealing with, and the few opinions that we do have that really kind of flesh out these issues, they don't always agree with each other.
Yes, sir.
As I spelled out in the beginning of my order, talking about the difference between Freeman here in the first and how the hearing's supposed to be conducted, where everyone else does it differently. And it's strange, sometimes we have cases, I think the first DCA just did it in there's a case about the attempted sexual battery issue, how they overturned 20 years of precedent in their own court, and then everyone else has relied on that case in the other districts. So
yes, sir.
It's these things are fluid. That's how the law is supposed to be. So
Just for Mr. Williams and Your Honor, the state's filed a couple of writ of prohibitions in the past, and we received DCA just a couple of days.
Couple of days.
When there was no show cause order issued.
See what happens.
All right, Judge.
All right, so the case will be continued. Obviously, I should get something from the DCA once it gets filed. Every once in a while, an appeal goes through, and I don't even know what happens, and then I get something from the DCA say, hey, you were supposed to respond yourself to me, to the court, and I never even received it. So I guess just kind of keep us all in the loop.
Yes, sir.
If there is a resolution, if there's something that I need to do, because every once in a while, it just, again, I don't trust these portals and things like that where things get filed, because it's looked like I haven't responded to the DCA sometimes, but I never knew about it.
What I can do is send you a courtesy copy.
Sometimes it comes up, especially if it's an appeal of another judge and I've taken over the division, it'll go back to that judge and no one ever tells me about it. It shouldn't be a problem like that. But if there is anything that comes through, let's make sure we all talk about it.
Yes, sir.
So we can get it done fast, because again, I want this case to come to some sort of resolution sooner than later, because it's quite old. All right, so we'll put Mr. Norris on the June 24th date at 9 o'clock. That's our next in-custody pretrial. And obviously, if anything else comes up we have to do sooner, we can certainly get another date for that.
Yes, sir.
Thank you, Your
All right, Ronnie. Put over that.
And that concludes my business with the court. May I be excused?
Yes, thank you, Ms. Sandler. Ms. Sandler, I would never object if you've got one case, if you want to ask the defense lawyer if they can call it up quicker.
We normally do on Mr. Norris's. I don't know why that didn't happen this time.
I let y'all call the cases, so I don't know what's happening with them until y'all tell me. So
on the jail folks,
I don't want to
take
say,
whoever he says
why aren't
he's
you
got
guys
ready.
calling Mr. Norris? Because that's probably Ms. Sandler's only case, and we should just go ahead and resolve that, because maybe there's some bigger issue you guys want to be at the end and you wanted to talk about.
Yes, sir.
So I try not to push those things, but I'm always willing to ask if someone only has one case, we can call those quickly.
I appreciate it, Your Honor. Today, I wanted to wait because I figured we'd talk for a minute.
Yeah, that's fine. I appreciate it. Thank you, Ms. Sandler. Thank you, Mr. Norris and Mr. Williams.
All right. Okay.
What's that?
Judge, we're still kind of going back and forth.
who is this?
Oh, this is Christopher Arnett, Judge. He's going to be 54 on your docket, I believe.
Go ahead. Go ahead, Mr. Williams.
All right, thank you, Judge. Judge, this is the one that we were talking about checking fingerprints to prove up a intervening prior that, if it is his, would keep his prior record.
On the score sheet.
On the score sheet, yes, sir. I don't know whether the state's got anything back on it. As an aside, I spoke with one of the witnesses in about the grand theft of a firearm case over the course of the weekend, just on the phone. And I'm not sure whether it's really a notice of alibi situation, but I don't think that would be the one that, if we do go to trial, that would be the one that we'd all be ready on. The remaining issue really is just the score sheet at this point.
You say go to trial, do you mean this time?
Well, Judge, when I
didn't
looked at
have it
the
as a
clerk's
trial.
notes, and what I have is a great big question mark for how set, because it usually tells me, and instead it just had today's date. So I'm good with continuing the cases until we get that issue with the score sheet resolved. But
I think what I'm going to do is really get people to announce, is this a plea? Is it a trial? Is it a continuance? Is it a plea trial? Is it a plea continuance?
Yes.
That way we just know for sure, because I think I asked specifically on this one, and you said put it for call, and I put call in quotation marks because that was the word that you said.
Well,
And here's the thing, and I know you've practiced in other counties and other areas, even next door counties that are part of the same circuit, people use terms very differently. As someone who's practiced across not only the circuit but the state when I was a lawyer, and then I've been on the bench in 3 different counties, between what we call pre-trials and docket days and mini docket days and jury reviews and call, and I just want to make sure we're all on the same page going forward. So,
And Judge, if I say for call, I'm not intending it to go to trial.
that's what my understanding of the way you used it, Mr.
I just, looking at the clerk's notes, they do the memo. It didn't say anything one way or the other, and a week or 3 days later, that becomes my Bible because I don't remember what I said. And so I look there to see what the clerk says I said.
That's why I keep all the dockets and I put my notes on them every single time.
Yes, sir.
And every once in a while I'll miss one, and I'll go back and, I've got the advantage. I can go back and listen to Court Smart anytime I want, and I do it pretty frequently. Just to make, I don't remember what we're supposed to do on this case.
Your Honor, there was the issue about the
score
prior
sheet.
record. The point I want to make is that I am not offering a guideline sentence. I'm offering 24 months DOC, independently from what he scores.
Okay, what does he score according to your score sheet?
However, he's charged with possession of firearm by convicted felon. It's actual possession. He's facing a 3-year minimum if we go to trial.
Okay,
The defendant admitted to possessing the firearm.
okay.
And it was a search due to probation, so it was a valid search. Probation went there, searched the property, and then he admitted that he was fixing this gun for a person. He was going to get $350 for it. So the point I'm going to make is that The last offer that I made, I'll keep it over until Friday if he wants to consider to take it. Otherwise, I will revoke it and then we can set that case for trial.
Okay.
Judge, my recollection is that the charging document does not contain the two key words that you're looking for on a mandatory minimum. In terms of the score sheet and that this is a downward departure, Mr. Arnett's position is that it's not a downward departure because the score sheet's incorrect and that he would not score so high. I'm fine with leaving it on for Friday and going out and talking with him again. But where we are is just where we are. You know, if he objects to the score sheet, I've got to make that known.
But I want to make sure it's clear, I'm not offering a guideline sentence, I'm offering 24 months.
Again, I don't know what the score sheet says. I don't have access to those. So I'll let y'all work out what you're going to work out, or we'll set them for trial for the next time around. But do y'all want to keep it on for Friday, or just?
Judge, that's fine with me. I mean, I want to keep these cases moving as well. And if talking with her some more and going out to the jail and seeing him again will get it resolved one way or the other, I'm fine with that. I'm going to be at the jail anyway.
What can be figured out between now and Friday?
I don't know, maybe she can get Tom to check the fingerprints and see if that prior that she's relying on is his. I understand her position, but see, if the score sheet is a lot less, that opens up the possibility of a plea straight up to the court, and I need to go over that with him as well as being a possibility. Your Honor's kind of a stickler on proving the reasons for downward departure, and so I don't necessarily recommend that to people.
I'm not
unless
sure
that's where
anyone's
they
tried
are.
to prove a reason for downward departure. They've all been uncoerced plea bargains for the most part. I think today was actually the first time in the probably hundreds of pleas I've taken since I took over the division 4 or 5 months ago that there was a reason for a downward departure that wasn't uncoerced plea bargain, and that was the need for treatment in a case we talked about today. Otherwise, every single one has been, so I haven't been a stickler about that.
Well, we'd had an original meeting where, the court established its, what it expected of us.
Well, but I'm not doing anything that's not.
No, you're following the law. I'm not
following
saying.
the law. The law is you
You're
have to
following
prove
the law.
that there's one of the factors is in play, and then two, if you've proven that it's in play, should I give it to them?
Yes, sir. Yes, sir.
So that's just what the law is. So.
I'm not complaining,
Okay.
but I have to advise him accurately.
Okay.
Yes, sir. All right, so 5-9.
You can advise your client that I follow the law.
Yes, sir. Let's not ask me specifics on who and where I might not have advised that.
All right, so do you want to try and come back Friday?
I'm fine with that.
All right, let's
I'll
come
be
back
here.
Friday, May 9th. Oops. See if y'all can figure anything else out.
Yes, sir.
On the score sheet.
All right, Mr. Arnett, if we get any movement, I'll come out and see you again, okay?
Okay, just real quick.
Ma'am,
Charge
would you
verified.
tell me, he's concerned that it went from 17 to 24 and that, quote, nothing had changed. Was there another score sheet run? Were there additional charges? Was there something that changed on the score sheet, assuming that, I believe you had the case from the beginning?
I had. But I would have to go through my notes, I don't recall that.
If you could and let me know, I'll pass it along to him when I go out to see him.
Is he saying that he would take that? The
No,
17
he's
months?
just got a question.
So I'm not gonna, no, we can talk about it on Friday, I don't have.
All right, he just advised me he would take the 17 months.
Then I'll offer the 17 months if he takes it right now.
All right, do you want to take the 17 months right now?
Yeah.
Okay.
That's fine.
Let me make the change on the plea agreement. Judge, looks like we may have a negotiated plea.
You accept a downward departure?
Only if you prove it. I'm not sure.
For the sake of, what was he contesting over here in the course? The two
Well, here's
manslaughter,
the-
he said the guy won?
Yeah, here's the thing, he was contesting that, but he was also saying that the manslaughter was his last conviction, and that was 11 years ago.
Oh.
And so. Actually, all of those are wrong. He's saying the others are all wrong as well, but I haven't gone
Except-
through CCIS on them as yet.
Except for the violation of the injunction.
The point I'm making, I can take him off. He's still gonna plead to 17 months.
Okay.
That's gonna be my
I'm gonna-
position.
I'm going to suggest that, just to keep the record clear. You understand that she can offer you more than the guidelines, right? Okay.
And
that's what,
yes, I
that's what
understand
she's doing. She's going to take those off the score sheet, just so that the score sheet is clear and the record is clear, okay? All right. All right, Mr. Arnett, I've made the change to 17 months. Is this what you want to do?
Yes, sir.
Okay. Let me get your signature here, and have we previously gone over what your rights are and things like that?
Yes, sir.
Okay. All right. Do you mind if I date this for you?
No, sir.
Mr. Williams is a stickler for having the date on there.
I noticed that, Judge.
Took it off, all the prior records.
Okay. All right, and.
Thank you, Mr. Williams. Appreciate it. So basically, you just struck his entire prior history off
Yes,
the
Your
sheet
Honor.
because of the concerns about whether or not there was something in the past 10 years.
That's correct. I
Okay.
just conceded for the sake of the plea.
Okay. I just want to make sure that it's clear, so this is not a downward departure.
Yes, sir. No.
All right. Mr. Arnett, can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do.
All right. Can you state your full name and date of birth, please?
Christopher Lynn Arnett, 6/13/71.
Okay, Mr. Arnett, you're here in 24 CF 977, charged with possession of a firearm by a convicted felon, which is a second-degree felony, punished by up to 5 years in state prison. So is there an agreement that it's constructive
Constructive
possession? 24 CF 1243 is a grand theft of a firearm, third-degree felony, punished by up to 5 years in state prison. Is that a different firearm?
It is, Judge. In fact, I think that one happened some time ago. That's Stacy's ex-husband. You've got it in the reports. His
Yeah.
boyfriend. He's
I'm just-
actually the ex-husband.
All right, and do you understand those charges, Mr. Arnett?
Yes, sir.
Okay, and I've been handed a plea and sentencing agreement that has you pleading as charged. Adjudication of guilt, 17 months in the Department of Corrections with credit for time served, 515 court costs, $150 PD fee, and run concurrent. Is that what you want to do today?
Yes, sir.
Did you go over this plea agreement with your attorney?
Yes, sir, I did.
Did you understand and sign it?
Yes, sir.
Did he date it for you?
Yes, sir, he did.
Are you satisfied with his representation and advice?
Absolutely.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressured, or threatened you in any way to enter this plea?
No, sir.
Has anyone promised you anything in return for your plea?
Sir.
Do you understand by entering a plea, there won't be a trial of any kind, and you're giving up your trial rights, which are on page 1 and continuing on to page 2 of the agreement that you signed?
Sir.
And do you understand that you're waiving any potential defenses that you may have? And you understand this is an adjudication of guilt, so you'll be convicted felon for these charges?
I do.
Okay. And do you understand that if you're not a U.S. citizen, that you could be deported because of this?
Yes, sir.
All right. And what is your plea to the possession of the firearm, constructive possession, and the grand theft of a firearm?
No contest.
All right. I'm going to accept your no contest plea is freely, voluntarily, knowingly given. Adjudicate you guilty, sentence you to 17 months in the Department of Corrections with credit for time served, $515 in court costs, $100 PD fee. Those will be sent to judgment since you're doing a DOC sentence. Those are concurrent between the two cases. This is a guideline sentence due to the state conceding for purposes of the plea that there may have been issues with his prior record for purposes of scoring. But it's 17 months. And Mr. Arnett, you have 30 days to appeal the judgment and sentence of the court, and I need your fingerprints before you leave.
Yes, sir.
All right, thank you, sir.
Thank you, Judge. Okay, good luck to you. Judge, this was past plea or continuance for the state to discuss the officer with the victim. My last communication with the state was that they had not gotten a call back from the victim.
That's
I'm
correct.
sorry, this is who again?
Chad Brown, Judge, I think he's 55 on your docket.
No, yes, I tried to contact Mr. Weber, and over the weekend, he hasn't responded to me yet. I would ask, please, to keep it for Friday, so hoping that I can get to talk to him and see if he agrees to the counteroffer defendant made.
Judge, I'm going to be here anyway, so.
All right. So we'll see you back, Mr. Brown, on Friday, May 9th at 9 o'clock. See if they can get that phone call returned, and then see if there's a counteroffer. Is that what you said, Mr. Williams?
That's correct, Judge, and if I hear a response, I'll come out and see you, okay?
Can we bring you here real quick?
Yeah, real quick.
Mr. Douglas.
I'll give you the score sheet for Mr. Douglas.
Okay. Judge, this is a negotiated plea on Mr. Douglas. Okay, no, that's just where I had it.
All right, Mr. Douglas, can you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Sir, I do.
This is going to be a downward departure as well.
I believe it is, Your Honor, yes.
Of course, 26 months, and this is 1129.
Yes.
Okay.
That would be for the need of treatment.
Okay. All right, Mr. Douglas, can you state your full name and date of birth, please?
My name is Joshua Adam Douglas. I was born 12/26/1984.
Mr. Douglas, you're here in 24 CF 1226, currently charged with trafficking methamphetamine, which is a first-degree felony punishable up to 30 years in state prison.
Yes, sir.
Possession of controlled substance, third-degree felony punishable up to 5 years in state prison. Driver license suspended for habitual traffic offender, which is a second-degree misdemeanor, punished by 60 days jail. Possession of paraphernalia, first-degree misdemeanor, punishable by a year in county jail. And then you also have 24 CF 1678, where you have a fleeing to elude. Third-degree felony, possession of controlled substance, third-degree felony. Driver while license suspended again, second-degree misdemeanor, and resisting without violence, first-degree misdemeanor. Do you understand your current charges?
Yes, sir.
All right. I've been handed a plea and sentencing agreement that calls for you to plead in the 1226 case on count 1 to a lesser included offense of sale, manufacture, or deliver, or possession with intent, which is a second-degree felony, punishable up to 15 years in state prison. But all other cases would be pled as charged. Is that your understanding?
Yes, sir.
All right. And then it calls for 11 months, 29 days county jail on the felonies, followed by 2 years of community control. You're going to have to do the ECLC program while in jail and follow-up. In the misdemeanor counts will be time served. In the 1226 case, it'll be 615 court costs plus 150 PD fee, and 1678 court costs on 1678? 548. And then I think it'd just be $100 PD fee and not 150 because you already paid the application on the other one.
Yes.
All right, and then you'd be adjudicated guilty of each count. Is that your understanding, Mr. Douglas?
Yes, sir.
Did you go over this plea and sentencing agreement with your attorney?
Yes, sir, I did.
Is this what you want to do today?
Yes, sir.
All right, did you read and understand it?
Yes, sir.
And are you satisfied with your attorney's advice and representation?
Yes, sir, most definitely.
Do you need a second?
Did you have a question?
We have to tell you where all the maximums are so you understand, kind of what you're facing. Because in the felony counts, Mr. Douglas, you're going on community control once you get out of jail. So if you were to violate that community control, you can get up to those maximums. Do you understand that?
Yes, sir.
All right. All right, and are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues?
No, sir.
Has anyone forced, pressure, or threatened you in any way?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand by entering a plea, you'll be giving up your right to a trial, and your trial rights which are on page 2 of the agreement that you signed?
Yes, sir.
Do you understand that you're waiving all potential defenses that you may have?
Yes, sir.
Do you understand that if you are not a U.S. citizen, you could be deported because of this?
Yes, sir.
And what is your plea to the lesser included offense of sale, manufacture, deliver?
Sir.
Okay, and is the rest of them as charged? What is your plea?
No contest, sir.
All right, I'm going to accept your no contest plea as stated. In each of the felony cases, it's going to be 11 months, 29 days county jail, waive any credit for time served so you can do the ECLC program.
Sure.
And that will be followed by 2 years of community control. In misdemeanor cases, it's going to be time served. As far as costs in 1226, it's going to be $615 plus the $150 PD fee, and 1678 it's going to be $548 plus a $100 PD fee. I'm going to waive the cost of supervision on the community control once you're released. Adjudicate you guilty on all cases, all counts, as I've stated previously, I think. Anything that I've missed? This is a downward departure based on the need for treatment.
Yes, Your Honor.
It was also an uncoerced plea bargain. County jail, 729. All right, Mr. Douglas, you're going to have to talk to probation. It's going to be a little bit of time before you end up talking to them and being supervised by them, but they're going to want to talk to you before you leave today. You
Yes,
also
sir.
need to be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court.
Yes, yes, sir. I just wanted to thank you, Your Honor, and thank Ms. Leone for this. And I'll do right by it, sir. Thank you so much.
Well, we wish you good luck.
Thank you, Mr.
You're welcome.
The
You're
ECLC
welcome.
program's
Good luck.
done really well for people, so make sure that you pay attention to it and live it. So, thank you.
Madam Clerk, just so I can write it in, I kept getting two different answers on the court costs on a aggravated assault with a deadly weapon. Is that 967 or 867? Thank you. All right, you understand that?
Yes, sir.
Okay.
I gave you the score sheet, Mr. Williams?
You already did?
I did, okay.
is a guideline sentence. All right, Mr. Durden, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right, can you state your full name and date of birth, please?
R.J. Durden Jr., 12/25/1991.
Okay. Mr. Durden, you're currently here in 22 CF 178, which is a violation of probation, 22 CF 2587. Is that a new charge? That's the new case, 22 CF 2587? That's not a VOP?
No, he has one VOP and two new
The other two
law.
are new. I just want to make sure, because again, when the docket comes out for docket day, it doesn't indicate if it's a VOP
Yes,
or not,
yes.
so I just wanted to make sure, because it's an older case.
And Judge, I may have messed up on the plea agreement, which one I thought was the VOP.
I think the VOP,
If I may, Your Honor.
go ahead.
The VOP is 22 CF 178.
Okay, so you got it right, Mr. Williams.
Okay.
All right. All right, so in 22 CF 2587, that's the charge of aggravated assault with a deadly weapon without intent to kill. Count 2 is discharge of a firearm. Count 3 is possession of a firearm by a convicted felon. And then I'm assuming that's going to be constructive then?
Yes, Your Honor.
24 CF 2762, you're charged with witness tampering and domestic violence battery. Do you understand all those charges?
Sir.
You can put your hand down, Mr. Durden. All right, did you go over this plea and sentencing agreement with your lawyer? Is this what you want to do today?
Sir.
And calls for 34 months DOC? All right, did you go over the agreement and understand it and sign it? You didn't sign it. And neither did the state, oh.
Yes, sir, I did.
Neither did Mr. Williams. It's okay.
I went over it with him this got finalized this morning, and I saw him in the conference room about it.
I'm a stickler for the pleas being signed.
As well I can understand, and Ms. Leone, I think, signed it where I'm supposed to sign it, but I'll sign above her. There you go, sir. They don't print out consistently over time.
Thank you, sir. Oh. All right. Now have you signed it, Mr. Durden? Okay. You military?
Sir.
Say again?
Yes, sir.
Okay, it says you signed at 4-5 instead of 5-4. Sometimes military goes the other way, so. All right, Mr. Durden, are you satisfied with your attorney's advice and representation?
Sir.
Are you under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to take this plea?
Sir.
Has anyone promised you anything in return for the plea?
Sir.
No. All right, do you understand that if, in the VOP, if you admit your violation of probation, there won't be an evidentiary hearing where the state would have to prove how you violated your probation? And in the two other cases, do you understand that if you plead no contest as indicated on the form here, there won't be a trial of any kind and you're giving up your trial rights, which are listed on page 2 of the agreement you've now signed?
Sir.
And do you understand that you're waiving any potential defenses that you have to all this? And do you understand if you're not a U.S. citizen that you could be deported because of this?
Sir.
And you understand you'll be adjudicated guilty, so there'll be adjudication of guilt on these felony counts. All right, and also on the domestic violence battery, do you understand that federally, once you plead to a domestic violence battery, that you can't possess a firearm?
Yes, sir.
All right, I mean, obviously, you guys, with the felony conviction, doesn't really change anything, but just to make sure that you understand that as well. All right, and let's see, and how do you plead to each of the charges?
No contest.
All right, and the VOP, do you admit or deny your violation of probation?
Admit.
All right, I'll accept the admission and the plea of no contest to the new charges as freely, voluntarily, knowingly given. On each of the felonies, it's going to be 34 months Department of Corrections, concurrent and with credit for time served. Oh, I'm sorry, I didn't see here, you've got dismissing 2762.
That's
Yes,
the new
law.
case.
Okay,
The
so,
newest case,
so you're
yeah.
not pleading to the witness tampering or the domestic violence battery? Mr.
No,
Williams,
Judge.
you always sneak that into that little section between there. You're the only one that writes it. I'm not saying it's wrong, I'm just like, sometimes I just miss it,
Yes,
where
sir.
you put,
Yes,
you know,
sir.
what's being charged, and it's actually in the perfect place for it, but no one else does it that way.
Sorry.
No, I think you're right, actually, Mr. Williams. You should probably tell everybody else that's where they need to put that stuff.
Oh, nobody listens to me, Judge.
All right, so, and I just want to make sure it's clear then, in 24 CF 2762, the state's dismissing that case, correct?
That is correct, Your
All
Honor.
right, so he's only pled to the VOP and the aggravated assault with a deadly weapon, discharging the firearm, and possession of a firearm by convicted felon, which is a constructive, so there's no mandatory minimum. All right, I apologize, that's my fault, I missed that section. Y'all need to correct me when I get things wrong. All right, so again, it's 34 months on the felonies, so that's everything but the discharge of the firearm. Is that just going to be time served? Yes.
Yes, sir.
Because when I read all misdemeanors, there's only one misdemeanor that he's pled to, so that's, I think, what kind of threw me off, too.
Force of
but
habit, Judge.
It's fine. I don't have a problem with it, but we've taken about 25 or 30 of these today, I think.
Yes, sir.
So they start to all run together a little bit, but, all right, 34 months on the felonies, $867 in court costs, and $150 PD fee, revoking term on the violation of probation case. Did I miss anything?
I don't believe so, Judge.
Anything from probation?
The outstanding monies on the revocation to collection.
All right, outstanding monies due on the revocation of probation case will be sent to judgment. Mr. Dirt, I'll need you to get fingerprinted before you leave, and you have 30 days to appeal the judgment and sentence. This is a guideline sentence. Guideline was 33.75.
Sir.
All right, thank you, Mr. Dirt.
Good luck to you, Mr. Dirt. Judge, this is another one we've gone back and forth on offers and counteroffers. I'm not clear what it's, whether it was set for plea or continuance or set for trial.
Which?
This is Mr. Durham. It
Which
should
one
be
now?
60 on your,
Okay, because I know we have had other terms on the docket before. I got it listed as trial.
It is, and the state is ready.
all right, Judge, we've taken depositions except for the witness that I think you indicated you were not going to call.
Right.
I had asked to take that individual's deposition anyway, and I think the court overruled me on that.
I overruled you on a deposition?
Well, the state's essentially taking them off the witness list. It's Avery, it's the Hicks. It's the father of the children that he was trying to arrange visitation with Ms. Baisden? I think her name-
Brianna Pageant was the co-defendant of Mr. Durham. I can state to the court that Mr. Hicks has simply refused to cooperate. So, I cannot call him, I cannot force him to come here and testify, especially because he hasn't even given a deposition. So
I think a subpoena will force him to be here, wouldn't it? A subpoena would force him to be here or force him to go to a deposition.
Yes, what the subpoena cannot force him to do, I guess, is to say, well, testimony,
Okay.
that's what I meant.
Well, and that's my interest, Judge, is what he would actually say. If we are going to have to go to trial on this.
This case is from March of '23.
Yes, sir, I realize that. It's not that old for me. But I'm just trying to do my due diligence.
The entire time up to now.
I believe Timothy Gibbs, I think that perhaps Charlie or Lisa had it for maybe one docket between Mr. Gibbs and myself.
So what are you asking for at this point?
Judge, I was going to ask, let me ask you this. Is he here in Florida?
I only know that it's in Florida. I know that he moved to Fort Walton Beach. I don't have his address. He didn't want to give me his address.
I would have to go through the file or sit down. I can probably find it real quick on the computer,
last
Judge,
time-
but I think maybe we had him served before.
If I may explain, you sent a subpoena to his grandmother's house. Grandmother is an older lady, she just took it. But Avery Hicks told me that he never received notice. Grandmother never told him. And in the meantime, he doesn't live in Crestview anymore. He lives in Fort Walton Beach. After that, he has refused to give me his address.
Judge, I'd be real surprised if they don't have an address on him in MNI or local law enforcement.
He was in the
Can't find
process
him.
of moving, Mr. William. When I spoke with him, he was literally moving to Fort Walton Beach, so I don't believe the law enforcement has that very new address.
Over to you, Judge.
Are you saying you need to have this witness for the trial?
I've just been told that an eyewitness, somebody that was there, all right, is suddenly not wanting to tell anybody what they saw and heard. You know, we're in a
I
position
don't think
where.
there's anything sudden about this case. It's 2 years old.
Well,
Unless someone's talked to him recently, because everything I've heard is he won't talk to anybody.
Can we approach Your Honor, please?
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
For years, I proudly served Florida as a state trooper. During that time, I investigated over 1,000 car, motorcycle, and trucking crashes. My mission was simple, to help the victims. Now, as an injury attorney, I can do even more to help accident victims. Hi, I'm attorney Coy Browning. If you've been injured in a car accident, I'd be honored to help you. Call or visit us at browninglawfirm.com.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their property. My office is just one block south of the courthouse.
Mr. Durham, do you understand that your lawyer's asking for a continuance to try to track down this witness?
Yes, sir.
Okay. Do you have any issues with the continuance? No? I do, but at the same time, I understand Mr. Williams' concerns, and he just got the case in March. It's, so probably 4 to 6 weeks ago. Mr. Durham, up here. I'll give one continuance to try to find this particular witness. And the state's obviously put on the record what their attempts have been. I've tried to look up the guy right now while we were standing up here at the, just to see if there's an address, but nothing. But y'all have investigators who work for your agencies. I can't keep continuing cases this case is over 2 years old. And again, if Mr. Williams, it wasn't for the fact that you just got on this case and are kind of starting from not scratch, but where y'all have probably done more work in the past couple of months that was done in 2 years before you got on it.
Yes, sir.
So this, I hate saying last continuance, but it's certainly the last continuance for this particular issue. If
Yes,
this particular witness can't be found, then I'm not sure what else I can do in a 2-year-old case where someone is seemingly actively refusing to be a part of it.
Yes, sir.
But obviously, if the court can be of assistance with an order to show cause for someone who doesn't show up on a subpoena, we talked about that the subpoena was a substitute service and the person never got it. But serve someone with a subpoena, and if they don't show up, then we can ask people to find them.
Yes, sir. I'm looking at the subpoena that we originally issued, and it was substitute serve. It looks like it was served on a Minetta Westbrooks.
Well, maybe it's something that you ask your process server to do individual service only.
We use the sheriff's office, Judge.
All right, well.
Yes, sir.
All right, so Mr. Durham, I'm going to put you on the June 24th pretrial. But again, it's certainly my intent to have this case tried the next time around. I kind of set up here, while we were up here, we can't have too many cases keep getting last continuances. But we got so many cases that are 2 and 3 years old, I can't try them all at once. And I think, unfortunately, because of the turnover we've had in the division, it's made it pretty difficult to get these things and these trials worked out. We had 15 set. At this point, I've got no more than 2 going.
Yes, sir.
So, all right, Mr. Durham, we'll see you back on that date.
Just 1 second. Mr. Fountain's here for docket day, plus he's got a bond hearing scheduled.
That I said I agree to your counteroffer, I think you said.
Okay.
About inpatient, I believe you wanted to do.
Right. This is Jared Fountain, Judge. Mr. Fountain, we tried to get you into some inpatient, if I recall correctly. Is that right? She's now agreeing to that. So here's what I'm going to suggest is passing you until Friday. I'll come out to the jail and I'll draft the written. Let me look first, make sure I don't have one in here. No, I understand that. Do you have a preference between Haven House and Chrome? Whatever she'll accept?
Yes, ma'am.
All righty. Judge, if we can pass this till Friday, I'll get with the state. We'll nail down what it's actually going to look like, and I'll go see him at the jail, and we'll get this entered for the court on Friday. I mean, unless...
Nate, any issues with that?
No, Your Honor, I'm fine with that.
Okay.
The only problem with doing it, one, it's going to be a pickup. You're going to be in jail until they pick you up anyway. And 2, it's been a long day. I don't want to give him worse of a headache by having him try to read my handwriting.
Yes, sir.
If he also wants to consider the 1129 with ECLC, that's another option. You can discuss that with Mr. Fountain.
I will.
All right, Mr. Fountain, we'll see you back on Friday. It sounds like there's going to be some sort of resolution, so we'll see you back then.
Thank you, Your Honor.
Okay. And with that, the bond hearing's moot, Judge.
For today, at least.
Okay. Judge, this is Joseph Horn. Judge, I've got it as plea or continuance. This is the case where we had...
I know what case it is.
Okay.
Car from Tennessee and whether it was stolen in the Bolo and the...
Yes, sir. The female companion, or female that had sold him the car, we've managed to locate her in a jail in, I believe, Tennessee. I got an email about it from my investigator this morning. After talking with him last night, I don't think that he's amenable to the state's offer of a plea to the 7-year mandatory minimum and reserve the right to appeal and the stipulation that it's dispositive. Based on my conversations with him last night, he was still wanting to fight the case. It may be that we can make that work a little bit better now that we know where Peggy, I believe her name is, Katie McCurdy.
It's my position that this defendant, the defense that they want to use is the ownership of the drug. The state does not have to prove who owned the drugs. I have to prove knowledge and control of the drugs. He was the sole occupant of the car, and the court is aware of that. And the drugs were found right by his feet. He claims that the owner of the who sold them the car was going to go meet him to retrieve the contraband. Again, one, I don't believe that even if they found her and they get to talk to her, she has a right against self-incrimination. She's not going to come on the stand and say, yes, they were my drugs, trafficking them out.
Damn.
Second, as I said, I just have to prove that this defendant had knowledge and control. So even if they weren't his own drugs, he was going to give them back. At that time, he had knowledge that it wasn't a contraband, and he had control over it.
Well, understand, he's not saying that he knew the drugs were present and he was going to give her the drugs back. What he's saying is that the purchase of the van was actually, what's the phrase that I'm looking for? It was in the nature of a purchase money mortgage on the van. It was a loan with the van as collateral. And when the money was for her to go up to Tennessee and deal with something up there. I don't remember the details now. And then she was going to come back and return the money, or he was going to return the money, and she was going to get the van back. There has not been definitive evidence provided to show that he ever exercised dominion and control over the contraband.
That's what trials are for, right, Mr. Williams?
Yes, sir. We're
My
just
position
trying to be in a position to put our best case forward on that.
I don't need to depose this lady here, so I'm ready for trial.
We're not, no one set it for trial.
Whenever, I know it was continued. I'm just saying for next time, whether he has this lady or not, I'm ready to go.
And Judge, personally, I'm kind of, the case has been around for a while for me as well. And if it's a situation where there's no way to get the lady, I'll talk with my client about it. I'll reach out to the state. We'll try to I'll try to renegotiate it. But thus far, there's not been much in the way of actual negotiation.
Did you say the witness is in jail in another state?
I believe she's in jail in another state, but I don't know how long she's going to be there. I don't know what sentence she's serving. I'm just knowing that, and I can't remember the name of the service that he went through, but that he did locate her. I may be able to even tell the court where, but I'll have to go look at my emails.
I'm not going to investigate it. That's not my role. But I'm just trying to make sure that we're not continuing the case and we come back and like, well, turns out she's going to be in jail for another 6 months. That at least we know about that the next time we get here so decisions can be made.
Well, here's the thing. Let's say that that's the case. Then I ask the court to appoint a commission so I can take a deposition to perpetuate her testimony for use at trial.
I'll rule on motions once I receive them and they're set for a hearing.
Yes, sir. No, that's what you do a deposition perpetuate for. It's when a witness is not going to be available, and cannot be forced to be
I'd
available.
really like to know how long she's not going to be available. I'm just going to put that out there now.
Yes, sir.
She's getting out next week. That's different than if it's going to be a year or she's heading off to prison or I don't
Yes,
know
sir.
anything about it. But
I've done several of those, so I'm familiar with what the rules are. We'd have to show that she would not be available at the time of trial. Well, that's the other alternative, is we seek to have the subpoena served on her in another state. That's probably going to require me to go to the other state or appear by Zoom. There is a procedure for doing that. That one I haven't done before, but I've been present for it as the prosecutor when it's been done before. So there is a mechanism. Now, I don't know that we can force the court up there to allow us to pay somebody. We'd probably have to get off-duty officers to do it, to come pick her up and bring her down here, but we can certainly explore that.
bring her down here, then house her where?
Presumably in our jail, Judge. So again, that's a more complicated question that I've not been involved in before. I just know that we've had, well, we had not long ago, I wasn't one of the attorneys, but Your Honor had not long ago one where a couple of.
Subpoena.
Right, out-of-state subpoena.
Middle of the Norris hearing.
Yes, sir.
Sprouse was handling it.
Had this case for a while, and the name of this McKitty showed up at the very beginning of the case.
Right. I've known her name, but I've not.
Not that we're trying to set the case for trial, after you've done your motion to suppress, now you want to look for her.
I think they've found her is the issue, finally.
You never tried to look for her.
The case is a year old, but it's a 7-year midman is what I heard.
Yes, sir.
It's going to be more because then I'm going to send out the other drugs to different trafficking amount of drugs. Only one has been tested. The offer is based on the one that was tested. If we go to trial, I'll go forward on those counts.
And we weren't set for trial this cycle But Mr. Williams, we got to figure out something. Again, I don't want to come back next time and find out, well, we can't get her. Okay, what's the plan?
Well, Judge, I'll also look into whether or not, what I've got is I've got a stack of J&S's. I suspect that when I checked Earhart, and I just got those in my hands, our office, apparently, the investigators had them for a week or two. But I got them in my hands yesterday, and or not yesterday, Friday, and I brought them out and showed them to the client, gave him copies yesterday. It may be that I can get those in as documents under seal and get past a hearsay exception to them, but right now I think I've got to ask her. She's got a list of priors.
Well, but she's got to get here to testify before you talk about impeaching her.
Well, yes, sir. If I'm going to impeach her, what I'm trying to do is figure it out if I can get them in somehow as substantive evidence. I don't have high hopes on it, but I'll go through Earhart and see if the records under seal exception applies to us as well. I think it only applies to the state.
I don't think I'm going to reply to that, other than I'll deal with any motions that you file.
Yes, sir. And it's set plea or continuance, so I don't think any subs have gone out.
I just don't want to get to next time around and there's no change.
Yes, sir.
And I know you're doing what you're doing, what you can, Mr. Williams, but we at least got to know what our limitations are, what our restrictions are.
Yes, sir.
If she's going to be in jail for a month, I might consider another continuance. If she's looking at a 10-year prison sentence, then you're going to have to figure out another way to do that.
Yes, sir.
All right. 6:24.
Thank you, Josh.
The cases that are left for trial,
The only thing I've got left is Lopez, which is Mr. Switek and Ms. Basso, and then I have Schofield, who we still got to bring back out.
Oh, yeah,
That's the only ones I've got left.
No, you're right, you're correct. I wanted to know the second one.
I had one of mine judged at FT8 earlier. She showed up.
But I can't just appeal in the middle of the case.
Y'all calling? I mean, rock, paper, scissors for it. It doesn't matter.
I'll come out and see you again, Mr. Horn.
Your Honor.
All right, so Mr. Schofield, we passed you because you said you wanted to represent yourself. Is that still the case?
Your Honor, this is why. Mr.
I don't need to
Landis,
know why, I just need to know an answer. I mean, we'll get to that point, but I need
Yes,
to know,
sir.
is that what you want to do?
I feel like it's in my best interest because I feel like that Mr. Lennox is trying to please me and the state, and I don't mean any disrespect towards him by saying
I
that.
think what he's trying to do is make sure he's prepared for a trial where you're looking at potentially prison time.
I would like to just go I think I would just like to proceed, but it's because of his expertise. When he came and seen me and showed the video, he said, well, this video is inadmissible. I'm like, well, why are you showing it to me? In the incident, the Circle K,
Don't get into that. Well, actually, if you're going to be
I want to make
Yeah.
sure you understand, Mr. Schofield, you gotta not just start shouting about the evidence.
Yes, sir, but I'm
You're really
saying,
gonna cause a problem for yourself, and frankly, I'm concerned at whether or not you're gonna be able to handle a trial by yourself if you can't help yourself but to shout out about evidence and not control your behavior.
Yes, sir.
Because that's been a concern every time we've been to court. You start saying things that I've told you not to talk about, your attorneys told you not to talk about, and if you blurt out things in front of the jury and we end up with a mistrial, then we're just gonna have to start all over again.
then I won't do that anymore.
Okay, well, you shouldn't be doing it in the first place, especially because you've been admonished by the court numerous times about that. It's clear that he's trying to tell you things, and you're just, no, I'm gonna say what I'm gonna have to say. And that's not how jury trials work. There's a procedure, there's a sequence of events, and you can't just blurt out whatever you want whenever you want. So, how would you like to proceed?
Per se, Your Honor.
Your Honor, Out of an abundance of caution and to ensure that Mr. Schofield, in case there's a change of heart, has representation, I would not object to being appointed as standby counsel if Mr. Schofield wants it.
I understand, but we're not going to bounce back and forth between these things, Mr. Schofield. He can help you, but you're going to get up there and question these witnesses. You're going to be going forward for a trial where no witness has been deposed. You have no idea what they're going to say. Those are decisions that you're making.
Your Honor, and I'm going to tell you why. When I was released back on bond, I'd investigated these two cases. Okay, so I didn't do so. So my girlfriend called and contacted them because she used to work with the girl at the CEFCO.
Okay. Do you understand the rules of evidence as far as discovery?
Yes.
That you have to disclose any witness that you've got?
Yes.
Have you done that?
Yes.
So there's no witnesses that. Has there been a reciprocal discovery done?
Witness list, Your Honor? No.
So you haven't even given any witnesses over?
Because I know that girl at the Circle K got fired over this incident, and the corporator from Circle K contacted my girlfriend and was like, look, we're not pursuing charges.
Who's going to testify to that?
Nobody's going to be here to testify against me because that woman doesn't work there anymore because she got fired over this incident.
How do you know that?
Because my girlfriend spoke with the CEFCO corporator.
Okay, so you're talking about double and triple hearsay.
I guess so, Your Honor.
Which means it's not admissible, which means you can't testify to things that you heard from 2 or 3 different people.
But I trust.
This is why you need a lawyer, Mr. Schofield, because you don't know the rules of evidence. And if you get in there and we're in the middle of a trial and it's objection, sustained, and you can't testify to the things you thought you could, and that jury comes back guilty if they do, then you're looking at prison time.
I guess I'm just going to prison then, sir. I mean, I'm sorry to say that, but I know for a fact that this video that he showed me, he said it was inadmissible, and it's a completely different incident that I thought y'all were talking about. That's when I seen it, I was like, and then he sat back and he said, look, Schofield, is this you or not? And I said, no.
You're getting into attorney-client privilege information, Mr. Schofield. Your Honor, if I may, I just want clarity from Mr. Schofield. Is he going forward pro se on just this case or on all of his cases?
Oh, I think we're just dealing with the one case today. I'm not, this is the Circle K case, correct?
This is the case with the phone chargers, yeah, sir, okay.
Right, yes.
Allegedly, yes.
I mean, if you want to help me out, I appreciate it. He said he wouldn't allow that, so I'm going to have to.
It's either going to be he's representing you or you're pro se. It's not going to change every 5 minutes. It's not going to be, okay, you do this, now I'm going to do this. It's one or the other.
I just don't want my speedy trial waived, and I just want to go on. I will go pro se.
Your Honor, I just want to make Mr. Schofield aware that I've made the state aware of this, but we still don't have discovery in 25 CF 495, which I request and we should have forthcoming. In 25 CF 398, we received discovery in March. That still needs investigation and due diligence on my part. And then in 24 CF 1844, again, that case could be prepped for trial, but I don't believe it was the court's intention to send both that case and 2080 to trial. It was just 2080.
I think it's just 2080.
Correct, Your Honor. So I just want Mr. Schofield to understand that because he's thinking in his mind that everything's just going to come to a head and all 4 of these cases can be tried. That's not what's happening here, and I want him to be aware of that. And I also just want to make him aware on the record that this is today the last opportunity to accept a negotiated plea bargain to resolve all of his cases, certainly in this case today, at least with the 9 months. Okaloosa County Jail offer credit for time served to resolve all cases, and 1844 would be dismissed. Apologies for my long-windedness there.
You're okay.
If he's comfortable with that, then that's fine.
let me understand. We're past speedy trial.
Case, yes, Your Honor. It was a failure to appear quite some time ago in the case.
So if there's a failure to appear, how does he still have a speedy trial? Right?
That's not my position at all. That's what Mr. Schofield represents.
There hasn't been a notice of expiration of speedy trial there, Mr. Schofield. Just see, you're always so worried about saying things, but you don't want to listen to what I have to say first. When did you file a notice of expiration of speedy trial?
I filed it about 2 weeks ago. It was been about 10 or 12 days ago, but my last court date, when I tried to hand it to you, you said it had already been filed. I filed it. I worked very hard on it, and I filed it because I knew the 180 days, actually it's 175 day speedy trial time was up. And then we had the mix up about the failure to appear, and then I was able to get you to agree with me about the FTA because
I didn't agree with you about anything.
Well, I thought you did, but you, on the January the 30th, me beside Lisa Rivers, because she came in here and she said, Mr. Schofield, they're probably not going to reinstate your bond. And I said, well, ma'am, they told me the wrong court date. And she said, well, I'm just telling you, your chances are slim. Then when I got in here, they agreed to reinstate my bond because I didn't fail to appear, on purpose, like it wasn't, they told me the wrong court date, and I had that on record.
Revoked again on February 26th when you...
24th.
Yeah, that's when he picked up the new charges, Your Honor.
Because the speedy trial time was up before that.
When did you file your notice of expiration?
Your Honor, I know it's been within the last 11 or 12 days. I can't tell you the exact date because I don't have a phone or anything, but I filed it. I got a memorandum back on it.
Yeah, I think it would have been sometime in mid to late April, Your Honor. If I'm remembering.
This case where it was filed in the wrong.
It would have been, I believe it would have been in a different case number, Your Honor. It might have been in one of the newer cases, 395 or...
That was the alibi.
Or 398 or 495, excuse me.
The notice of expiration of speedy trial filed 4/25/25. It has two case numbers on it. Are you adopting that, Mr. Maddox?
No.
All right, so he's not adopting it.
I'm pro se then.
Okay.
Completely pro se. Without Mr. I'll just completely go pro se because I worked very hard on that motion, Your Honor.
Yeah, but he wants a trial, we can give him a trial.
It's not a motion that has to be worked on. It's a notice. You're saying this is expired. But it doesn't become effective until he's no longer on your case because he's saying it's not right. So he's not adopting it.
I would like to file it pro se then, sir. I worked very hard on it.
The judge's going to take that up with you, that's fine.
We can go forward pro se, but I'm not going to have him then jump back in later.
Okay.
I mean, if you want to go to trial, which is going to be next week, this is what you want to do.
Yes, sir.
Okay. Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir, Your Honor.
Okay. All right, so this is what we call a Ferretti inquiry. And I'm going to go through every single question with you, Mr. Schofield, because I'm starting off with I'm concerned at your understanding of how these things work. Do you understand that you have a right to a lawyer?
Yes, sir.
Do you understand if you can't afford a lawyer and if you qualify, you can be appointed one, which you were? Do you understand that?
Yes, sir.
But you don't want me to appoint one, or keep one appointed to you?
No, sir, because I want my motions filed. I want you to honor them. I want them to go through and work, and he won't adopt them.
Just understand, if he's off the case and you file it, and I look at it and I say, well, that's not right.
Yes, sir.
Because I have to go back and look at this point, because it wasn't when you're represented by a lawyer and you file something, it's what we call a nullity, unless he adopts it. But if you don't have a lawyer and you want me to look at it today, it can potentially become effective today, and I can certainly get you your trial in a speedy way, which is next week.
Your Honor, and I think when you do see that, I think you'll be impressed with it. I worked very hard on it.
Mr. Schofield, can you let me finish?
Yes, sir.
All right. So I could look at it and say, I think you've waived your right to speedy trial because you missed a court date previously. I'm not saying I would, but I have to go back and look at it. So just because you asked for a speedy trial, but if you did something to waive it previously, I mean, there's a way to start the clock back up after you waive it. But you want to go to trial, and the state's saying that they're ready, correct?
Correct, Your Honor.
All right, so I don't think there's an issue about speedy trial at this point.
Okay.
Trial's going to be next week.
Okay.
Knowing that, do you want to go forward without a lawyer?
Yes, sir.
Tell me why.
I want to go forward. The reason why I want to go forward, Your Honor, is because I didn't take those phone charges out of that store.
Okay, so here's the problem. I've asked you a question. Now, you've said something that you've been told numerous times not, let me finish, Mr. Schofield. I don't think at this point that you're capable of keeping things to yourself that aren't detrimental to your case. That you don't just get to blurt out the facts of the case. So I'm worried that if we get in front of a jury, you're just going to start testifying anytime you feel like it.
Okay, my answer now to that question you asked me is because I'm innocent.
Okay. But why don't you want to have a lawyer with you for that?
Your Honor, because I don't feel like he's really my friend in my best interest. There's been so much that
But then you're asking for potentially a different thing, which is a Nelson inquiry, which is, did he do something inappropriate that I can potentially appoint a different lawyer?
I know they don't have any evidence, and I'm ready to proceed with trial pro se because I know that they don't have any evidence. I know that Circle K's not going to come here and say, we caught him stealing there. We know he stole something. I know that they didn't catch me with any phone charges, and I know that I didn't take any. I know there's so many things that I know that where I'm like, you know what, let's just go to trial because I know.
Mr. Maddox, what is your concern with going to trial when he wants to?
Like I said, Your Honor, I can have the case prep for trial with what I had. I'm prepared to go forward with what I had. My concern was I just wanted to depose the store clerk and the officers
Well,
to pin down.
he's refusing that. He's saying.
Yeah, I understand that. That's fine. And apologies for.
No, you're.
I understand that, Your Honor, and that is perfectly fine. Like I said, I can move forward with what I had. It's just Mr. Schofield and I, among other things, have just disagreed about essentially everything that there is in the case. And while I've tried to bring him things, I've tried to go over things with him, I've done just about everything I can. I was still prepared to go forward today with trial, assuming that he was willing to accept the case as it was, as I have it.
So, Mr. Schofield, if he stays on the case, someone who knows how evidence works, knows how a trial works, has actually been in a courtroom before, why don't you want to have a lawyer help you in things that you have no experience with?
Because the case
trial's still going to go next week.
Okay, like I said, you said we weren't going to go back and forth, and I'm in my mind confused. So, it's
But
like, well, I wanted to.
It seemed like, because here's the problem, it seemed like one of your big concerns was you saying you want a speedy trial. And what I've told you is that wasn't effective until then. But the issue is, it's kind of a moot point. Because once your speedy trial, once you file a notice of expiration, we have to have a hearing within 5 days, which we can do today or Friday or what, and then we have to set the trial. Your trial's going to be in 5 days. So.
I may, Your Honor,
Go ahead.
1844 has similar concerns. He's concerned about the same thing in 1844. He'd like to take that case to trial immediately based on what he's represented to me, and like I've tried to explain to him, I don't believe the court's prepared to do that at this time, but he has
Well,
similar
the
concerns.
court is prepared. It's just that it wasn't announced for trial, so I'm guessing the state hasn't sent subpoenas out for that case.
Yeah, we were prepared to go forward on 2080, Your Honor. That's,
Okay. So we can go forward on 2080.
I would like, if we could, I wanted to move forward with both of the 2024 cases. Like I say, I know that the case is so weak that.
But you said at our last court date, last week, that you wanted to go forward on 2080, right?
It's a 2024 case, right?
Yes.
Yes.
24 CF 2080.
That would be the Circle K,
That's
right?
one that's, I don't know.
it's the Circle K. It's
Okay.
allegedly occurred at Circle K, yes, Your Honor. And that was, me and Mr. Sheik, along with the court, had a dialogue about which case we wanted to go forward. I selected 2080 for various reasons. The state was not an objection to that, so we were prepared to move forward with 2080. I believe among other reasons, there was multiple cases set, so we just wanted to get one before the court in an expedited fashion, per Mr. Schofield's request.
All right, so Mr. Schofield, we can go forward with 2080 next week. And then we can set the next one for the next trial period. But I can't have 4 trials for you in 1 week. I mean, I could now, but we didn't know that last week. We could do 4 trials in a row. It's just the state wasn't told to prepare for that, to send out subpoenas last week. And now it's a little too late, even to get law enforcement subpoenaed. They need more time than this.
I'm going with my gut feeling, Your Honor. I'm just going to go pro se. Let's just do it. And if I go to prison.
Well, I have to make that decision because I don't think that at this point you've got to show me that you're able to do that.
I mean, Your Honor, I mean, I can't argue with you. You're the head officer of this court. I'm just going to.
No, but you have to answer my questions. But up to this point, you have displayed a lack of ability to answer questions properly, not say things that you shouldn't that'll be detrimental to your case. Just so you understand, I'm not doing this because I'm trying to have some easy trial for the court. I'm trying to protect your rights. And I don't want you to end up in prison because you made a poor decision about representing yourself. That's what this is all about. It's about protecting your rights. But if you want to go forward without a lawyer, then you can do so if we go through this inquiry and I find that you're capable of handling this on your own.
Yes, sir.
Okay. All right. Do you understand the advantages of having a lawyer?
Yes, sir.
Do you understand that a lawyer has legal knowledge and experience that may be favorable, that affects your release, obtaining information about the case through skillful use of discovery?
Yes, sir.
All right. But you're not wanting to participate in discovery at this point because you want your trial immediately.
Correct, Your Honor.
Okay. So do you understand that lawyers can uncover potential violations of your constitutional rights?
Yes, sir.
Do you understand that they can take effective measures to address those violations?
Yes, sir.
Do you understand that they may ensure compliance with speedy trial and statute of limitations provisions?
Yes, sir.
All right. And that they may identify and secure favorable evidence to be introduced later at trial on your behalf?
Yes, sir.
Do you understand that a lawyer has experience and knowledge of the entire process of a trial?
Yes, sir.
Do you understand that a lawyer will argue for your side during the whole trial and present the best legal argument for your defense?
Yes, sir.
Do you understand that since jury qualifications and selection are governed by numerous legal procedures, a lawyer's knowledge and experience may enhance the selection process on your behalf?
Yes, sir, Your Honor.
Okay, I want to specifically kind of go off script here. Do you understand that when you're picking a jury, you can't talk about the facts of the case? And that if you, yes?
Yes, sir,
You have
Your
to
Honor.
respond verbally, or out loud.
Yes, sir, I do understand.
So if you start talking about the facts of your case during jury selection and the state objects, that may end up with a mistrial and we'll start all over in 2 months.
I won't do that.
Okay. Do you understand that a lawyer can call witnesses for you?
Yes, sir.
Can question witnesses for you?
Yes, sir.
Present evidence on your behalf?
Yes, sir.
Do you understand the lawyer can advise you of whether or not you should testify?
Yes, sir.
Whether or not there's consequences of that decision?
Yes, sir.
And what you have a right not to say?
Yes, sir.
Do you understand a lawyer studies the rules of evidence and knows that what evidence can and cannot come into your trial?
Yes, sir.
Okay. Do you understand the evidence code?
Yes, sir.
Okay. What chapter in Florida statutes is it?
All I know is that inadmissible means no good.
Okay, but do you know what makes something inadmissible?
No.
You know what hearsay is?
Yes.
What is it?
Just like a rumor, something said, no solid proof, no physical evidence.
Do you know
It's
any
just-
of the exceptions to the hearsay rule?
I do not.
Do you understand what foundation means?
I do not.
Do you understand what a predicate is?
No, sir.
You understand that the state has an experienced prosecutor who's going to be able to, is going to know all these rules.
Yes, sir, I do.
Okay, so if you try to get into evidence and the state objects and they're right, and I sustain their objection, that your evidence may not come in. Especially things about, things you think because someone told you, if that person's not here to testify.
Yes, sir. May I ask one question right now? I did good. I didn't interrupt. I'm getting better.
You're getting better. Thank you, Mr. Schofield.
Let's just say if I was pro se, if the video that Mr. Maddox showed me, if he said two or three times, it's inadmissible. Is it still inadmissible if I'm representing myself? Is it still the same, or does
It's
it?
not inadmissible until I make a ruling on whether or not it's admissible. And no offense to Mr. Maddox or any other attorney, what their theory is on that could be wrong. Or I could make a decision where they think I'm wrong, but ultimately I make that decision. So if you try to present evidence and the state objects and I sustain their objection, it's not coming in.
Yes, sir.
Again, I'm not saying Mr. Maddox, I don't know what the video shows at all. I don't even know what the video you're talking about. Is it a body camera? Is it surveillance? I don't want an answer to that. I don't know anything about it. But it's not inadmissible until, there's an objection and then we talk about that. But that's done outside the presence of the jury. You understand now?
Yes, sir.
So if you're going forward based on someone else's opinion on that, if it's wrong, then that's going to be detrimental to you.
Yes, sir.
And you have to make that legal argument. So even if, again, Mr. Maddox was right about something being inadmissible, you have to be able to articulate that argument as to why it's not.
Yes, sir.
All right. Do you think you can do that?
No, sir.
Okay. So if evidence gets in that should have been inadmissible because you didn't, because it's not for me to save you, Mr. Schofield, although I'm trying to protect your rights through this process, it's not for me to say, you know what, that's clearly hearsay, or that's clearly a lack of proper predicate or foundation, or best evidence rule of completeness, all these things that a lawyer could object to. If you don't object and it comes into evidence, I can't just say, you know what, he should have known better, and deem that it's inadmissible, even though you didn't make the proper argument. Do you understand that? I'm not trying to be critical. Vast majority of people don't know how a real courtroom works.
Yes, sir. You've been more than fair with me. I just, I haven't had any theft charges. I have been to prison 3 times for battery.
That's not the issue right now. We're talking about whether or not you're capable of handling this.
Well, maybe I thought I was, but you being the judge here, you kind of made me maybe think differently. Maybe.
Well, and I'm not trying to make you think one way or the other than to make sure you understand the advantages of having a lawyer and the disadvantages of doing things on your own if you're not skilled in this arena. The way I sometimes equate it, you may be great at arguing, but you're dealing with a professional on the other side. It's like someone who says they're a great street fighter, but then you go against a professional boxer, you might learn a lesson you didn't want to learn. Do you understand what I'm talking about? So what do you want to do at this point, Mr. Schofield?
At this point, I think I'm just going to take your advice.
I haven't given you advice.
Well, I think
I have to just advise you of things. I guess when I say advise, it sounds like advice, doesn't it? But I just have to make sure you understand these things. These are more warnings about the issue, so to make sure you're thinking about it, because you haven't been through this.
if Mr. Maddox, even though he's had a hard time with me, if he would still be willing to help me through it, then I would appreciate that of him very much.
Okay. Mr. Maddox?
Absolutely, Your Honor. Ready to proceed. If he is going to retain me as counsel, I would like to address something with the court, but I'll do that at the appropriate time.
You want him back, right?
That's up to you.
I was talking to Mr. Schofield, sorry.
Apologies.
Yes, sir, Mr. Oberliesen.
Okay. Come on back up.
May we approach, Your Honor?
Yes.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
All right. So this is what I would plan to do, Mr. Schofield, and I'll let both the attorneys bring anything else to my attention, is we're going to keep it on for Friday. This Friday is going to be called jury review. I don't see this as a case where we need an extra number of people in the venire or anything like that.
Only 20-something. Whatever it is fine, yeah.
I think it's 24, but I'm not even sure. Well,
fine.
We'll see what we need. Hold on, Mr. Schofield, let me finish. If there's any evidentiary issues, they can be, I mean, I prefer a motion be filed if it's gonna be something we have to have a hearing about. If y'all agree to something, that's different. But if there's a motion that's gonna be filed, I'd like to have it in advance so I can read it in advance and I, you know, I do my own research too, but I'll certainly read anything y'all provide me. We can have those on Friday. At this point, we've got a docket on Friday with some possible pleas and things, but for the most part, you know, I think we'll probably be done by 10 o'clock. So we've got some time to handle motion hearings that day instead of trying to do it while the jury's waiting for it.
Yes, Your Honor. I still will plan on being on Zoom, but if a motion needs to be heard, I'll certainly be available for it.
Okay. And then Monday, that's right, you got the wedding this weekend.
Yes, Your Honor.
850-306.
So will you be ready for jury selection on Monday?
I could be, if possible. I'd prefer it later in the week. If I need to be here Monday though, and that's what works for the court, I certainly can be.
Main Street. We
I'll
serve
have to,
handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m. Serving lunch from 11 to 2. We hope to see you
Wednesday,
soon.
Thursday, Friday.
At this point, it's the only trial that we're gonna have next week. So we've got the whole week.
I am Bonnie from Body Be Healthy.
But I just have to make sure they can get the people on a different day if that would be beneficial, because I think this is probably even a pick and go.
Yes, it would likely be a pick and go. I think we've got, what, two?
One at a time, one at a time. So you gotta do it to the lawyers too, Mr. Schofield.
Go ahead.
Stop by and let us help you be healthy.
How many witnesses are there?
I'm Amanda Gaskin with Briarpatch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check
So what that
from
means,
Homes
Mr.
for
Schofield,
Heroes.
is because it's only a
Check out
felony because of
amandasheroes.com
prior
for more
history.
information.
Basically, there's a trial to prove your petty theft. And then, if the jury comes back that they've proven that the state's proven the petty theft, then there's almost like a secondary trial where they have to prove that you have priors. That would get you to the felony point. Otherwise, if we talk about you having having prior petty thefts, that may bias the jury against you in the first place.
Encourage you to join us for lunch.
I appreciate you bringing that
Monday
up, Mr.
through
Sheik.
Thursday from 10 a.m. till
But I
3
still don't
p.m.
think with three
Friday
witnesses
from 10 a.m. till
on a
4
theft
p.m.
case, from what
and
I've
Saturday
heard, that we
from
couldn't
10
get it done
a.m.
in
till
one day.
2 p.m.
No,
We're
that should be
located in
fine.
historic downtown.
And if we need to put it later in the week, the state, actually, I would prefer it too, but I also understand we have to go by what the court's able to get.
Well, I understand. To me, it's about, we can pick a jury on Monday and do the trial another day if that's what benefits the parties. I'm just trying to find out, I'll have to figure out if we can have the jurors come in on a separate day as opposed to coming in Monday and coming back another day. If we can just have them say, come in on Wednesday and just do it all in one day.
Yeah.
I just want to make sure, because it's the first time I've been in a jury selection in this division in this county, so I just want to make sure everything works. It should be, but until I get a commitment from jury management, I don't want to say that for sure. So think about between now, well, actually, if y'all could communicate on your side, and Mr. Sheik, and then just send me an email as to what day y'all think you could do it best.
Oh, yes,
'Cause again,
absolutely.
I'm not trying to jam you up either. You've got to go out of town this weekend is what you've told us previously, so I don't want to jam you up on that either, Mr. Maddox. And I want to make sure you've got enough time to devote to Mr. Schofield's case. Obviously, you got this whole week, but I want to make sure that you're ready to go as well.
Thank you, Your Honor.
All right. So we'll talk about it more on Friday, Mr. Schofield.
And then, oh, sorry.
Yeah, I had something to say.
Your Honor, this is going to sound correct, but I'm going to be completely honest. You know why I am completely not comfortable at all right now?
I don't
Because those are the people trying to prosecute me, and when I was gonna go and representing myself, they didn't look very happy. And as soon as Mr. Maddox was gonna get back on my point, they seemed very happy, and that's why I wanted to represent myself. That's what it should be. I'm just being honest. I'm not making you. I'm not gonna say I'm gonna go back and forth again, but I'm telling you that's how I feel in my heart. And I know that may sound crazy, but that's the truth. When I seen them smile, then that makes me feel uneasy about him. And I'm just being honest, and I'm very sorry. I don't mean any disrespect for this court, but that is the truth.
You want me to take 5 minutes and explain it to him?
Why don't y'all come back on Friday and you can explain it to me or not?
Okay.
Because Mr. Schofield, I've got concerns, not just at this point about whether or not you can represent yourself, as to whether or not you're competent.
Are you directing that emotion?
I'm not at this point.
Okay.
But I've got real concerns that you're making your decisions on your rights and your liberty based on whether or not you think one of the prosecutors smiled. So I'm gonna let them talk to you. We're gonna come back on Friday. However you want to do it, but if you're gonna represent yourself, we're gonna go through all of this again. And then, but that decision's gonna be on Friday.
Okay.
But I think Mr. Williams, who's one of the public defenders who works with Mr. Maddox, wants to maybe jump in and help out too. But I'm not gonna get in the middle of all that.
No, I understand that, Your Honor. Just to be clear, so that Mr. Schofield is aware, understand that the court normally doesn't take any negotiated plea agreement beyond today. Is that still the court's position?
If y'all come back and you work something out, I'll certainly entertain that on Friday.
Understood.
I don't expect I would at jury selection, because once we start bringing in members of the public to take time away from their lives, then your only plea is straight up as charged. All right,
Yes, Your
we'll
Honor.
see y'all Friday.
All right, thank you.
This is mine.
Yeah.
Anybody need a break?
No, sir, I got 2 cases, Judge.
Okay, so you good? Do you need time? I know you. Okay, Mr. Russell, who are you looking for?
Yes, but we have somebody in the back, one more inmate. Either one is fine, whichever way you want to go.
Who is it? I don't think he knows the names.
Oh, Jonathan Murphy is the one in the back. Yes. Okay, go ahead and do him. Judge Charles Russell, Public Defender's Office, just as Jonathan Murphy, case number is 24 CF 2181. For the record, Mr. Murphy was before the court earlier with a possible plea. Then he raised some concerns. I went in the back and talked to him, explained to him, choices today are plea or don't. And I'm not telling him which one to do. He can do either one. The other stuff that he brought out in court earlier, we can deal with, but we're going to have to put the case off. He indicated to me that he wants to take the plea. Sure?
Yes, sir.
Okay. May I approach?
Concerns about previous plea offers or alternate plea offers. All
Right.
Yeah.
But Mr. Murphy, you want to go forward with the plea that Mr. Russell
Yes,
has
sir.
in his hand?
That's the best I'm gonna get, absolutely.
I don't know. Come on up. The court's not supposed to take part in the plea negotiation
understand
unless
that.
invited into it. And, if they've had negotiations, they don't tell me that, because if ultimately you don't take a plea and you come in front of me and I'm going to make a decision on sentencing, I don't want to be biased by the fact I know what the plea offer was and say, well, you didn't take that.
I understand.
So, even if, we like to say we won't be biased because, we're trying to be as professional as possible, I still don't want that in the back of my mind in some way. All right, so, Mr. Murphy, we're back, 24 CF 2181, where you're charged with aggravated assault with a deadly weapon and felony battery, both of which are third-degree felonies, punishable up to 5 years in state prison. The plea and sentencing agreement I received is that you would be agreeing to an adjudication of guilt, 21.68 months, Department of Corrections, on each count. Those are run concurrent. You'll get credit for all the time that you've served on these counts. Court costs would be $867 because of the battery charge, and then $150 PD fee to judgment. Is that what you want to do today?
Yes, sir.
All right. Have you gone over this agreement with Mr. Russell?
Yes, sir.
And did you understand it? And did you sign it?
Sir.
Are you satisfied with his advice and representation?
Yes, sir, I am.
Do you have any other questions about it?
No, sir, not at
Do
all.
you need any more time to speak with Mr. Russell?
I don't, no, sir.
All right. Are you
help
currently
me.
under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health issues or concerns?
No, sir, not at all.
Has anyone forced, pressured, or threatened you in any way to get you to take this plea?
No, sir.
Has anyone promised you anything in return for your plea?
No, sir.
Do you understand that if I accept your plea, which is listed as no contest on here, that if I accept your plea, there won't be a trial of any kind, and you'd be giving up your trial rights, which are listed on page 2 of the agreement that you signed?
Yes, sir.
And do you understand that you'd be waiving any potential defenses that you may have?
Sure.
And do you understand that if you're not a U.S. citizen, then you could be deported because of this case?
Sure.
All right, and this is a guideline sentence, correct?
Correct, Judge. 21.675 is what he actually scores, but the state rounded.
21.68, which
Yes, sir, that's fine.
I'm not even sure is a full day difference. And this is the state's agreement?
It is, Your Honor.
All right, Mr. Murphy, based on this plea agreement that you've made with the state, what is your plea?
No contest.
I'm going to accept your no contest plea to the aggravated assault and the felony battery. I'm going to adjudicate you guilty of both. Sentence you to 21.68 months in the Department of Corrections for each count to run concurrent. You'll receive credit for all time that you've served up to this point. Court costs are $867 and a $150 PD fee. Those will go to judgment. All right, any other questions, Mr. Murphy?
No, sir.
All right, I need you to be fingerprinted, and you have 30 days to
Thank you.
appeal the
Appreciate it.
judgment and sentence of this court.
Charles Russell, Public Defender's Office. Judge, this is Jessica Kosen. Case number is 24 CF 2203, page 15 on my docket. Ms. Kosen was not here earlier when we called her case, but she's here now. So we'd ask that the capias be withdrawn, and we have a negotiated plea if the court's willing to accept it.
Okay, Ms. Kosen, what happened? You were here last week, right?
Yes, sir. I thought it was at 1, so I was here at 1.
Okay.
Sorry.
I think that's what you had said, Mr. Russell, unless I'm confusing it with someone else too. All right, I'll withdraw the capias.
Mayor Pro Tem.
I want to make sure I'm saying that so it doesn't feel that's part of the plea negotiation or some sort of exerted pressure onto Ms. Kosen. All right. Can you raise your right hand? Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay. Miss, is it Kosen? Am I saying that?
Kosen.
Right? Kosen. Can you state your full name and date of birth, please?
Jessica Kosen, 10/23/1990.
Okay. And you're here in 24 CF 2203, where you're charged with 1 count of possession of a controlled substance, third-degree felony, punishment up to 5 years, and 2 counts of possession of drug paraphernalia, which is a first-degree misdemeanor punished by up to a year in county jail each. You understand that?
Sure.
All right. I've been handed a plea and sentencing agreement that calls for you to plead to counts 1 and 2. You'd be adjudicated guilty, time served, court costs, which would be $615, which includes that $100 cost of prosecution, $150 PD fee, give you 90 days to pay that or go to judgment. Okay. And then count 3 would be dismissed by the state. Is that what you want to do today?
Yes, sir.
And that is, she doesn't score, so that's a guideline sentence. All right. Did you go over this plea and sentencing agreement with Mr. Russell? Did you understand it? And did you sign it?
Yes, sir.
I got to check. We had a couple not signed so far today. And are you satisfied with Mr. Russell's representation and advice?
Yes, sir, very.
Are you currently under the influence of any alcohol, drugs, or controlled substances? Are you currently suffering from any mental health issues? Has anyone forced, pressured, or threatened you in any way to enter this plea? Has anyone promised you anything in return for your plea? You understand by entering a no contest plea, there won't be a trial of any kind, and you're giving up your right to a trial and the rights that are listed on page 2 of your agreement.
Yes, sir.
And do you understand you're waiving any potential defenses that you may have?
Yes, sir.
Do you understand that this makes you a convicted felon? All right. And do you understand that if you're not a U.S. citizen, this could lead to your deportation? All right. Then what is your plea to the 1 count of possession of a controlled substance and 1 count of paraphernalia?
No contest.
All right. Accept your no contest plea is freely, voluntarily, knowingly given. State have an announcement on count 3.
Yes, Your Honor, the state will null pros the count 3.
All right. And as far as your sentence, Ms. Kosen, again, it's an adjudication of guilt on the possession of controlled substance and the possession of paraphernalia. Time served, $615 in court costs, $150 PD fee. I'm going to give you 90 days to pay that or go to judgment.
Yes, sir.
All right. Any questions about that?
No, sir.
All right. I need you to be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court. Do you have anyone else, Mr. Williams, Mr. Maddox, Mr. Russell?
No, Your Honor.
No, Your Honor, I don't.
I think we just have Mr. McDonald left. What do you mean?
Judge, just to let you know, I noticed it might not be the same Mr. McDonald, but there's a Mr. McDonald on the arraignment list. If it's him, you might want to go ahead and arraign him.
It could be. He's got a new case.
I think I remember that.
Step what?
You gonna stick around?
He's not mine.
No, he wasn't. You had him
Just in
before.
case? Yes, I'll stick around just in case.
That's up to you.
All righty.
Okay. You can do that too, because we're not, because get notified if we get a point.
Oh, yeah.
Yeah, I don't see that information's been filed on the newest case.
All right, Judge, just in that case, may I be excused?
Yes. All right. Mr. McDonald.
Hey, how
Sorry
you
we
doing?
saved you till last, but I
That's all
just
right.
wanted to make sure we had enough time to cover what you wanted to cover. So what we're here for is that we weren't set for trial for next week, but we talked about setting a hearing on all the motions that you want to have heard. So, which case would you like to talk about?
I want to talk about the 1950 case first, Your Honor, for the record.
1950. Okay, go ahead.
Okay. I got the discovery Friday at the jail, and I have a documentation within that discovery exhibit of the certified records of the EMS report from the incident, Your Honor. And I wanted to ask the court or Miss Ariana Leon how I determine and cipher, because I'm not an expert in medical.
We can't give you legal advice,
All right.
Mr. McDonald.
Well,
That's
well,
why.
what is at my disposal
Well, hold on a
for
second.
this?
Let me stop for a second. I didn't do what I'm supposed to do to begin with. Raise your right hand. Do you swear or affirm testimony about to give us the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. You're here representing yourself on multiple cases again,
Yes, sir.
Mr. McDonald. Do you still want to go forward without representation?
Yes, sir.
Do you want me to talk any more about the advantages or disadvantages of that?
I understand them, sir.
Okay. Again, there's a recent case that talks about, the judge shouldn't keep bringing it up and make it sound like you have to do it.
Yeah,
So I don't want to make it sound like you have to have an attorney.
Right, like a coercion thing.
Yeah, I'm not trying to do that, and it's funny because it's always been, we have to make sure to bring this up every single time, and I almost forgot, because I'm just so used to dealing with you now, Mr. McDonald.
That's fine.
But as far as, you're asking either me or the prosecutor to explain things to you, we can't do that.
Okay, well, can I rephrase the question?
Sure.
I can't cipher this. I'm not an expert.
Well, what would you like me to do, Mr. McDonald? And that's a serious question. I'm not sure.
Yeah, I understand that. So this is in regards to claiming that I ingested a dangerous drug. But the vital sign, for my assumption of it, is all normal and doesn't show that.
This is for the 1950 case?
Yes, sir. For tampering with
Oh,
evidence.
for tampering. Okay, I
Yes.
got you now.
Yes. And so what, it appears to me, and I'm not an expert, that it's all normal and doesn't show signs of a person who would ingest a dangerous drug.
I don't know. I don't look at the evidence in advance. That's just not my role.
The other thing I would like to address is,
So what would you like done about that, Mr. McDonald? You didn't answer that question.
I was going to ask the question was going to pertain to what was at my disposal to bring somebody in there to determine that.
Have you filed a motion to appoint some sort of expert?
Well, for the purpose of that question, Your Honor, I've only had this discovery 2 days.
Well, I
And so
understand.
there's a lot to go over for both of the cases. And so I haven't reached to that and arrived to that point yet. But I will. I will in that case, since I understand exactly where I'm at, standing with that particular.
Okay. So what other issues did you want to address?
The other thing is I would like to see if the court would entertain today for oral pronouncement and then me produce the motion for the discovery depositions and my persons that I want to depose.
Have you filed a notice for?
No, Yes, I did. It was the consolidated cases,
Mr.
but
McDonald, let me stop you for a second. What do you think I was asking you?
for the notice of discovery, for the depositions and the discovery?
That's the point. You're
And
not
the
sure which
witness
one
list?
because you interrupted me and started answering before
Well, I'm sorry, Your
I
Honor.
got to finish the question. And I'm not trying to be difficult. I just want to make sure that we're on the same page.
Yes, sir.
You filed a notice, you're asking for discovery already, right?
Yes.
Okay. So what has to be done is you have to set up the deposition,
Okay.
which means that's typically coordinated. And that's why, again, it's one of the advantages of having a lawyer is what?
That's what I'm trying to do now.
But you can't possibly expect I could read that, what you just
I understand
flashed to
that.
me for about a second and a half.
I understand that, but I was asking if I could, the court would entertain me saying that I would set up for the depositions today and produce the motion for it by mail.
It's not something the court grants. They've sent you a list of witnesses, right?
Yes,
And you want to depose them.
yes.
Which witnesses?
The Officer DeWitt and Officer Perslick. That's the only two I wanted to
That's
depose.
the only witnesses you want to depose?
On in that case, yes, sir.
Okay.
It's only two. Officer, and then, for that case right there, that's where I'm at with that case right now, Your Honor. All right?
Okay.
And
You
then
just
for
want to
the,
set up depositions with them?
yes, sir. And for the record, can we go to the 2917 case, Your Honor?
2917.
Now, in this case, Your Honor, I'm confused because they list three different types of vehicles for one criminal episode with three different types of.
I'm not sure what you're referring to, sir.
I'm referring to the documentation for the Crestview Police Department call history identifies a 2000 K 3500 truck, white dump bed. In the sworn statement by the victim, he describes the vehicle as a 1998 white Ford F-150. And in another sworn statement from an officer, it's described as a 1998 white Chevy pickup.
All right, so what would you like me to do, Mr. McDonald?
I would like to set up depositions for the Category A witnesses.
And who is that?
That is going to be Anthony Ray Krieger.
Crocker?
Krieger, Krigger. A Mr. Richard Lewis Goff.
How do you spell that?
It's going to be Goff, if that's how you spell his last name.
Is that the only people you want to depose in
No,
that
sir.
case? Say again?
No, sir.
Okay, then keep going.
A Wesley Blake Herring. Would you like me, he spells his name Weslee. Blake Herring.
What is his last name?
Hearings.
Just pull it up. Hearings.
Yes, sir. Hearing.
Okay.
All right, now, but the issue with Mr. Hearing is that on line 16 of the call history record, they describe him as a white male, approximately 35 years old, but then on line 19, the Okaloosa County Sheriff's Office states that there's no locals by that name. But Mr. Anthony Ray Krieger swears that he employed him and just fired him 2 days prior.
What would you like me to do about that? Sir, it's not for me to go through the evidence with you and decide if there's an issue with it or not.
Yes, sir.
It's not my role.
Yes, sir.
Again, that's something you would do with an attorney if you had one.
All right. So I'd like to depose them and Rebecca Lynn Feller. And those are the only four.
Anything else that you want to address today?
I wanted to address the issue with, wanted to know if this is the correct email address for Miss Ms. Leon, the state attorney, is it lowercase a-l-e-o-n-e at the thing that's on your?
It is.
That
Yeah,
is?
it is.
But just so you
Did-
understand, any conversations that she has with you have to be on the record.
Yeah, yes, sir. Well, my alibi witness was going to upload some information to her email address where it shows that I was physically impossible to commit this crime on the 18th because of my GPS location and my information, my cell phone information was to a senior investigator, Mike Hogan, in which I had a physical meeting with him that day at my home, that evening, on that day of this incident. And so I was trying to.
So something's going to be provided by someone else.
Yes, by Rebecca Lynn Feller, who is my alibi
Have you done a
witness.
reciprocal discovery?
Yes,
for that?
part of my reciprocal discovery, yes. I was just trying to do that, to show her that I was physically impossible to do that, and I had a physical meeting with this senior investigator, Mr. Hogan, at my home, or at Rebecca's. And that my text messages are from the time that these officers here at the scene are saying that this offense happened, and that my text messages
I
began.
understand that, but you're providing that to the state at some point.
Yes, I want to provide that to her, and let her be aware of
And
that.
I hate to keep saying this, but what would you like me to do about that, Mr. McDonald?
Well,
I want to know what you're asking me to do.
I just want Miss Ariana Leon to review that, and then we come back at a later time and see what she thinks of that.
Well, she doesn't have to tell you what she thinks.
Well, I understand that, Your Honor. I'm not trying to be difficult. I'm just saying, I did not commit this offense, and I'm just trying to prove my innocence, that's
I
all.
understand. You can provide your evidence, and if she thinks differently and wants to give you some sort of different plea offer, she can do that on the record.
All right. And that's all I have for today.
That's all you have for today. So you just want to get these depositions set,
Yes,
basically?
I do. I wanted to say that, she was going to do that. I know she's having difficulty, but she was going to do that yesterday for me, to do that to Mrs. Leon's email. So I don't know if it's done yet or not, but hopefully it gets done this week.
How are you going to subpoena the witnesses for the depositions? Do you know how to do that?
Yes, I can do that. Did you get it in the mail?
Get what in the mail?
The subpoena, the witness attendance subpoenas that I produced.
I'm not a witness, I don't get the subpoena.
Why would you be sending subpoenas to the state attorney?
Well, you said for me to produce something last Wednesday, and that you said that you doubted that she would get it, and I told her I would have her copy of it. But I have already subpoenaed them already prior.
For what date?
I didn't leave a date, I left it up for the
That's what a
court.
subpoena is. A subpoena
Right.
is a piece of paper that gets served on someone, says, you have to be at this place at this time for this purpose.
Well, what date can we schedule it, Your Honor?
That's what we're trying to figure out.
I can't just schedule something if I don't have any feedback, Your Honor. That's what I'm trying to say. It's a difficult thing. If I schedule it, I've already scheduled it, it never happened for the 20th. So it left me blank-minded. I had already, of April, 10 days prior before I came to court on the 30th. So, I don't know.
Well, again, Mr. McDonald, I can't help you with this.
I understand that.
You need to coordinate these things with the state attorney. I'm trying to do a little bit of that right now in court to give you the
Well,
opportunity.
I supplied her a blank to fill, to say whatever time that she wanted to
Her
agree
job
for
to
that.
serve your subpoenas. You have to do that with the clerk's office.
Okay, well, I can do that today.
But I was just trying to get the date set.
Well,
Ms. Leone, do you know
when
what
is
dates are
reasonable?
available?
When is a reasonable?
Mr. McDonald?
Yes, sir.
You need to stop interrupting.
Yes, sir.
I'm trying to ask Ms. Leone if she has availability dates.
Okay.
Because I can't just say, you need to be there on this date. I don't get to control people's calendars.
Yes, sir.
Your Honor, if I may, unfortunately, I do have access to my calendar, but my assistant schedules all the depositions. So sometimes she might have blocked some for other attorneys who have requested, so I don't have that answer right now. If he writes a letter, an email to my office, we may coordinate it. It's hard, I know, Your Honor, because he's incarcerated, but also I want to, last week I had to get an investigator to just drop everything he was doing, to take the documents to him because the court ordered me to do that. I just want to make sure
Well,
that
it's because it hadn't been done.
I understand, but it wasn't the state's fault. It's the public defender who didn't give the evidence.
I understand.
What I'm trying to say, Your Honor, is he cannot expect us to just hand deliver stuff to him just because he,
I only asked you to do it the one time.
yes.
Because it had been, in my opinion, a little bit behind so he could get it. So we could have a meaningful discussion today. But I'm assuming your investigator works in the Crestview office?
Yeah. Well, we don't have one yet now, but yeah, he used to.
It's down the street. It's not like it
I
takes 4
understand, Your
hours to
Honor,
do that.
but it's not like he only has Mr. McDonald's case to deal with, and we had trials. He had to chase witnesses for trials. He can communicate with my office, and they'll give him the dates for depositions.
All right, so you're gonna have to coordinate with her.
Okay.
You can do that through the mail, but you
Yes.
should do it proactively and quickly.
Yes, sir.
But because of the mail going back and forth to coordinate this, you're gonna have to make sure you do it in a date that's far enough where you can then serve the subpoenas.
Okay, Your Honor, thank you.
So, I mean, I'm not like a case manager as far as.
I understand that.
All right. Anything else, Mr. McDonald?
No, sir. Thank you.
I'm trying to ask you questions so I can be of little help as I can within the
Yes,
rules.
yes. Hey,
But-
it's-
But you don't seem to want to listen to the answers I'm trying to give you or say how things work because you just want to put your head down and say, oh, well, okay. I'm trying to ask these questions and you don't want to really communicate about it.
I had already set a date for the 20th, and so it didn't get done, so.
But you don't get to just pick the date. You have to coordinate the date.
I understand that, Your Honor.
All right, thank you, Mr. McDonald. Well, your next
Your
court
Honor.
date's going to be June 24th. Anything else?